Good morning,
Are you well
Commissioners.
this morning?
I'm well this morning, thank you.
Good. Are you ready to start?
Yes, CJ?
Okay.
CJ, with your permission.
Sorry?
I'm saying with your permission,
Yes.
I would like to apologize to the CJ and the Honorable Commissioners in that last year I was invited for the interviews. I could not make it for some reasons. It was a conscious decision, I suppose, with the anxiety and level of preparedness at the time. I thought it was prudent for me to withdraw. I sincerely apologize for the inconvenience caused, and I know for a fact that there's a lot that needs to be done in preparation of these particular interviews. So hopefully you'll find it in your heart to forgive me for not appearing in the last interview last year.
You are forgiven.
I beg your pardon?
You are forgiven.
Thank you, CJ.
So you feel ready now?
I'm ready now, CJ.
Well, that's what matters.
Thank you.
Yeah. Okay. You hold 3 law degree, 2 law degrees and LLB from the University of Zululand.
Indeed, CJ.
And an LLM in international business law.
Yes.
From the, is it Freie?
It's Freie University.
Freie University in Netherlands. What is that?
Attention, please. I would like to inform you that.
Where did that come from? Yeah. And an MBA.
Indeed, CJ.
I see this name everywhere all the time, but I can't pronounce it. Is it Regenesis? What's that institution called?
It's Regenesis Business School.
Regenesis, all right.
Indeed.
Okay. Between 1990 and 2000, you worked for the city of Johannesburg, doing, you held a number of roles there. What exactly did you do?
CJ, that was immediately when I finished matric. I think it was 1989. I was still fairly young by then, obviously, with an expectation of myself having to go to tertiary or institution, but then it so happened, obviously, in respect of limited resources from my parents, then I ended up seeking employment so that I could service myself in respect of my education. How it came about that I got to be employed at the Johannesburg City Council, I was studying, doing my initial diploma in municipal administration. And I was doing it with a Technicon SA by then. So seeing that I was deriving a passion and I didn't have much background in respect of local government and municipalities, that's how I sought employment within the city, which was a good thing for me. I started as an administrator in the records office, in particular in the health department, whereby I worked extensively with the health and environmental inspectors. That's what they were called by then, in having to make it a point that the city is being taken care of. So that was a learning curve in having to be exposed, on the basis of a local government. Then from there, I moved in different ranks. From an administrator, I then worked as a junior researcher within a health department in the Department of Epidemiology, whereby I was working with quite a number of medical officers. Remember, by then, the local government had a responsibility in having to promote healthcare services, the clinics, So I was part and parcel of the team that was making sure that there is efficiency in our clinics. And by then, at least the system was still easy because they could measure the members of the society so that they were able to provide better services. And then, interestingly, just to move forward, I then joined in the committee section within the council of the city, whereby I was one of the community officers. And that on its own, as a scriber and being exposed to the local government dynamics and the councils having to debate issues and having to make resolutions and the bylaws and interpretation of the bylaws. So I was exposed to those bigger meetings. And then, but the most fundamental one, that was when I worked in the Human Rights Information Center within the city of Johannesburg. It was fairly unorthodox or unconventional in having a center like that within the local government, because people will ask to say, but when you look at the purpose of the local government, it's just to promote social welfare to the communities or to render services. But then at the time, I think it was around about 1994, 1995, there was a lot of changes, obviously, and the introduction of our constitution, establishment of the constitutional court. So they thought it was prudent for that particular unit to sensitize, conscientize, and teach the members of the communities in that indeed you do have right to services, but also you need to take responsibility in respect of you having to pay for those services. So it was a fairly challenging time because not much of us were exposed to human rights culture, but by virtue of having to go to communities, having to conscientize them, teach them, and allowing quite a number of resources people to give talks. And that to me, that was a journey of inspiration because having to link local government and human rights culture. So that on its own, it created an exposure for me to attend bigger conferences, regional conferences in respect of human rights, which became an enabler that I could actually go in different countries having to make presentation pertaining the changes in human rights culture in our communities. So I delivered papers, one, I suppose, in Zimbabwe. In other instances, I was given an opportunity as well to present papers in Tanzania. And bearing in mind that at the time, it was a regional conference, and you may find that other African countries, they were well advanced on issues of human rights culture. So I had to learn a lot from that time. So basically, CJ, that's exactly what I did in the city of Johannesburg. But then it was not only that, I think later, in 2011 or so, I joined again the city, but I was within the entity being the Johannesburg Roads Agency. And that was good at the time because I was studying, obviously doing my MBA. So those skills were quite positive in having to do my job because I was hired as a legal secretary, a company secretary, and having to sit with the board and a number of committees, being exposed to quite a number of things within the city, and bearing in mind that at the time, cities were never intended to generate revenue, but just to sustain themselves and having to provide services. But now having to work in an entity whereby there's a government element in it, and there's also a business element in it to say, how do we best sustain the infrastructure on our roads by generating a revenue? So that on its own, it gave me a broader perspective in having to work within the local government without losing, actually, CJ, the element of legal orientation and understanding, because I was still heading the legal department within the Johannesburg Roads, whereby you know for a fact in such entities, there's quite a number of litigation in respect of tender processes, procurement. That was a learning curve, having to understand the committees and them having to make decisions. But obviously, my role there, it was important for me to mitigate that there are no risk in us having to have litigation. So that's the experience I have within the local government, CJ. Thank you.
All right. But then when you returned to the city in 2011, you'd left in 2003 to start your own practice as an advocate.
Yes, no, when I
In
left in
2003?
2000, I went to the university to study full time.
Yeah, no. I'm just following the information you provided in your form.
Yes.
And I'm looking at your career now, not the academic route.
Yes,
You say in 2003, between 2003 and 2008, you were at the Johannesburg bar
Yes.
practicing as an advocate.
indeed,
All right.
indeed.
And in 2008, was it 2 years when you were a state advocate?
Yes,
Uh-huh. And you also had a brief spell at the public protector.
indeed,
All right. And then you returned to the city.
indeed.
Okay. Uh, so when did you leave the city? In 2013?
I think it's 2013, CJ,
And you've been practicing since.
ever since.
What kind of a practice do you run?
Yeah, CJ, well, a bit vast.
Just briefly.
Briefly, no, I did mainly criminal. Obviously, those were the opportunities that they were afforded to me, but mainly my practice, it was on criminal law and also a bit of some civil litigation, labor in particular, and family law. So, but in essence, it was mainly the criminal law.
Did the situation change over the years?
It did. It did.
Alright.
As you grow and get to be exposed in other issues, then I tend to do other things.
All right. You've taken. Sorry. You've acted as a judge in the High Court.
Indeed.
When and where?
I started, I think, late 2018. I think it was the last term. And then mainly I was in Johannesburg High Court and Pretoria High Court.
Okay. How long were your acting stints?
Since 2018, obviously in different terms, 2019, 2020, and during COVID, 21, 22. So I've been consistent. And in other most instances, it was full-time acting stints.
Are you able to give us the total number of weeks or terms?
Sajay, I'd actually prepared a spreadsheet for the JP. I don't know if I have it here.
Well, maybe I should leave it to AJP Ledog. He probably has DCJ Mlambo's spreadsheets. Okay.
Thank you.
I imagine that you would have sat in all the courts.
Indeed, Sajay.
Did you do criminal trials, civil trials? Did you sit in the appeal court?
Yes, I sat in full bench and on civil matters, on criminal matters. I presided on special motions. I presided on opposed motions, agent court, and mainly on criminal trials.
All right.
Yes,
And you've written judgments.
I have.
About how many?
I was just calculating, I think about 105.
Any of them
Judgments.
reported?
Well, not that I know of, but I know that some of them, they went to SCA. I think 4 of my judgment were actually confirmed by the SCA. I'm not quite certain. Maybe some other matters are still pending, where perhaps the court could actually overturn my judgment, but I've written extensively.
All right. When was your last acting stint?
I'm currently in
You're acting
criminal
now.
court. Yes.
All right. And you still have not picked up reserve judgments?
Well, for now, I don't have any CJ. Remember, the criminal matters, they take longer.
Or you are in the criminal court?
I'm in the criminal courts.
Okay.
So that's why I started with new matters. The other matters were in the stage whereby counsel had actually submitted their heads of arguments on merits. So I'm just waiting for them to argue so that I could prepare my judgment.
You listed a few parted matters. How are those coming along? Are they in progress?
Much progress, but I can safely tell you, CJ, that the last time there were a number of hurdles in my criminal matters because the state was struggling in respect of securing witnesses to come to court for quite a number of reasons. So that impacted immensely in us having to proceed with the matters. But thus far, there's a huge progress.
All right.
Yes.
AJP, let go.
Thank you, CJ. Good morning, Advocate
Good
Bukako.
morning, JP.
On the question of the,
Oh, I'm sorry, AJP. Before you put your questions to the candidate, I forgot to welcome you and Premier Lesufi to the proceedings. It's never too late to do the right thing. Good morning and welcome, gentlemen. All right. Carry on, AJP.
thank you and good morning to other commissioners that I have not greeted. I've got your spreadsheet here, which shows that you've acted for about 79 weeks. And in terms of this spreadsheet, I see that you are also strong, done a lot of criminal trials, opposed applications,
Yes,
and you've also been in the urgent court.
indeed, JP.
And as you know, that with the opposed courts in the Gauteng division, you get about 10 opposed applications which need to be finalized in 1 week.
Indeed.
And how was the experience dealing with these opposed motions and the urgent court?
Well, I'll start. Thank you for the question, Commissioner. I'll start with the opposed. Obviously, like you've just indicated, that you get a number. Obviously, what assists mainly, you get to be exposed to the files prior 2 weeks or so before dealing with the matters. Then that gives me an idea based on the practice notes of the litigants, safe to say whether do they need a day or 2 days or half a day, then I'm in the position to schedule, just to do a case management process for myself. If I've got about 8 matters, maybe for that particular week, I think obviously I'll indicate with my register so that I can talk to counsel beforehand to say at least let's rather deal with 3 matters, probably on day 1. Obviously, that will be influenced by the time allocated and requested by the parties. They could say 30 minutes, some they could say 2 hours. So I'll manage that process in day 1. And then in day 2, and if there's a need for a break, perhaps to catch up in other matters, I'll spread it on day 4 and day 5. So that enables me at least to have sufficient time to read. Then obviously, if there are opposed motions, because sometimes things happen, they might even settle immediately, which obviously the load gets to be lesser. Or in other issues, they might find that the preliminary issues that needed to be decided there and there, I tend to deal with them immediately and maybe dispose with the matter. But I make it a point that I do cover the time frame in having to deliver my judgment. But I can safely tell you that's a very strenuous process because you need to read extensively and understand the issues as a presiding officer before we are dealing with the matter.
And in addition to the work that you've been doing, you also had to deal with petitions, automatic review, and bail appeals.
Indeed.
And you managed to juggle all those things within the time that you had.
Indeed.
Right.
In particular, the bail appeals. Now, recently, we've been having quite a number of them. And I got a good exposure because I think I must have handled about 3 of them thus far, which it was a good learning curve as well. And the petitions as well, they can be very voluminous, but the good thing is you don't work alone as a judge. There is another judge that works with you. Obviously, you'll have your discussion and then you come to a conclusion. But the sooner you deal with them, the better.
You indicated and apologized for not attending the interview last year,
Indeed.
but you were interviewed in 2023, am I right?
Indeed. Yes.
So you are used to that hot seat.
You don't get used to
Okay.
JP at all.
Yeah. There were also some criticism by the practitioners that when they looked at your judgments, they experienced some grammatical and spelling errors.
Indeed.
Do you need to comment on that?
I can.
Yeah, briefly.
Yes, which JP, I appreciate, the comments because we can only learn by being assessed by others, which to me, it's peer reviewing. So I looked at that, and that was raised in particular in 2023, which I do admit, when I see myself now, even before, there's a huge improvement. I suppose it's based on personal assessment, but I do take into cognizance that these are constructive criticism, and I've worked immensely on them. And I can safely tell you, with my latest written judgments, I proofread so many times to make it a point that I do not want to be found wanting, but there is a progress.
And also this may be caused by the fact that we don't have enough researchers to look at the judgment, assist you here and there. And also with my experience, if you read your judgment twice, thrice, you tend to miss even obvious spelling errors.
Indeed.
So with the benefit of getting more researchers, I think this can improve.
Precisely. I've seen in Joburg now recently, there was the memo that was issued by the DJP in that there's quite a number of intents that are being now placed in having to assist us as judges and them to learn in the process. And that to me, I think is significant, JP.
It is also stated in one of the comments that if your appointment, this would send a negative message to the public. What's your comment on that?
I've seen that one of the bodies, which JP, I applaud them in having to concentrate to detail, because the assessment that they did, it's thorough, which it says to me, Timby, you need to do better. But I do not think, JP, that could be such a detriment in me not to execute my functions. I think I respect the fact that obviously judgment writing is fairly fundamental, because that's the document that needs to speak sense. That's the document that needs to show coherency and clearness, because it's not only the intellectuals of the courts and the judges that read the judgments, but the members of the public as well. They read the judgment. So therefore, there is a duty in me to improve in my writing. But I can safely tell you that beyond that, there's quite a number of things that I'm capable and I'm excelling in doing them. I'm not being defensive in that my writing is bad, but I think there is an area of improvement. And the more I'm given an opportunity, which I appreciate, that to me, it gives me an opportunity to continuously improve in my writing.
There's also a compliment. You are complimented that you conduct your proceedings fairly, efficiently, effectively, and you've got an independent mind.
It's true.
This shows that you are ready for the position and you think you can serve our people when should you be recommended and be appointed.
Definitely, JP. Thank you.
And lastly, there was a question about your health. You know the environment, you've been there.
Yes.
Health-wise, are you saying that you are in a position to can face the challenges of the Gauteng division?
I am. It's fairly exhausting, I must say. So I make it a point that I really take care of myself, because you need a lot of energy and a lot of sanity. It's not only physical, but mental-wise as well. I think it's important to be sane. Thank you.
Thank you, CJ.
Do you have questions for the candidate premier?
Good morning, CJ. Thank you. Morning to all commissioners. Good morning, Advocate Ukako.
Good morning, Premier.
Now, Gauteng is a cosmetic province with all languages found here. I don't think there is any province that have so many languages like
Indeed.
Gauteng. Do you think in the long run, to ensure that the judgments are accessible to all citizens of our province, should we invest in ensuring that some of the judgments are delivered in other languages except English and Afrikaans?
Thank you, Premier, for the question. Definitely. Well, one example, I wouldn't go too far. We know for a fact that our CJ actually coined a judgment in Xhosa, which was commendable. I cannot emphasize much in respect of language, because language, it talks to your heritage, it talks to your identity, you as a person. I'll simply make one example, Premier, without taking much time, in that seeing that I've been exposed in dealing with criminal matters and having to represent the diversity of clients, and mainly, obviously, intellectually, they're not the same. And as counsel, having to understand your client, having to explain the legal issues to your client, it gets very difficult. Because one, you don't just simply go to your client and say, I'm your lawyer, then you start speaking English. You need to understand the person. And by virtue of you being understood is the language. So it's not only on the writing, Premier, but it's about the court itself, that in future, I will advocate in that our courts can actually be conducted in Zulu, in Sotho, in Pedi, in Tsonga, because we do have the interpreters. They play a very key role, but you may find that the interpreter that we have is exposed to the Zulu, Joburg Zulu, and you'll find that the accused person is from KwaZulu-Natal, in the deeper areas, whereby his understanding of the language is much deeper than the interpreter. But because of the services of the court that are there, sometimes you may find wanting. So, for an example, a typical example that I get to be exposed to, Premier, when a counsel will have to explain a Section 220 admission to an accused person. That's a very complex process in having to explain it, because you simply say you are admitting, and the client might think to say, you want me to say I'm guilty, and that's not the area. But if you fail as counsel to comprehend, understand, and talk to your client, it can be very detrimental. So I do advocate our languages. They're fundamental. They're being recognized in the Constitution. They talk to the identity of us as South Africans. So I'll advocate for that, Premier. Thank you.
Thanks for that, advocate. I've seen in courts, you'll have interpreters when somebody speaks a different language, but when the judgment is delivered, the hard copy is only in one language, not even in the language that was interpreted in court. What do you think we'll need to do to ensure that aspect is also strengthened and is adhered to, so that those that appeared before you can also follow a judgment?
What I normally suggest in my court, because sometimes you may find that the judgment that I've written is fairly detailed with legal connotation and so on. I'll prepare a copy for myself, then I'll prepare a copy and give it to my register prior me having to deliver my judgment, in that immediately when I'm done in delivering my judgment, what I'll take the copy from the register and give it to the interpreter so that he can actually interpret and translate. But what I will do, instead of regurgitating everything that has been said, I normally go to the analysis, the evaluation of my judgment, because it's easier written, and then the outcome. But then I always assure counsels to say, I am going to provide you with a copy of my judgment. Should it happen that your client does not follow, I think you have a responsibility in having to explain the reasons of the court.
Thanks so much, CJ.
Thank you, Premier.
Minister?
Thank you very much, CJ. Good morning, CJ and commissioners. Good morning, Advocate Bukako.
Good morning, Commissioner.
Let me start firstly with the observation by GCB, that made an observation which I found it quite interesting in terms of your contribution to constitutional values, around you being able to provide services to members of the society or destitutes at reduced value. I'm asking this in the context of access to justice, because one of the areas where there is a challenge in terms of access to justice is costs. So how are you able to run an effective practice while reducing cost to be able to allow for access to justice to your clients?
Thank you, Commissioner. Um, the CJ posed the question as to the area of my practice, and I indicated that I did criminal law. I have done a number of cases for the Legal Aid Board. And, that's pro bono, even though we were paid. It's fairly minimal, I must say. But because of the passion that I had and having to assist those that I need, I committed myself as a person to deal with that. But in private practice, whereby there's an attorney, obviously, they have their own prescribed fees and having to brief counsel, I'll provide my fees and the attorney. So the level of negotiation in terms of costs, I don't get to participate much. I suppose it's the attorney that gets to be involved in that. But significantly, I've done number of cases assisting the needy. Thank you, Commissioner.
No, thank you very much indeed. The work that is done by Legal Aid South Africa is quite critical.
Indeed.
And they're quite constrained because of the fiscal environment.
Yes.
In one of your cases, namely State versus Dube J and others, 10 others, you made a point around that in the course of your case, you learned that Prevention of Organized Crime Act it's a complicated law. And part of that demonstrating that criminal intent necessary for poker convictions can particularly be in trick. Do you mind sharing with us, can you share with the Commission your observations and what you think should be done?
Thank you. Commissioner, that one deals mainly with poker, which is a legislation that is still fairly teething in our courts. And it's a legislation that is very complex, which covers mainly the issues of money laundering. And the critical aspect is the benefit of it. Because in other instances, for a matter that I did, the one that I'm making reference to, a number of accused persons that were present in that matter, it's accused that actually benefited without really being conscious that they're participating in money laundering. Some innocently, for an example, a mother, a sister, or a neighbor, or a girlfriend could be getting money from a boyfriend without having to ask, what is your source? So that to me, it taught me a lesson that we ought to be a conscious society in that if people get monies in their account, not knowing where does this money come from, I think we have a duty to question the source. Without questioning, you'll find yourself wanting to be a beneficiary in money laundering. So that's a complexity of it, that there is a thin line. Whether you're aware or you're not aware, you are bound to be guilty of the whole value chain as to how you receive the money.
Point, Sitja, on the matter. Is it the matter of a law being poker law being complicated, or is it a matter of advocacy that the public doesn't know? Because that's what I'm trying to understand. It's one thing, because I wanted to understand from what you're saying that it's a
Yes.
complicated law.
Yes.
So it's not about the act itself being complicated. And I'm interested, as you know, that I would be responsible for that amendment of the act or not amendment of the act. Now, seeing this was quite intriguing for me. In my responsibility to say, okay, is it difficult to prosecute? Is it difficult to prove a case? Is it difficult to be able to successfully have these matters, as you say, money laundering and all those issues that we could be able to prevent organized crime in the country, especially in the current context. So from your answer, I'm a bit confused whether is it the issue of the law or is it the issue of awareness by the public?
I think the major one is the awareness to the public. Also, in respect of the law itself, when it comes to prosecution, in respect of the matter that I'm making reference to, Commissioner, it would have been complex if the investigating officer in this particular matter was just a warrant officer or a constable without accounting and financial management understanding. That could be complex in that particular area. But if it's handled by people who are knowledgeable of financial management, FICA, and the rest, then it's easier to do that, because I think that's what we were exposed to. The person who was the key witness was a person that works, for an example, for SARS, fairly knowledgeable in terms of trails, fairly knowledgeable in terms of having to link the pieces, who got what, when, and money transferred to where and where. So I think our police, there's still a need for them to be trained immensely in having to cover that particular aspect. That's another aspect in terms of complexity. But in terms of advocacy to the community, it's very important. I cannot emphasize it much that the media ought to play the role, and the legal bodies will have to continue to educate people and councils as well, and attorneys in respect of these issues, because you may find the attorneys, they do have trust funds, commissioner, and they invest monies for clients. So sometimes they might not even know the source of that particular investment. Thank you, Commissioner.
Thank you, CJ.
Commissioner Trolley?
Thank you, Chief Justice. Just to follow up, Advocate Bokako, I'm concerned at your answer to the Minister, because I can accept that the public might not be aware of the provisions of POCA. And I accept that some people might not be aware that it's important to understand where money appearing in your account comes from. But in this document that you provided, you said, I learned that receiving funds in an account without knowledge of its source is important. And I came to understand it may raise concern regarding money laundering. Now, as a judicial officer, I would have thought that you wouldn't have to learn that through a case, that you would know that receiving money in your account without knowledge of its source is a problem. So could you please explain to us why you only learnt these things and came to understand them during the case, and why you didn't have the judicial knowledge or grasp of how important it is to know the source of funding that arrives in your bank account?
Thank you, Commissioner Trollip. I think the matter that we're making reference to, I was the counsel in the matter. I wasn't a judicial officer in the matter. And it was for the first time, it was in 2018 when we started with the matter, for me to be exposed to the aspect of POCA. Thank you. Prof?
Thank you, CJ. Good morning, Advocate.
Good morning, Commissioner.
I want to ask you a question, and it's based on some of the judgments that I've seen that you have authored.
Yes.
Without really dealing with them, just certain aspects that come from them. I mean, when one looks at it, mandatory minimum sentences were introduced in this country as a temporary emergency crime control measure, where there were those that believe that it will lead to harsh punishment being meted out to reduce crime. But it appears as if the legislation that was introduced did not live up to this kind of objective, or what generally people thought it will lead to. And we see more and more people participating in heinous crimes, serious crimes in South Africa. I just want to know, in your view, do you think that the Criminal Law Amendment Act has been effective in fighting crime, especially serious crimes in South Africa, and have assisted the courts in trying to curb this, what I call a pandemic in this country?
Thank you, Commissioner. If I may try. Indeed, Commissioner, these mandatory minimum sentences, you find them mainly on Section 51(1) of 1977 Criminal Amendment Act, specifically on the aspect of murder, for an example. And you'll find mainly on the aspects of the armed robbery, possession of firearm, and the rest. Now, in answering your question to say, this particular proposal in having to have minimum sentences, is it beneficial or effective? Remember how it came about. It derives back from S versus Makwanyane's case at the time, and the harshness of sentences, in that previously, when the courts were making determination in respect of sentences, they were not focusing on substantial and compelling circumstances of an individual. One, it's important for me to articulate that if a court will have to impose a sentence, you don't only look at an individual per se, the criminal. You look at the crime itself, you look at the interest of the society, and you need to understand what becomes the purpose of punishment. Punishment is not just to take people forever into jail, but we talk about issues of deterrence, issues of rehabilitation, and that you'll find in one particular case law, which a tried fact of Zin, to say you look at that. I do agree with you, Commissioner, in that even if people can be taken to jail for quite some time, because the standard minimum sentence for murder, if it's done with pre-planning, it's a clear case that it is life. And obviously people will have to be in custody for about 25 years. You'll be surprised that some of them, they'll still come back and commit crime. And that, I think there is an aspect that they called recidivism. And what influences them in having to do that is their social circumstances and the environment that they find themselves in. So it's not only the courts, Commissioner, or the criminal justice system that has a role to play in combating crime in our courts. The courts simply interpret what has been legislated. I cannot safely say there could be any other harsher punishment, for an example, for a person that has committed murder. Life is still significant, but then we need, as a community, to understand that you do wrong, then you go to court. But it's not, if I answer you correctly, Commissioner, that it's not only the role of the courts in having to make it a point that crime is being kept. So I do not see any need currently in improving the current criminal justice system that we have in place.
It seems to me that your answer has in it the concept of restorative justice.
Indeed.
The exact meaning, place, and role of which in criminal matters remains unclear, particularly in serious crimes. So my question then would be, does restorative justice have a place in the prosecution and conviction of serious offenses in South Africa? And I'm asking that question based on the answer that you gave me.
If I understand you very well, when one talks about the word restorative, obviously is to maintain the status quo, equilibrium, that there should be balance. My understanding, Commission, restorative justice, I think it gives a sense of responsibility and accountability. In that, if we have done wrong as an individual, you don't only be taken to jail, you need to come back to the community and restore the disturbance that you caused in the community. That is why I'm one of the people that subscribe to the parole processes that are taking place, in that individuals ought to be given a second chance to come and restore the wrong. Because by just simply taking them to prisons without them having to add value in our society, I think it's meaningless. I hope it answers you, but that's my understanding in terms of restorative justice.
No, it's fine. I will leave it there. We don't have enough time. Thank you very much, TJ.
Thank you.
Commissioner Gotze?
Thank you, CJ, and good morning to you, Advocate Bukako.
Good morning, Commissioner.
Perhaps just then on the back of the Professor's question, I see that you have done, as part of your community work, some work at the Maranatha Prison Ministry.
Yes.
What was your role there?
My role, it was fairly interesting initiative. It was a group of women, in particular from Soweto, from different churches, fraternal, whereby we'll go either on Saturday or on Sundays, even obviously just to educate the young women in particular. That was my area of focus. But then at some stage, then I made certain limitation in having to go to the correctional services because I might be found in conflict because most of my clients are there. But the other angle of the Maranatha, it was about the restoration that I was trying to articulate to the professor, in that there were a number of young women that have been incarcerated. And when coming back, we knew for a fact that they have criminal records, and which was an impediment in them having to get employment. So as a group of women in Soweto, we'll give them support, just to provide the basic necessities, establishing themselves into coming back to the communities. Because it is a known fact, Commissioner, that if one has been in prison for quite some time, there is a societal perception about the person. Either the family members that don't get to appreciate and to understand you, the community that don't understand you. So we were playing the role in having to bring them back into the communities and make them to participate in young people's initiative, community initiative, so that they find themselves. And because I'm not going to lie, some of these women that we're helping, some of them went back to jail, because there were no means, they were not employed. So that's what I was doing with the Maranatha ministry.
Okay, because I was going to ask you, I mean, you spoke earlier about the recidivism rate, which is, I think, a big problem in South Africa. My view has always been, and particularly having been to several correctional facilities, that in fact the surrounds and the areas the spaces in which the rehabilitation is meant to take place is actually not conducive to rehabilitation. And I was wondering if you would agree with me that in fact that would contribute to the high recidivism rate.
Yes, you mean rehabilitation inside the
Yes.
correctional services or outside?
No, inside.
Inside. Look, I respect the processes within the DCS. When I'm exposed in dealing with the parole application, for an example, there's a number of trainings that are taking place. Conflict management, anger management, skills. Some of them, they do commit themselves in having to do that. And that becomes an enabler in them having to say, when going out, I'm going to do positively. But then, in respect of resources being constrained, you may find that the DCS can actually consider in having to enhance other programs that are relevant outside, because sometimes you may find that are just personal skills which are not going to be positively contributing, one having to skill to say, I'm going to start to work. Because if they have a criminal record, Commissioner, it's very difficult for them to do anything, which is something that in future I will advocate to the minister, in that let's give our citizen a second chance, because the circumstances that we live in, I mean, you may find the areas where there's a lot of crime, the environment, it's not that conducive for people to get employed, and there's quite a number of external factors that makes them to commit crime. Not that I condone that, but I think people ought to be given a second chance, because if we are saying we are trusting the systems and the programs from the correctional services in having to skill them, whilst on the other hand, the very same DCS will not take them, for an example, to be their workers, then it becomes a futile exercise. Why then continue to train them? Because you need to trust on your systems, you need to trust in what you're giving to them. So let's give them a second chance to be the better members of the community.
Thank you. And then just, you've spoken about systems.
It's two questions, Commissioner Gotze.
Okay.
Still have a long list. Commissioner Lezi.
Thank you, CJ, and good morning, Advocate Bukako.
Good morning, Commissioner.
Just one, is there any reason or that why you haven't taken senior counsel status given your extensive experience in the field of law as an advocate?
It never crossed my mind, Commissioner. There isn't any specific reason.
Yes, okay. And then the second one is, previously in 2023, there were some criticisms and also there were some undertakings and to improve. The current criticisms raised by the GCB, are they the same or related to the previous ones? Just to ensure that to check whether there has been some movement since the last time.
To be honest, you're quite correct, Commissioner. To be honest, it was mainly on grammar, mainly on the typing errors, not concentrating much into details. Obviously, they were basing their reasoning in my previous judgment, which I've taken cognizance into that, even though now they've raised the recent cases, which I think they are 2023. So I've perused on that, and in my assessment, I see there is an improvement. So it's genuine concerns. I can't take it any further, Commissioner.
Thank you, thank you.
Thank you.
May I follow up on that, Chief Justice? I just want to give you a proper chance to respond, because the GCB is referring to 2024 judgments in some cases, and it's not grammatical errors. They are referring to your reasoning and absence thereof. In the Kanu versus, no, that's the wrong one. In Royal Square Investors, which is a summary judgment case.
Yes.
The comment is that you actually misunderstood Rule 32.
Yes.
And the requirement that a plaintiff must file a summary judgment within 15 days of receiving plea. You said this is to ensure that the defendant gets Audi, but that's not the reason for confining it to 15 days. Can you perhaps tell us what the reason is?
Commissioner, without taking far, I've seen that. I've gone through the judgment and I saw the shortcoming. So I do not have any other explanation as to how I would have cured it, but I've learned in the process to say it was an oversight from my side.
But have you then learnt why there's a 15-day limit given to the plaintiff?
Yes, those are court rules, Commissioner, the prescribed court rules.
Yes, but what is the reason for it? There are many judgments talking about the reason for the 15 days, and it's not for the sake of arguing.
Commissioner, I do not have a clear answer to that one particular aspect. I'll have a look at it.
Because I would suggest that learning from it would be then finding out if it's not RD, then, what is the reason?
I'll do that, Commissioner.
And then, likewise, there's another 2024 judgment, Mayor versus Mayor.
Yes.
Where they point out that you granted leave for appeal, but you didn't give any substantive reason. You merely said another court can come to another conclusion. And again, that was last year. Do you not think a court granting leave to appeal must say why on the facts another court could come to another conclusion?
You are quite correct. It's important, and given the threshold of an appeal, it's important for the judiciary to give reasons. Yes. Well, I suppose I might have consumed the submissions as they were made by the parties. Then I concluded that it will be amenable for me to grant the leave of appeal. But I do take your point, Commissioner. It's important in me having to do that. But I think in my other latest judgment from 2024, till date, I've given extensive reasons in respect of leave, why grant a leave of appeal.
Thank you.
Thank you, Commissioner.
Chief Justice, my questions are related to the same matter, if I'll be allowed.
Jump in now.
Thank you. Advocate Bokako, Commissioner Hassan here.
Good morning.
These are in follow-up to the questions that have been put forward. And I think you've acknowledged that there were some challenges in the past, but I'm interested in the precise mentorship arrangement, because that's what you said to this particular body in the past, that you would seek senior judge support. So if you could please set out the precise mentorship arrangements you've implemented, and you've just mentioned now, you've said there are judgments that show the progress. If you can specifically mention those judgments and highlight, I'm asking you to illustrate that progress that you've hopefully made.
In answering the first question, Commissioner, pertaining the mentorship, I do recall that immediately after the previous interviews, I sought counsel from the then JP to say, this is an assessment and analysis. I need an advice or counsel in moving forward. What I really appreciate, it's an open door policy within our division that I have access to all the judges, and that culture is being encouraged. So subsequently, there were 2 senior judges that they were allocated to me. For an example, should I have an issue in terms of legal analysis or understanding any principle, I will knock at their door, send them an email, write a memorandum for them. They'll greatly assist. And then in respect of judgment writing as well, which was more critical, I'll make it a point that my first draft, I take it to them, we'll have a meeting, we'll say, okay, Tembi, I do understand what you're trying to say, but let's look at this, look at that, look at that. And that, it has been very beneficial to me in having to improve. Because I take the point, it was raised by the previous commissioner, that at some stage I struggled with the reasoning. I think I did not trust myself in having to apply my reasoning. I thought maybe let me focus mainly on precedents, but that on its own, it gave me courage to say, I can reason and I can apply my mind. So that has been excellent in respect of mentorship. I think the second aspect, Commissioner,
Yeah, it was related to that first question. I wanted you to mention some case examples from your most recent acting stint that show this progress.
Commissioner, I can make reference to the cases that I've submitted for this particular application, though they're mainly for criminal matters. But if you can compare what I've written and previously, it's totally different. These ones, they speak for themselves. I think I must have submitted about 3 of them.
Okay, and then my last question would be that the GCB is saying that your permanent appointment would send a negative message about the quality of judicial appointments. What objective indicators can you place before us to help restore that public confidence?
I think the JP asked that question. It's just the level of me being open-minded and being...
Sorry to interrupt you, Advocate. I'm asking you about objective factors, right? So someone who's sitting at home who will have heard that the GCB doesn't believe that your appointment would send a good message, what would you say to them?
That I'm confident that I can do better and I'm capable of doing better. And then I cannot only be judged on that one particular aspect in me having to fulfill my duties as a judicial officer. So I strongly believe, Commissioner, to say I need the community and the public in particular to trust that I'm capable of doing more, and I will be exposed to a lot of training, which I am amenable to that. And I've seen that there is an ongoing training within our division, which it's fairly impeccable. So I'll appeal to the public to say they can put their trust in me.
Thank you, CJ.
Commissioner Matolo Dlebo?
Thank you, CJ. Good morning, Advocate Bukako.
Good morning, Commissioner.
I think I asked the same question the last time we were here. You have a lot of experience in the local government procurement, and from what you're saying, you have never gotten exposure in practice. I just wanted to know from the last time you were here up to now, do you still not get that type of work?
Fairly minimal. Not as much though, because I think, Commissioner, I've been concentrating mainly with the acting stints. So I haven't had, not that I haven't received briefs. Obviously, when I'm not available, I couldn't take any briefs, but fairly minimal.
The second one is the issue of your judgment writing.
Yes.
Have you attended the Bridget Mabanda course, or what else can you do?
The training?
Yeah.
I did. I've attended the training. I think about 2 years ago, if I'm not mistaken. I did.
Thank you.
Thank you.
Commissioner Mangen?
Thank you, Chief Justice. Good morning.
Good
Advocate
morning.
Bukako. You sat as a co-judge with Johnson AJ in the matter of ex parte Galela. It was an admission application.
Yes.
The candidates were owing fees to the university. And there was an issue of non-compliance with the rules of the LPC. But the LPC was not objecting to the admission. You remember that?
I do.
Yeah. When one reads that judgment, one gets a sense that you, as a person who was sitting with Johnson AJ, did not appreciate the level of poverty and unemployment in our country and the attempts that are being made to break the cycles of family in families. Why did you find it necessary to refuse to dismiss an application for admission for non-compliance with the rules when the LPC, as the custodian of the policies regulating admission of practitioners, did not object?
Thank you, Commissioner. I remember that matter. I think I was in Pretoria. It was a fairly awkward moment in dealing with that particular aspect. But bearing in mind that as a presiding officer, you don't only get to be driven by emotion or your social perspective in life. It's the prescripts of the law and what the law says. I take your point in that the LPC actually wrote in that they do not see anything impediment for her to be admitted. But obviously, the court is not only governed by what is echoed by the LPC. We respect the structure as a regulatory body because they look at quite a number of technicalities. But there are certain prescripts, guiding prescripts in respect of the admission. So what happened in that matter, it was not only the question of her not having money to pay her fees, because I think the matter was she did not have the certificate, even though she had the results that indicate that she has finalized her LLB, but she did not have a document, which is one of the requirements in your attachment. That was not the only aspect, but there was another aspect of non-disclosure in respect of a business, if I'm not mistaken, that she was running, and in respect of the attorney's rules for one to be a candidate. You are not supposed to have any pecuniary interest, or you're not supposed to run any business, or you're not supposed to be exposed in anything that provides an income. So it wasn't just that particular aspect. But in understanding you, I totally agree with you that obviously we still need to be conscious as the presiding officer, because this particular aspect, I remember I made the research, even though I was not the scribe, but we had an extensive engagement. There is one popular decision, I think it was made by one Honorable Judge Victor. I think she was sitting in NCA or went to the SCA. There were conflicting decisions in respect of this particular aspect that you are raising. Then we tend to follow for the other one in that non-disclosure impacted in her not to be admitted. But I know subsequently our reasoning, a judgment was overturned by the SCA or the higher court.
Advocate Bukago, you are wrong. I was sitting with Judge Victor in that judgment of ex parte Judicial.
Okay.
You made reference to that judgment. You also made reference to the judgment of ex parte Makamu coming from Mpumalanga.
Yes.
You misinterpreted both judgments, ex parte Judicial and ex parte Makamu, both of which were saying that candidates cannot be, a court cannot refuse candidates an admission on the basis of outstanding fees. So it talks to the GCB's concerns about, one, your reasoning, two, your inability to formulate appropriate orders. Because if there is non-compliance with an LPC rules, you don't dismiss. You strike the matter of the roll to allow the candidate to comply. Because if you dismiss, you are saying that this candidate should actually never come back unless he or she appeals the judgment.
I take your point, Commissioner. I wouldn't take any further, but I totally agree with you.
Thank you, Chief Justice.
Anyone else, colleagues? All right. Commissioner Shivan?
Thank you. Advocate, in the GCB, they mentioned case of BL versus AL, and they say you did not take cognizance of the fact that Rule 43 had been amended. Could you give us some background on how did that occur?
If I may be permitted to go through.
It's mentioned in 14.1. If you don't recall, I accept that you won't recall, but that's one of the criticisms they say.
Yes.
And then you also mentioned earlier that POCA was a complicated legislation, and you said you only dealt with it in 2018.
Yes.
POCA was promulgated in 2004, so that's similar to the criticism leveled against you by the GCB, that you didn't correctly interpret, you didn't take note of the amendment of the Rule 43.
Yes.
So that means it implies you're not keeping track of the latest changes that are going on in the law, because if you take the POCA example, you said you only dealt with the case in 2018.
Yes.
POCA was promulgated in 2004. That's like 14 years after you dealt with it.
Correct. But then, Commissioner, I don't know whether you're finished.
Yes, I'm
If
finished.
I may
Thank
respond.
You.
Yes, isn't it perhaps as counsel, you get to be exposed to a certain law or a prescript when you are dealing with that particular matter. So like I said, it was for the first time in 2018 that I got to be exposed to deal with matters of this nature. But I do understand that the promulgation was way over 2004. I take that into cognizance.
Thank you.
Thank you.
Thank you, Chief Justice.
President Mulemel?
Yes, thank you very much. Good morning, Advocate Bukaku.
Good morning.
How are you?
Fine, thanks, and you?
I'm fine, thank you very much. I serve on the Council of SAJE and of SAJE, South African Judicial Education Institute.
Yes.
So I'm just curious to find out whether you have any proposals regarding any additional training courses that you think should be, the acting judges should be assisted with.
Oh, definitely.
Yes.
Thank you. Definitely, Commissioner, there's always a need for improvement. You never get to know much. For an example, like I said, in our division in Joburg, every Thursday, there's training and in different various aspects of the law. And you wanted to say, oh, I thought I knew this, I don't know. So I would greatly appreciate that. And in particular, seeing that I'm one of the mentees in having to mentor young women, I think there should be some kind of a program to say what is necessary, what is important for them, because those fourth year students, obviously, that are preparing themselves in to come to the system. So I suppose that there is a greater need in us as mentors as well, and them to be trained to say, how do we impart knowledge to other people? So I do support the view that we can expand training programs.
Thank you, Advocate Bukako. Thank you, CJ.
Thank you, President. We've reached the end of your interview, Advocate Bukapa.
Thank
You're
you.
excused.
Thank you, Sajay. Thank you, commissioners, for the time. Much appreciated.
Advocate Letwaba. How are you? I'm fine, thank you. Sorry to keep you waiting, having a disorganized morning. You were here not so long ago, late last year,
I was here this time
applying
last
for
year.
a position in Limpopo then.
Yes, I was here last year.
Okay, so we should not be all that long with you today. We do have the background intel on you already. Your application form does not state your place of birth and date of birth and refers to some annexure in your bundle. Why must we troll through this thick sheaf of papers to find out information? When were you born and where were you born?
I was born in Limpopo.
When?
When?
Yes, you are supposed to give us your date of birth. The questionnaire requires it.
Yeah, there was an extra A that I completed.
I can't find the Annex A. You're supposed to state it where the form asks, and you have not done that. That's why I was asking, why must you troll through these documents to find something you could easily state where the form requires you to state it?
Yeah, but the bundle that I have, I've got it, but I can tell where I was born
All right.
in Limpopo.
But what is your date of birth?
61 January, 1961 January.
Sorry?
1961 January, January the 1st.
1 January 1961?
Yes.
Okay, thank you. You hold 4 law degrees, a BProc, LLB, and 2 master's degrees.
Yes, yes, Chief Justice, yes.
From Limpopo, University of Pretoria, and UNISA, respectively.
That's correct, Chief Justice.
You came through the ranks of civil service. You taught for a brief spell at the beginning of your career, and then joined the Department of Justice as an administrative clerk in both civil and criminal courts.
That's where I started, Chief Justice, yes.
That was 4 years.
4 years, yes.
And then you did articles and went to work for the Lawyers for Human Rights as a legal officer.
Yes.
For another 2 years.
Yes, 1991 to 93, yes. 2 years, yes.
And then in 1994, you started your own practice as an attorney.
1994, yes.
In partnership with someone else.
Yes.
And in 2008 until now, you've been a member of the Pretoria Society of Advocates and the Limpopo Society of Advocates.
Yeah, Pretoria, up to last year, October. That's when I resigned from that membership.
Just pull your mic closer to you, please, so that we can hear you clearly.
Yes, I've been with Pretoria Society from 2008 to last year, October, when I resigned from the membership.
All right. And during this period as an advocate, you've also been a part-time commissioner.
Yes.
With the CCMA.
I've been a CCMA, yes.
Okay. You've acted for a really long time. There's mention of 112 weeks somewhere in your papers.
Yes.
Has it been that long?
Yes, 112 weeks, 80 something in Limpopo and 23 in Gauteng.
I'm sorry, I'm still struggling to hear you.
Yes, I've acted in Limpopo and Gauteng, 23 weeks in Gauteng, and then the rest in Limpopo, so 112, all of them.
All right.
Yeah.
And you've, as you told us last time, you've sat in all the courts in the High Court.
Yes,
and you've written judgments on the widest range of legal subjects.
Yes, yes, Chief Justice. Yes.
On your last visit here, you had not, you didn't have a reported judgment. Has that situation changed since?
No, I don't have a reported judgment, no.
Have you written any more judgments?
Yes, since I came here, yes, I've written more judgments, yes.
How many?
I think there must have been, it's more than 5, I think, since I came here. Yeah.
When was your last acting appointment?
The last session, I think the end of September.
This past September.
This past September, yes, I was in Gauteng.
Okay. I should probably leave this to the objections committee. Okay, I'll stop here for now and hand over to AJP Ledwaba. Are you related by any chance?
Yes, well, we share the same name, but we started knowing each other in Pretoria when we are attorneys together.
You are not related?
No, we're not related, but
okay, thank you. AJP?
Lugupina.
Yes.
I'm greeting him in Ndebele from Limpopo, even though he's not written, but he's still there, and we are proud of the language. Advocate Ledwaba, can you, I see here you acted in Pretoria, you say 23, but according to the spreadsheet I've got, it reflects 27. Are there instances where you acted on pro bono basis in Gauteng?
I can't recall in Gauteng, I recall in Limpopo, but I can't recall if I did pro bono in Gauteng.
But when you are in Gauteng, you've been exposed, you were also in the urgent court. And,
yes.
Have you done matters or also in the opposed motion court?
I did both opposed and unopposed motions.
In Limpopo, did you deal with criminal trials?
I did criminal trials in Limpopo, yes.
Okay. I see from the GCB, you've been complimented for being punctual and that you conduct the proceedings fairly effectively and efficiently.
Yes, I've seen that. I've seen that, AJ.
And what contribution do you think you can make in the judiciary if you are appointed?
Well, I'll come with a whole of experience, starting from when I was still the clerk and an attorney and advocate. I think I've accumulated enough experience to contribute to the judiciary.
You indicated that you acted for about 112 weeks in Limpopo and about 23 weeks in Gauteng.
Yes, yes. All 112, 23 in Gauteng and the rest in Limpopo.
And comparing the two divisions, if you are given a choice, why do you choose to be in Gauteng now? Well, to apply for a position in Gauteng?
Gauteng is more competitive compared to Limpopo. We do more than that when we do in Limpopo.
Right. There was a complaint by Amalgamated Lawyers Association, and you've given a comprehensive response to that. Briefly, can you tell the commissioners what is your view or your further contribution in respect of that complaint?
Well, that complaint was a complaint born out of what happened in court on that day when Mr. Maluleka wanted to appear before me while he knew that he was struck from the roll. So our difference started there. I called him and the fellow advocate to the chambers, thinking that we could resolve it. But in chambers, then it went worse. So, and from there, then he told me that he was going to object to my appointment. So I'm not surprised what he's doing to me now.
Are you done?
Yeah. Yes, I'm done. But I've written everything what happened there. And I responded to what he's saying, that I'm not fit and proper. I don't think he's given any reason, because he talks about some people having observed me in court, and he doesn't say who's that person. But the only evidence that I'm asking the commissioner to judge on is what happened on that day, and also what the bodies are saying. So I think
I don't agree with what he's saying to me, that it's saying about me.
Having experienced the workload and the pressures in the Gauteng division, health-wise, are you saying that you'd be able to cope with the pressures in the division?
Yes, I think I will do that. I've been in Gauteng, I think from 1991, that's when I started there. So I even practiced in Gauteng, so I know the pressure. I know what it takes to be in Gauteng, so I think I'll manage.
Premier.
Thanks, CJ. I don't have a question for this candidate, CJ. Thank you.
Thank you. Prof, followed by Commissioner Nukaito.
Thank you very much, CJ. Good morning, Advocate Ledwab.
Good morning, Professor.
There is a case that I want us to deal with, where you deal correctly with the principle. But nonetheless, I just want to pick your brain on how that principle should be understood. I think it is on page 76, hand paginated 76 of your bundle.
76.
Yes, it is the Nyakani case that dealt with forfeiture of patrimonial benefits.
This one.
I wouldn't know which one it is. Let me just check.
Okay.
Yes,
Yes,
paragraph 23 of that particular judgment, where you correctly state that fairness is not part of the inquiry when one is dealing with forfeiture of patrimonial benefits in terms of Section 9 of the Divorce Act. Yes. There is a case that was delivered by the Deputy Judge President of Gauteng, Sutherland, in 2014, where he questioned this notion that fairness is not part of the inquiry in Section 9. In fact, when one reads his judgment, paragraph 25, he appears to be saying that the role of the absence of fairness is overstated in the inquiry. The question I want to pose to you, based on what you wrote there, and I believe that you are right, do you think that having regard to the lack of development in the jurisprudence relating to forfeiture of patrimonial benefits, and particularly having regard to the fact that there are no statutory and judicial guidelines on how to determine the concept of undue benefit and the concept of substantial misconduct itself, is there substance in the thinking that for some reason fairness can actually play a role in this when applying this remedy?
Well, the case that I quoted here expressly says that fairness is not the criteria to determine forfeiture, because we define what is substantial misconduct as defined in the Act. So there's no way where the Act itself talks about fairness. I think to say that fairness plays a part will be something's contrary to the Act itself. There's no way the Act talks about fairness.
Yes, I accept that point. And I think Sunderland also accepts that point.
Yes.
And I'm not saying he's right and you are wrong.
Yes.
In fact, I'm with you that you are right. But I want to understand, because there is some value in what he's saying. So the question that I'm asking you is, because for you to get to those three requirements, factors for you to be able to make a forfeiture order, ultimately you want to demonstrate that there is undue benefit to the spouse that you want to grant the remedy against. So what I'm saying is, in that assessment, given the fact that there is no judicial and statutory guidance as to what amounts to, unduly benefited, and the concept of substantial misconduct itself, is there no merit in the assertion that to some extent fairness can actually play a role in the assessment? That's where the question lies.
Well, I don't think fairness will be used for the purpose of the forfeiture of the benefits. The fairness can be looked at from when you're talking about the conduct of the parties. But to say that he has been unfair to another party to an extent of saying that for that factor, a party must lose the benefit of the marriage and community property. I think I will say that maybe we should look at each case according to the facts. There can be a situation where maybe fairness can play a part. I think I haven't read that judgment of Fatherland, but I think each case may be looked at its merits.
No, but your answer was correct. There's no fairness in the process. We can leave it there. So I wanted to just to test your brain in relation to that. Thank you very much, CJ.
Thank you.
Commissioner Ngwaito?
Thank you, Chief Justice. Advocate Dwaba, there are two issues I want to deal with. Number one, the AFT says that the fee dispute where you were accused of overcharging has been resolved and you've received a letter of good standing. Is that correct?
Sorry, I didn't follow.
The Advocates for Transformation, in their appraisal of your application, have told us that the fee dispute that was raised with this commission before has been resolved. You've received a letter of good standing. Is that correct?
That's correct.
How was it resolved?
Well, first of all, what we were differing about the figure, we reached a figure. We agreed on a figure. After the investigating committee...
Sorry, just give me some facts. The charge was that you had overcharged. So how did you resolve that problem?
All right, maybe let me give you the background. The background was this. After I'd submitted a statement, and we agreed on two figures to say this and this should not be there, and then we deducted them. Let me just give the background. And then once we done that, they said...
So what does that mean? I don't understand. You submit an invoice. There is a complaint that you have excessively charged. Do you then remove items from the invoice?
Yeah. What had happened is there was a day when they said to me there was a COVID day and we're not supposed to appear.
Yes, I understand, but I just want to understand the principle. You removed items from your invoice, yes or no?
Yes, we removed items from the invoice.
You removed items from your invoice?
Yes.
How did those items get there in the first place?
How did they?
Get into the invoice in the first place?
Well, there was a dispute whether that day we set or not set on that day. Because on that day, there was a COVID day. There was during COVID. And the manager said, on that date we said, but the register said we did not, the register said we said on that date, but the manager said we did not sit. Now, when there was a dispute, I said, okay, if that is dispute, let's remove this item. Because on my notes, it shows that we attended on that day. But there was a difference between the registrar then and the manager. The manager said, his note says we did not sit. But the registrar said we sat. But I said, in order to avoid that situation, let's remove that dispute. Let's remove that figure. Then we remove that figure. Another figure, when I was calculating, as I entered the figures, as I entered the notes, there was a line where there were two figures in the same line. And when we discussed this thing, I discovered that I'm the one who, because of the movement of figures, two figures remain on the same line. So I said, this one should be out, because that was my mistake. Those were two figures that were there. So those two figures were removed. Yes. But what happened after those figures were removed, they said to me, then give us a new invoice. And I gave them a new invoice. When I gave them the new invoice, the figure that we had then exceeded the figures on the invoice. And then we sat again to say, let's rectify that. And then the manager and myself, we sat again. His figure again became more than the figures that we said. And then instead of resolving that, the register reported to the committee. And then the committee, investigating committee, said to us, we differ on the figures. Can you resolve these figures? And we said, yes, we can resolve them. And when we went back, then they went back to the original statement where we only agreed to remove those figures that we differ. And then, so the only difference was that because they said I must generate another invoice, I found that the invoice now became more. And with the manager as well, even the figures became even more. So we went back to the original figures, to the original statement, and we just took those two figures. And then we agreed.
Now, just to sum up,
Yeah.
the way this was solved is that there were items on your invoice that you removed. One of the items you admit was incorrectly there. The other item you disputed it was incorrectly there.
So two figures that were
Yes.
there. The figures that I made my mistake, and the figure that register and the manager differed as to whether we said on that day.
Yes.
But I said, in order for us to move this matter, let's remove both these figures, and then remove those figures.
Yes. Now, there is a second issue, not raised by the Advocates for Transformation, but raised by Amalgamated Lawyers Association.
Yes.
The allegation is that you misled although you were presiding in the court, you misled the lawyers by falsely claiming that Judge Patudi said he was conflicted in the Esther Maluleke case
Yes.
on the 26th of March 2024.
Yes.
Judge Patudi sat in the matter on the 16th and specifically said that it was a lie that he was conflicted. In fact, you never even spoke to him on that day.
Yes.
Now, I have a problem that
All right.
a senior judge like Patudi J can say that you've lied about what he said.
All right. There's always two distinctions, two dates. There's a date, the first date is the 19th of March, when he gave me that file. He said to me, I'm giving this file because himself and Chidata are conflicted. We said there.
Yes, but just hold there. So he told you that him and Judge Chidata were conflicted.
He told me himself and Chidata were conflicted. And that's the reason, because we were three. The only reason that he gave me this file because he said to me, himself and Chidata were conflicted.
Yes, but the quotation here from Judge Patudi, AML Patudi,
Yes.
he says that, this is what he says. He says, further, it is necessary to correct any misapprehension of the events that may exist.
Yes.
For this reason, I state that it is manifestly and wholly untrue and incorrect that I, by any means, explicitly or implicitly, intimated to Ledwaba AJ that I had any conflict of interest in the above. But
Yes.
you are telling us that this is untrue. He told you he's conflicted. He's saying what you are saying is untrue. He never told you he's conflicted.
Well, he told me that. He told me we were two in the chambers. That's what he told me. And that's the reason that he gave me for giving me that file. He said to me, himself and Chitata are conflicted. So I'm the one who must take that file. And that's the reason that I took that file. I know that he denies that he did not tell me, but that's what he told me when he gave me that file.
Thank you, Chief Justice.
Minister.
Thank you very much, CJ. Good morning, Advocate Letwaba.
Good morning, Minister.
In your questionnaire, you've been asked about what significant contribution to law and pursuit of justice.
Yes.
Amongst others, you reflected on your dissertation,
Yes.
your master's dissertation, where one of the areas you reflected is the tension between labor court and high court,
Yes.
but as well where you made reference to the issues around socio-economic rights perspective. I must say quite both are impressive in terms of the reference. Maybe if you can explain to us when you cite them as the most significant contribution, is it on the basis of it contributing to the study, being quoted by other scholars, or is it because the two dissertations in terms of how they distribute, they are cited and contribute, it's on the basis of impact in society? I just want to understand, while they are good dissertations that you have been able to make reference to, how do they contribute to society in terms of pursuit of justice?
Well, the one where I deal with the LLM for the UNISA.
Can move the mic closer to you.
To the one that I deal with
Thank
UNISA. I think my contribution is the tension between the jurisdiction of the High Court and the Labor Court, insofar as the employment is concerned. When I researched that, in the cases that I referred there, it showed to me that there's confusion as to whether the applicants are entitled to go to the labor court, or if there's a contract maybe relating to the lease, and there's a relationship between the lessee and the lessor, as to whether this person can go straight to the labor court, he must go to the High Court. But I concluded to say that the labor court came after the Supreme Court. And I said the Supreme Court, the labor court did not take away the jurisdiction of the High Court. The High Court remains with that jurisdiction. So for as long as it's not taken away from that, the person who has got a dispute can also go to the labor court, to the High Court. That's my contribution.
Thank you.
Anyone else? Commissioner Pillay?
Thank you, Chief Justice. Good morning, Mr. Lidwaba.
Good morning, Commissioner.
Mr. Lidwaba, I just want to first ask you, I should say Advocate Lidwaba, I just want to first ask you about your judgments. You've put up before us a sample of the judgments that you've handed down as an acting judge.
Yes.
One of the difficulties that I have, and I want to raise this with you, is that your judgments are written in a very sloppy manner. For example, some paragraphs are numbered, some paragraphs are not numbered. If you go through the judgments, particularly your earlier judgments, you'll find that there are typographical errors, etc. Now, in those instances, firstly, I want to understand how it is that you ultimately hand down a judgment that is riddled with these kind of issues. And secondly, why you would put that up as a sample before us of what you're capable of doing.
Well, I was asked to give the example, the judgment that I regard as best that I could, and I did that. I accept that I may have made a mistakes somewhere, but I don't think those are the mistakes that can say to me that the judgment are wrong. But maybe the commissioner can indicate to me where he says this is wrong, this is not right. Because the commissioner just talked about generally.
Yeah, I wanted to raise it generally with you first. I'm happy to get into the detail of each judgment, but we don't have sufficient time. But let's start with your Merifon judgment.
Yes.
You know that judgment ultimately went to the Supreme Court of Appeal and to the Constitutional Court.
Yes, it did.
If one reads both judgments, the Constitutional Court judgment as well as the Supreme Court of Appeal judgment,
yes,
it's almost unrecognizable to your judgment in terms of the court's approach to the issues.
Yes.
Now, in that case, a litigant had brought an action for specific performance against the municipality.
Yes.
Municipality had in return brought a counterclaim for the setting aside of the underlying contract.
Yes.
Now, my first difficulty with your judgment is that it approached those two big issues simultaneously. It's all jumbled. Instead of dealing with the challenge to the legality of the contract first. And then if you read the judgments of the Supreme Court of Appeal and then the Constitutional Court, although they agree with your conclusion, what I'm raising with you is how they reason that and how they approach the distinction between the two issues, which in your judgment is conflated.
Well, I don't understand because at the center of that, the whole of judgment was Section 19.
Yes.
They all agree with me. I haven't. I mean, what is written in the Supreme Court and the Constitutional Court. I accept that the standard is different, but they came to the same conclusion that for a purchase like that, you need a municipality resolution. That's what it comes to. So I accept that. I mean, I can't write like the High Court, like this Supreme Court, because I mean, there was Pelzer who was writing that. I can't compare that standard. And here, there was now the Deputy Chief Justice who wrote for the majority. So comparatively, I can't compare, but we come to the same conclusion.
Yeah.
It's about legality.
What I'm raising with you is how you go about conveying your conclusion. And I'm saying that in your judgment, it took a lot of time to sift through your reasoning and to understand your conclusion in light of your reasoning.
Yes, I had to deal with that because that by the time it reached the Supreme Court, many issues have been sifted out. You remember there were also transactions regarding the transfer of the property from one party to another. I had to deal with that at that level. But by the time it went to the Supreme Court, many issues had been shifted. So they did not have to deal with what I dealt with. Mine is very long because it was at a lower and I had to deal with many things. But at that time, when we went to the Supreme Court, the issues was crystallized. So I don't expect that to be the same as where I started because I was doing the groundwork.
But that's exactly what I'm putting to you. Before you, the issues were crystallized.
Yes.
It was the legality of the contract, and if you found that the contract was not lawfully concluded,
yes,
then you didn't need to deal with a specific performance issue.
There were many things because remember there was also authority from the Treasury and everything. So I had to deal with that because by the time they went to the Supreme Court, they went for specific issues, not the issues that they raised there. But I had to deal with those issues because they raised those issues. But when they went to the Supreme Court, the issues were crystallized. It was straight to Section 19. It was illegality about that one. But there were not any other issues. But I had to deal with that one. It's different from when they were at the Supreme Court. And at the Constitutional Court, they just went straight to say, we're dealing with legality here.
One of the issues dealt with by the Constitutional Court was the question of delay. Whether or not a municipality has to
I'm
provide...
starting to hear, Commissioner.
One of the issues, and this goes to what I'm trying to engage you on, which you don't seem to be accepting, Advocate Lidwaba. One of the issues, critical issues, which the Constitutional Court focused on was the question of delay, where a municipality raises as a defense the invalidity or unlawfulness of the contract, whether they have to provide a full explanation for the delay before they raise that defense. Now, one doesn't see that in your judgment at all.
I lost a bit. I think. I just had to say the delay.
Yes, it's being dealt with, for example, by the Constitutional Court. It's one of the critical decisions that they make. They consider whether or not the municipality was obliged to give a full explanation for the delay in bringing the defense that the underlying contract was unlawful. But you don't consider that at all in your judgment.
I don't know what issue was raised there at the Constitutional Court, but there sorry, it was about, all this issue was about the authority of a municipal manager having transferred the property without authority from the council. But I don't know what questions were asked there that led to to what the commissioner is talking about now.
All right. Just a second question, Advocate Ledwaba. You're aware that on the 9th of August 2025, the judiciary adopted the sexual harassment policy.
Yes.
Have you considered the sexual harassment policy?
Yes, I've read that.
And in your view, what are the kinds of challenges the judiciary will face in implementing that policy?
Well, when I read that policy, it reminded me of the sexual harassment at workplace. And I said, except that it's broader than the sexual harassment at place because it covers a broader space. I don't think there will be many challenges in implementing this, given the experience coming from what happened at the workplace. I don't think there will be many challenges. But yes, it covered a wide spectrum compared to the sexual harassment at workplace.
And why do you think it's necessary to cover a wider spectrum in the judiciary's sexual harassment policy as compared to the code of conduct?
Well, it covers, when I looked at it, it covers a wide range of people. It talks about even from the staffing and everybody else. It covers a wide range. And I think that's the reason why it's broader than what I thought at the workplace.
My question was, why is it necessary to cover a wider range of conduct?
Well, I think it comes out of experience that's happening. I mean, I thought that is something that comes experience to say we need to deal with these issues so that it doesn't get out of control. So it must be dealt with in a way that everybody understands within the judiciary. That's how I understood it.
Thank you, Chief Justice.
Thank you, Commissioner Pillay. Anyone else, colleague? Commissioner Moimang?
Thank you, CJ. Good morning, Advocate Ledwaba.
Good morning, Commissioner.
Just one from myself, in relation to the transformative impact of our constitution on South African law and politics. Can you just reflect on how did you ensure in this judgment of Malikana that the rights of those that are mostly vulnerable in society are protected? Because this is the judgment that you also refer to as your contribution to jurisprudence. Thank you.
Which case, Commissioner?
It's Malikana AM versus the National Director of Public Prosecution. It dealt with the
Marikana.
Yeah, Malikana.
Oh, Malikana. Oh, okay.
Yes.
That is the case that let me put it in this way. There was a situation where an attorney is married to a wife, and the wife is sitting at home. The attorney goes out and do what the law society says is a misconduct. And there's a property that was bought before the law society found that there was a misconduct. And then at the end of the day, they want to do a forfeiture. They come to a house. They come to the property. And what they found in the property, the only thing that they found is a house. And now this house, the law says, is an undivided half share of a woman. And is a very old lady who is a pensioner now. Now, that house has been attached. Now, the issue that I'm raising there is we have a situation where very old lady who had nothing to do with what the husband was doing, now the house has been attached. Now, this house is going to affect this woman. And I was also raising the issue that even this old man, now he's so very old, he's at home. Now, that is the only thing that they have. If this house is sold and on the basis that it's a process of a misconduct, how it affects these people. That is an issue. And this matter is still pending in the Mpumalanga High Court. It's a matter that I think I want to see through it, because it's very, very important to say, if at the end of the day you've got old age people who the only thing that they have is the house, and the house gets attached, is it what must happen? And what must happen to these old people who can no longer afford to raise a bond? They're going to be on the street at the end of the day.
Thank you, Advocate. That is the concern that I have, that this is a 2008 case, and you have just also confirmed that the matter is still pending before the Mpumalanga High Court between 2008 and 2025. Are you sure? What's the situation? When is it going to be finalized?
What happened, that matter, I argued that matter in the Gauteng High Court, and two judges were allocated to deal with that matter. The two judges did not agree what must happen, whether the house must be forfeited. And then matter went back to court again. But instead of being allocated again, then there was in Mpumalanga High Court that had started, and the matter was transferred there. The way I understand that the delay now is to get the record from the High Court, from the Gauteng High Court to Mpumalanga, so that this matter must be finalized. So that's how it takes a long time. But it's a matter that I wanted to finalize.
Thank you, Advocate Ludwaba. Thank you, CJ.
Thank you, CJ, and morning, Advocate Ledwaba.
Thank you. Morning, Commissioner. Yes.
Can you see me? Thank you. Just one minor aspect, page 74. The paginated 74, paragraph 91. I think it's about the same Merifon judgment.
Yes.
Yeah. Paragraph 91, is that part of the order?
Yes. Yes, I think there was an issue that was not dealt with in the previous judgment.
Yes, but are you ordering what? What are you ordering? Just to save time, to me it appears to be a discussion, not an order, and it should not be under the heading orders, because it might confuse the parties as to what should happen. And it suggests that they must accept an
yes, I was saying that it must be dealt with. It shouldn't be. I think I can't record it, but I think this issue was also raised, and I said it should be dealt with in another judgment.
Is that the order, that it must be dealt that way?
No. I was just making a remark. That's not something that he can deal with. Yes.
Orders should not have remarks, because they must be specific as to what should be done. Isn't it?
Yeah, because it was raised, I had to deal with it to say, I can't deal with it. It must go back.
But is it not misplaced under the order? It should have been in the body of the judgment.
Oh yeah, yes.
Order is what you are now determining.
Oh yeah, no. If you say it should not have been yet. Yes,
Thank you.
Commissioner Nokonyan?
Good morning, Chief Justice. Good morning, Commissioners. Good morning.
Good morning, Commissioner.
Just as a follow-up to the response to Commissioner Ngwaitobi.
Yes.
As regards the dispute of fact that you are raising between you and Judge Patuti.
Yes.
Is there any reason why must we believe you and not believe him?
Well, that is a question that I was asked at the other time, to say who's telling the truth. I can only talk about me because the last time I was asked whether I'm telling the truth or I'm telling the truth. It's something that's happened in the chambers. I'm going to leave it to the commissioner to do. But I think what the commissioner must look at is how this matter was dealt with. This matter, at the end of the day, the judge president himself, for a reason that he did not say, he ordered that this matter not be finalized before Patudi. He ordered that the matter must be taken to Polokwane, and he gave it to the High Court. There may be a reason for that, but I'm not saying that it's wrong, whatever, but that, to me, told me that the judge president, maybe there's something that he knows that I don't know. Because otherwise, why would he say Judge Patudi must never dealt with this matter? The matter must be taken back from Toyando to Polokwane. So on that basis, I think maybe the commissioner should just consider that.
The substance of a dispute is about what you told counsel in court proceedings.
Yes.
And the question is, why would he say you actually lied to those legal representatives? Is there any reason why he would do that against you?
Well, I don't know why would he say I lied to them, but I still don't understand why would he give me the file, give me the reasons why he's not going to deal with this file. The next thing he says, no, I never did that. Because what should we look at? And I said, let's look at where was this matter? This matter was before him on agent basis. Why did he not deal with it? And I accepted that when he told me. So why he will now turn around and say, I never gave him as the reason why he's not dealing with the matter, I don't know. But and there's no reason for me to lie to the parties, to say, I was told by Patu to deal with the matter because he's conflicted with both himself and Chitata. There was no reason for me to lie to the parties. I don't know why would I lie to the parties that I've taken this matter because it was given to me for this basis. I don't know why would I also lie to them, to the parties.
Thank you, CJ.
Thank you, Commissioner Nguyen. We have finished your interview, Mr. Gaba. You're excused. Thank you.
Excused?
Yes?
Oh, thank you. Thank you. Thank you. You know.
Okay, Liebenberg.
Good morning, CJ. Lovely to be here. Thank you.
How are you?
I'm well, surprisingly.
Good.
I noticed, may I just say, I noticed the Premier walked out as I came in.
No, that's all right. He'll be back.
He'll be back.
Yeah. Will he be back, AJP? Let me not make assumptions.
Yeah.
I thought you went to get tea or to the bathroom.
I also assume that he'll be back. He didn't say anything.
These things are
He's
still
back.
there.
He's
Oh,
back.
there he is. Okay. Your application form says you were born in 2072. When exactly were you born?
I realized that this morning as I'm reading it. And yes, in fact, I was born the 24th of November, 1972.
I thought that might be the case. The person who typed this form for you didn't do you any justice. I picked up a few other typos, but this one was rather startling.
Indeed.
All right. You hold BA honors and LLB from what used to be Rao.
Indeed.
And you started out as an attorney.
I did so, yes, CJ.
And you did your articles with 3 law firms and you explained how that came about.
Yes.
And at some stage, you practiced as an attorney for how long?
It was for 2.5 years.
2.5 years.
Yes.
Okay. And then decided to join the bar.
Yes, that was in January of 2000. I commenced my pupillage here at the Johannesburg bar.
Yes. And you mentioned that you switched chambers. You started somewhere, then ended up with Group 21.
When I started, I was one of the last intake when the bar was really still in town, and I took chambers up in what was Innes Chambers, what is now the NPA's building.
Yeah.
Which was wonderful for a baby junior who could run across the road and do what needs to be done by way of postponements or noting judgments.
And you've practiced as an advocate since 2000?
I've been in practice throughout since 2000, yes.
And what kind of work do you do?
At present, as I indicated in my questionnaire, over the 25 years at the bar, my practice has evolved to, I would say the latter half of it is mainly within the context of family and matrimonial work, where it became a specialized practice.
Yeah.
Not because I chose it, but because practice chose me. I enjoy it. I enjoy it.
Yeah, that kind of work chose many women practitioners for some reason.
Yes, indeed.
You also have, you've undergone mediation training.
I did. It was a 20-hour course I did in 2013. And pursuant to that, I assisted with FAMSA, the Family Life Centre in Johannesburg and Parkview, mediating, which I did for a couple of years, but I found the co-mediating module and method that they followed, it didn't suit me.
Is it a skill you apply a lot in your practice?
Sorry,
Is it a skill you apply frequently
Oh,
in
absolutely.
your practice?
Oh, absolutely. Within the context of family law, I regard it as my professional duty to rather find consensus-based solutions than advocating for litigation. It is simply too traumatic for both litigants, but if there are children involved, more so for them, so that one has to mediate insofar as it's a mediation, but find common ground and settle a matter.
You started acting as a judge in April 2020
Indeed,
in Johannesburg.
in Johannesburg.
That was during the COVID lockdown.
It was a baptism of fire, CJ. I remember so well, my registrar, we managed to meet each other so that she could hand over to me the hard copy files, because she was still unsure about case lines. I learnt about case lines there and then, for which I was eternally grateful. And it was very peculiar, and it was really the first time having to hold court online, sitting in my study at home with young children in the background and having to tell them to keep quiet because mom's working.
Yeah, interesting time that was.
We survived it.
Yeah, we did. How long was that acting stint?
That was, initially I did only a week at a time pro bono. I did 3 of those stints, and then since, let me just see here, what was it, in June of 2024, I took on longer stints, and it became stipendiary appointments, so that as I sit here today, subsequent to completing my questionnaire, I now have 29 weeks of acting under my belt.
All right. And during that time, in which courts have you had occasion to sit?
It is, at the time of finalizing the questionnaire, it was only in the civil courts. I sat in civil trials, opposed motions, unopposed motions, full court appeals, full bench civil appeals. I did say urgent court, unopposed divorces. Yes, and then subsequent to mid-June, in the last stint I had now in the 3rd term, I had occasion to sit also in criminal appeals, both in a full court criminal appeal and then a full bench criminal appeal.
How many criminal appeals have you done?
Well, I read 3 and we heard 2.
Have you sat presided in a criminal trial?
Sorry?
Have you presided in a criminal trial?
I've never presided in a criminal trial, no.
Have you done criminal work in your practice?
In my practice, no.
Okay. You've also attended the advocacy training course.
Indeed.
What was the purpose of that course?
The purpose of the course was to train me to be a trainer for pupil members, and to train the pupil members in what is termed the method, which is an international renowned and accepted methodology of training young advocates and pupil members in practice, in advocacy training.
Have you trained any pupils?
Yes, indeed. I've had 3 pupils myself in the 25 years. I'm very proud of them. They are doing exceedingly well. 3 ladies. I have also then, in the context of the group itself, we're a very large group with very many young members, advocates, and it's been a pleasure also to assist them both in informal lectures, but then whenever they knock at my door, they must come in and come ask advice, and I readily give it.
All right. How many judgments have you written?
CJ, as I sit here today, I have written 50 of them. I have 6 that remain reserved since my last stint, 3 of which are in the context of appeals. I'm waiting for 1 where I'm the scribe, 2 I am the scribe, 1 I'm waiting for comments from my co-judge. But yes, I have written 50 judgments, written judgments.
Any of them reported?
None. They have been, some of them are available on SAFLI and other online libraries, but nothing in the printed law reports, no.
The ones you say are reserved, when were they reserved?
I reserve judgments, if you will allow me to put on my eyes. The oldest reserved judgment, if I can call it that, was an opposed motion that I heard on the 26th of August. And I'm putting the final touches to my judgment.
That's the oldest, you say?
That's the oldest of the six, yes.
All right. All right. AJP?
Thank you, Chief Justice. Advocate Liebenberg, good morning.
Good morning, AJP.
I note that you've practiced for about 25 years.
Yes.
And mainly on matrimonial matters.
Indeed.
And in the questionnaire, you asked how often do you appear in court? You say occasionally. If you can indicate in the 25 years when you say occasionally, how many times you appear in court in a year?
I generally appear at least 2 or 3 times per month in court. I regard that as occasionally at this juncture. There were times where, as a young advocate, I was in court nearly every day of the week in unopposed court. That's simply not so anymore. I do far more chamber work, far more drafting work. That is the preparation of affidavits for then to argue then. So I would say about 2 to 3 times a month.
You indicated that you've never sat in a criminal trial and that you sat in criminal appeals.
Yes.
How many appeals, criminal appeals, did you sit on?
We had rostered, there was one full court appeal that I sat with very seasoned criminal judges and seasoned in criminal law. And then I sat, we had 2 full bench criminal appeals, of which one was postponed on the morning of the hearing. So we heard just the one.
Were you a scribe in any of those matters?
I am a scribe in one of them, yes.
And the judgment is still outstanding?
It's still outstanding. I'm awaiting comments from my co-judge.
Okay. Another aspect in paragraph 11 of the questionnaire, when you were asked to talk about your health.
Yes.
Since it's a public have access to these proceedings. CJ, can I read out what she stated?
I have absolutely no objection.
Yeah, you say in 2007 you were diagnosed with bipolar mood disorder and general disorder.
Anxiety disorder, yes.
Anxiety disorder. Can you maybe explain to this commission as to what is the situation now? How you're coping?
Since 2007, I have been receiving treatment by way of medication. I see my psychiatrist twice a year. As and when needed, I see a therapist. But that has nothing to do per se with the bipolar mood disorder or the general anxiety disorder. I believe that there is no reason for me to be ashamed of the conditions. I'm very fortunate in that my condition has been 100% stable. I have never since 2007 missed a single day's work because of it. Other people are not as lucky. But I am very fortunate. And I can and I do cope with it. as some people cope with high blood pressure or a heart condition or diabetes. It is treatable, but one has to be compliant, which I am.
With the workload in Gauteng division, as you've only acted for 29 weeks, do you still think that you'd be able to cope if you are recommended and appointed?
Absolutely, I have no doubt. It is, I don't think people who are not used to Johannesburg, I'm familiar with the Johannesburg court specifically, have got no inclination of the amount of work there is. And one has to do what one has to do when you have to do it. There is one opportunity to read. You must read for meaning, you must be prepared. I have coped, I think, exceedingly well. There were times where in the last stint it was somewhat overwhelming because I was pulled in at the last moment to assist in a post-motion court so that I had 2 opposed motion court weeks within 6 weeks. It took a lot of work and a lot of effort, but it's possible, absolutely.
Yeah. As much as we've got a family court, and you've also indicated that you've been working with matrimonial matters for some time.
Mm-hmm.
But in Gauteng, you've got to be able to cope with other works like criminal work, opposed motion, etc. Mm-hmm. Did you have an occasion to deal with criminal bail appeals?
No, not yet. No.
Have you been allocated any petitions where leave to appeal in criminal matters?
No, I have not. It was simply a manner in which I was rostered, whether by the DJP and the then JP. I've just never been rostered into the criminal courts. Also within Gauteng, specifically Johannesburg, judges are rostered for an entire term in the criminal court. And I have not acted an entire term for 9 weeks on end at any time.
Yeah, we don't roster judges, especially in respect of automatic reviews. Thank you. Yeah. My last question, in respect of the automatic reviews, mm-hmm. because they're just allocated to all the judges, did you get an opportunity to deal with those automatic reviews?
No, I have not.
Thank you, CJ.
Premier?
Thanks so much, CJ. Good morning, Advocate Liebenbeck.
Good morning, Premier.
Advocate, Gauteng is a cosmetic province that incorporates literally all constituencies. Mm. Informal settlements, townships, hostels, farming communities, suburbs, and all other constituencies.
Yes.
And I've gone through your profile. I've never seen an inch of understanding of all these constituencies that you may need to understand when they appear before your court. Am I right or wrong?
Sorry, I'm not following, Premier. I haven't seen what?
I'm trying to get your I'm saying Gauteng, you know Gauteng have all these constituencies.
Yes.
I'm trying to understand that if these constituencies appear before you in court, mm-hmm. will you have a better grasp of understanding their background and understanding their needs?
Well, Premier, in my practice, I have had occasion to interact with people from a variety of backgrounds. I have had pro bono clients from informal settlements. I have had clients living the most extraordinary life. I was fortunate in court itself. I have had occasion, reference is made, is it in Judges Matters, I think, a judgment I wrote where I was not prepared to authorize, in terms of Rule 46A, an executability order against somebody's home because I regarded the amount owing as too trivial to allow a home to be sold in execution. Attached to my bundle is a judgment I wrote regarding an interim interdict against the background of the National Feeding Scheme, Scholar Feeding Scheme. And to me, given what that feeding scheme is intended for, and it is intended to feed those children in quintile 5 schools who are unlikely to have any other meal of the day. That weighed very heavily on my mind, and in the exercise of my discretion, that was a factor. So that I do believe that I'm fortunate enough and empathetic enough to understand how fortunate I am, as opposed to so many others out there in Gauteng, the cosmopolitan province that we are.
Thanks for that, but if that was too close to your heart, when you are asked about your community involvement here, this will be high on your list of community involvement and pro bono work that we've done before. But what you've just beautifully explained to me is not tabulated in any of your documents.
Sorry, Premier, the judgment is...
Not the judgment. You said you've been doing pro bono work in informal settlements.
No, I did not say I do it in informal settlements. I said I do pro bono work, and some of my clients came from informal settlements. So that an institution such as probono.org would ask for assistance. I've had occasion where some of the larger attorney firms in town have a very specific department dealing with pro bono work, and I've done work with those firms, and it is for people who come out of backgrounds that I cannot even imagine.
I know you served in the school governing board.
Yes, I did.
Of large school UNICA.
Yes.
And in most instances, were responsible for the policy formulation of that document.
Yes.
Will you say that there are documents that promotes access and transformation? And what is the status of this school now in terms of representation of other races?
Well, I haven't been part of that governing body for some time. It is an Afrikaans primary school, formerly Model C school. I'm very proud to see more and more darker complexion children attending that school, because it's a very good school. But yes, it is an Afrikaans primary school. But the school is far from absolutely representative insofar as race is concerned, and no doubt because of the language of instruction.
But you served there for 3 years.
Yes, I did.
So for 3 years, you didn't see the importance of expanding the scope of the school to incorporate everyone?
Well, when I formed part of that school governing body, what was uppermost important at the time was that school running with COVID and the lockdown. and what we did for purposes of ensuring that all the children in the school, also those that come from less fortunate circumstances, were able to receive education online by way of Google Classrooms. We were able to source tablets, data, and assist families who were less fortunate to also ensure that those children were able to attend school online.
Thanks so much, CJ.
Thank you.
Yes, JB?
JP.
Yeah. Advocate Liebenberg, I'm just concerned with your choice of word, describing people by their complexion. When you say darker complexioned children, who are you referring to?
Africans, JP.
Is that a proper description by the looks and the appearance?
Well, the question was whether the school was representative of the society.
Yes.
And the answer is it's an Afrikaans school with mostly white children. But yes, they are, and more I see, simply because I live across the road, I see the little faces that come to school. And it's African children, and African as in the broader definition of black, colored. I think there might be some Indian children, but it is an Afrikaans school.
Yes, but collectively you say darker complexioned. That's my real concern. You've now explained it differently.
Yes, I mean no disrespect.
Thank you.
I choose not to think in terms of race because I think we're all the same.
But that's exactly blankers and blankers. This is what used to be. Even all the science used to be framed that way.
I apologize. My choice of words were wrong.
Yes. Commissioner Hassan, it is a follow-up.
It's related. It's not exactly a follow-up.
Okay.
Ms. Hassan.
Thank you, Advocate. I guess it's somewhat related. Across the 25 years of your practice, you've mentioned here that you've only had 3 juniors.
Yes.
Let me understand first before I probe my question. What was the demographic of the juniors?
They were all all African.
And do you think that 3 juniors in the span of 25 years is sufficient?
In the context of family law, regrettably, that's the reality.
Did you take any proactive steps to actually gain juniors?
In the context of family law, Ms. Hassan, perhaps I must just preface, the juniors I had in 2 matters were in fact commercial matters. It was insurance matters. There was 1 black junior I had in a family law matter. Family law, regrettably, I deal with individuals, and litigation is expensive. So that it is the type of work that I've received, the attorneys that brief me, very rarely do clients have the financial wherewithal to pay, never mind 1 advocate, but far less so 2 advocates.
Maybe before we get to the fee splitting, Advocate, are you saying that you didn't see the need to have black advocates because you had a family law practice? Or black juniors, rather?
What I am saying is that my practice and the type of work that I received.
Now, I recognize the type of work that you've received. When we're trying to understand the level, I mean, you want to be ascended to the bench. Briefing juniors is not just a matter of compulsory work, it's part of the transformation. And one of the challenges that keeps coming up, not only in this body, but in the industry, is the briefing patterns are extremely problematic. there are spaces of law in which young black juniors just do not get briefed. Are you then saying you did not brief black advocates by virtue of the fact that they were family law? Let's leave the fee split in a moment, we'll get there.
Well, Ms. Hassan, as counsel, I do not brief advocates. My attorneys brief advocates. Attorneys brief them. What I
No,
would do.
what I'm asking is you didn't see the need to bring on black juniors onto your work.
Not in the matters I had, no. There were no space for any junior, black or white. It was simply not the type of matter that required two. But what I did do is the moment that a matter would come my way, and there were parts of the brief that did not require my attention as a senior, more senior practitioner, I was very happy to give the names of colleagues in my group and elsewhere, black juniors, to do that portion of the brief.
All right, and then just before I yield back to you, Chief Justice, I'm interested to know on the fee splitting agreement. You indicated that the reason why you didn't bring on black juniors was because of fee splitting issues. Maybe you could explain that to us?
No, it's not about fee splitting, Ms. Hassan. Regrettably, as I've indicated in my questionnaire, working for individuals, I could never charge the rates, for instance, that commercial colleagues may do, because I work for individuals. And that was part of what I thought my way of giving people access to justice was to work at reduced fees so that people still battle to pay, and then to expect them to pay for two counsel becomes virtually impossible. So that I was only ever in family law, in a family law context, junior in 25 years, perhaps twice or three times, and then only for little bits of the entire matter. Because even those people with financial wherewithal have difficulty in paying the costs of litigation. It's incredibly expensive.
And have you taken any concrete steps to change briefing patterns in your bar council, in your group, anything related to that?
Yes, as I mentioned, I make a very specific effort to, when my attorneys call for names of juniors who may attend and can attend to matters, to refer them to black juniors, absolutely. Men but more so females.
Minister? Okay. Oh, before Minister, the follow-up?
Unless the minister is also following up. No. Advocate Liebenberg, the advocates for transformation, you know who they are?
Yes, indeed.
Yes. They say that you were a vociferous opponent of the three council rule. Is that correct?
Commissioner Katobi, I was taken aback when I read that. One, as I recall, that rule was adopted at the annual general meeting of the society in October of 2015. I was not at that meeting. I'm not opposed to transformation, but I may have raised questions in a different fora, whether it was in the common room in the group, as to the methodology of the implementation. But then as advocates, we very rarely agree with each other as to how to do things. But no, I was not a vociferous opponent, no.
And what was your concern about the methodology of implementation?
It's 10 years ago. I do not have independent recollection. I think it was, my biggest concern was probably mindful, again, my perspective from my practice as in family law, it is exceedingly difficult to pull in a junior, much less three, that there are three advocates on a matter. And I was concerned about, it might be that, I really do not have any independent recollection of what I may or may not have said, but that transformation is a must and an imperative stands. It's a universal truth.
What is the problem with your practice that disables you from implementing transformation?
No, there's nothing disabling me from doing that. It's simply a question that my practice does not allow the appointment, more often than not, of two counsel. Doesn't matter whether it's two juniors, whether it's a silk and a junior, it's difficult.
How does that apply to the three counsel rule? I'm struggling to understand why you are introducing your practice in relation to the three counsel rule.
I'm trying to answer it, well, as family law practitioner. To appoint two counsel is difficult. To then seek more so, because as I recall, the rule was aimed also at then regulating a compulsory aspect to the appointment, which may render a member guilty of unprofessional conduct if you do not do so.
Yes.
That became Rule 7.
Yes.
That is exceedingly difficult in a family law matter.
I'm struggling to follow. The rule says if you have three or more advocates, it's compulsory for the third advocate to be black. If you fail to do that, you are committing misconduct. What's the problem with that?
No, there's no problem with that. 10 years ago, there were debates about it. And I may have raised concerns in a common room situation at Chambers. I can't remember that I did.
But what were the problems you were raising in the common room at Chambers about this rule?
The implementation, how it will be implemented.
But what's the problem with implementing it? That's what I don't understand. What were you objecting to the implementation?
No, I wasn't objecting to the implementation.
What was
I
the
had
concern?
questions and reservations about it. That doesn't
What were
mean
the questions and reservations?
I cannot recall. I do not have independent recollection of 10 years ago. I'm sorry.
Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Advocate Liebenberg.
Good afternoon, Ms. Play.
As I understand your answers to both Commissioner Hassan and Commissioner Mbokai-Tobi, you've only ever had 3 juniors in your matters over 25 years of practice.
Yes, yes.
You've only led 3 times.
That's as I recall, yes.
And those were 3 specific matters.
It was specifically 3 specific matters, yes.
And all 3 times you used black juniors.
Yes.
And your explanation for not using more juniors is that your practice doesn't allow it.
Indeed.
Now, I know most established groups at the Joburg Bar have what's called a junior fund.
Yes.
Where they allow their members to utilize that fund in order to bring on juniors onto their matters. Does Group 21 have such a fund?
Yes. Yes.
And have you utilized that
No,
fund?
I have not.
Why haven't you utilized it?
I have experienced in court, in family law matters, not sitting on the bench, on the other side, the perception that it creates the moment that a litigant has more than one advocate. It creates the impression of there being more money than there really is. And that is it's a dangerous perception. And the perception is that of the presiding judge. and it does have an influence, regrettably, at times on judgments.
So is your true answer then that you chose not to bring more black juniors into your practice in order to protect your clients from an unfair perception?
In part, yes.
So why didn't you give that answer initially when you were asked about this?
I'm sorry, I didn't think of it initially.
Can I then take you to one of your judgments?
Yes.
It's the judgment involving 2 children.
Yes.
Who were engaged in a bullying environment. You recall the judgment?
Yes, yes.
It's got a difficult name. I think it's something like L versus
Yes,
R.
we had to redact the names.
Now, can I ask you to go to paragraph 50 of your judgment?
50. Yes.
Find it at paginated page 44.
Yes.
And in this matter, as I read your judgment, one of the issues was that the one child had at some point grabbed the testicles of the other child.
That was the allegation.
And the
yes.
other child considered that to be harassment, and that's one of the incidents that gives rise to the dispute, which is before you. Now, in paragraph 50, you say, I'm picking up from the middle of that paragraph, you say, in the context of this matter, I emphasize that the conduct is unacceptable and requires censure. But there is no suggestion on the affidavits filed that the alleged squeezing, and I'm going to read into that squeezing of the genitals, was sexually motivated conduct. You say whether the alleged incident amounted to sexual harassment was not established. Now, I just need to understand, if you've got 2 parties and the one squeezes the genitals of the other, how does that not amount to sexual harassment?
In the context of this matter, we were dealing with 2 young boys. And it was an appeal, civil appeal, from the magistrate's court. The boys at the time, I'm just checking, 9 years old. So very much one of the aspects was whether or not these children were Dolly Kapaks.
Sorry, can you just repeat that word?
Whether these children or the alleged perpetrator were in fact Dolly Kapaks, whether they had the capability of being legally liable. My co-judge and I debated the issue. This was a single incident. There were substantial, it was 2 parents deposing to affidavits, the magistrate having made a decision not to hear oral evidence in the face of factual disputes. The reference to squeezing was in fact the word utilized by the one parent. And my co-judge and I debated the issue, and we were satisfied that on the allegations before us, that did not amount to sexual misconduct. These were 2 boys fighting. And there was a real concern as to whether, in fact, the alleged incident really took place.
You see, Advocate Liebenberg, I don't want to get into the weeds of that particular matter. I'm debating the principle with you now, which is a very concerning one, and I'm going to be frank with you.
With adults, we're talking it's something completely different. When it involves adults, that is sexual harassment, absolutely. But in the context of 2 young boys, my co-judge and I, we were not satisfied that it amounted to, for purposes of the act.
You had already addressed the question of capacity of the children separately in your judgment, and you had made findings in relation to that.
Yes.
You are on a different topic now, which is, does the conduct amount to sexual harassment?
And you say there that it's not sexually, this is your word, the words used in the judgment, it's not sexually motivated conduct.
Yes.
Now, that's the difficulty I have. How does that square up with the definition of sexual harassment in the Prevention of Harassment Act?
I don't have the, let me just see if I have, if the...
Can I read to you what the definition says?
Yes, I'm just trying, I think I may have quoted it, but yes.
A of sexual harassment, the definition of sexual harassment is unwelcome sexual attention from a person who knows or ought reasonably to know that such attention is unwelcome. The second one is unwelcome explicit or implicit behavior, suggestions, messages, or remarks of a sexual nature that have the effect of offending, intimidating, or humiliating the complainant. Now, you're finding that it didn't constitute what you call sexually motivated conduct. It's not clear to me how that squares up with the definition of sexual harassment. And I'm worried about what kind of principle we draw from your finding.
Well, it must be gauged with respect, Commissioner Pillay, against the role players here. Because if we are talking children who do not have the capacity to appreciate necessarily what their conduct amounts to, that does not fall within the definition of the Act.
But then why did you go further and make a finding on sexual harassment? Why didn't you end your judgment on these children lacked capacity?
As I specifically recall, my co-judge included this reference. We agreed. And I do recall that it was her comment, and I accepted the inclusion, the suggestion to include that. Because in the context of this matter, I similarly did not believe it to be sexually motivated conduct.
But you're coming back to the problem of sexually motivated conduct and what that could possibly mean going forward in terms of interpreting the Act.
Well, the judgment, with respect, and at the risk of repeating myself, there's a difference, a big difference, in when one deals with children of a specific age, behaving in a particular matter, and when one has children perhaps that are older, at a stage of maturity that one would expect them to know better, and when one deals with adults. That sentence should not, and with respect, cannot be interpreted to constitute a blanket principle when dealing with the Prevention of Harassment Act, because of the role players involved in this particular matter.
Not sure what cannot be interpreted, because I've just interpreted it that way, because what you're saying now is not reflected in your judgment to curtail that paragraph to the facts of the particular case.
I accept your interpretation.
Thank you, Advocate Liebenberg. Thank you, Chief Justice.
Thank you.
Thank you. Good afternoon, Advocate Liebenberg.
Sorry,
over here.
Oh, sorry, President.
Good afternoon.
I hear the voice. I should have seen the hand. I do apologize.
Yes, that's fine. How are you?
I'm doing well, thank you.
I want to ask you a question, and the reason why I'm asking this question is that in response to the questions posed by the Chief Justice and the Acting Judge President, you indicated that you've never presided over a criminal trial. You haven't done petitions emanating from a criminal court. You haven't dealt with automatic reviews. You have had an opportunity of participating in a criminal appeal, but you have not yet written a judgment, or your judgment is still in the process of finalization. I'm sure you'll agree that criminal law is a very important area of the law because, I mean, as a judge, you can actually take away someone's freedom for life,
Absolutely.
which is a constitutionally protected right. And this is why where my concern emanates from. And I am mindful of the fact that as an acting judge, or even as an ordinary judge, you don't allocate work to yourself, so you don't choose cases. But fact of the matter is that you haven't done any criminal work at this stage. How will this body be in a position to assess whether you will conduct the proceedings in accordance with the requirements of the law when you are allocated a criminal trial? Because in as much as you have never been allocated a criminal trial during all your acting stints, we can all accept that once you are appointed, you can't escape that you will be allocated a criminal trial.
President, it's something that concerned me, and I'd hoped to be rostered, and I asked to be rostered. It didn't happen. I must say I was surprised when, and of course I must learn. I'll have to learn. But I was very pleasantly surprised when I had to prepare for the appeals, and I felt so out of my depth. And then in our pre-hearing discussions, when I was asked questions and I gave the answers, that it's kind of a muscle memory that kicks in. Yes, there are nuances. Of course, there are nuances in criminal law as opposed to the civil law. But the muscle memory of what I was taught 30 years ago, what I learned for my bar exam, it's still there. And what I also found was in Johannesburg, the amazing collegiality to be able to ask, I have a question, I have a concern, help me with my gut feel. I had an occasion, yes, in the context of a family court matter, but it was purely because it emanated from a Rule 43 order, where the respondent had been convicted of contempt of court, and the sentence was suspended on certain conditions, and he had not complied with those conditions, and what came before me was an application to set into motion that sentence. And I was able to talk to a colleague, a neighbor, and I was right, my gut was right, and I was quite proud of myself in realizing that no, I can't change the sentence. 14 days is 14 days, but I was able to craft an order implementing the sentence and send the man to the golf over weekends so that he was still able to work during the week so that he could pay his maintenance order.
Yes.
And that was, yes, there's a gap in my experience, and I accept that, and unfortunately there's very little I can do at this juncture about that gap.
Yes, thank you very much.
Thank you,
CJ,
President.
my second question, and it's related to the first. Two scenarios in a criminal trial. Under which circumstances would you order a separation of trials, and under which circumstances would you make an order for a trial within a trial? Thank you.
Thank you. Separation of trials would be where, for instance, if there are multiple accused, the one would plead guilty and the other not guilty. Then one would separate the trials. A trial within a trial is really a question on determining whether evidence is admissible or not. It's a question of the admissibility of evidence when there's a trial within a trial.
The question was, when would you make an order for that to take place?
Oh, sorry, the
The
trial
trial
within
within
a
a
trial.
trial. Can you make an example? Thank you.
For instance, should an accused allege that a confession was somehow elicited unlawfully, be it under torture or threat or of some kind, then to ascertain, I would order a trial within a trial to determine the admissibility of that confession. Thank you.
Thank you very much, Advocate Liebenbeck. Thank you, CJ. Else, colleagues? JP?
It's me again. Just to follow up on the criminal trial experience.
Yes.
Often in criminal matters, especially at the High Court level, you come across very serious cases. You have to look at post-mortem examination reports, which are quite gory, scary. Will you be able to manage to look, analyze these documents?
I see no reason why not, JP. In children's matters, when one has to read, it's not necessarily the blood and gore of photographs, but to read reports, expert reports. It tugs in places you don't want to be tugged, but you have to, and you analyze it for what it is. If I can avoid blood and gore, I would appreciate that. But that's not my job. My choice is not what seizes the day. One has to look at it. You have to consider it, and do so forensically, detached, in as far as possible.
But it does take some time to get used to this.
Of course
Otherwise,
it does.
it might have a serious problem.
No, of course it does. Well,
Thank you.
JP, that's family law. It's the old thing, well, not an old thing, but it's trauma. It's traumatic. And one has to, and I think I've learned through family law and the trauma that my clients bring to me and how to deal, I have to deal with it for myself. It's the similar skills that one then adopts within criminal law.
Thank you, Advocate Liebenberg.
Thank you, JP.
Thank you.
Thank you very much, CJ. Good afternoon, Advocate Liebenberg.
Prof, good afternoon.
I was quite taken aback in relation to the issues of transformation that were taken up with you. In particular, earlier on you said that you were not comfortable, or perhaps the core mediation process did not suit you. And then it was revealed that at some point you had certain discomfort with a 3-counsel rule. When I look at these events, it creates a perception in my mind that brings up a question whether you are able to work within a team. Not because you are forced to, perhaps maybe you have sat on appeals and all those kind of, because we don't know what really happened there. But it creates that perception that are you able to work and function adequately within a team, not because you are forced to, but because you are comfortable in doing so.
All right. In relation to the co-mediation model that I did not find comfortable, regrettably, it was, the model is a legal practitioner and a mental health practitioner co-mediating. And it got to me that the mental health practitioners gave legal advice and did so wrong. They gave wrong advice. And I found it uncomfortable, and I was I didn't wish to enter into nastiness or have fights about it. So that was the discomfort there. When I say in relation to the 3-council rule, it was never whether or not there should or should not be transformation. It's a question of the implementation thereof. More so that I was, and I think back about what I may have found uncomfortable was to tell an attorney or tell a client who must or must not be briefed, because I am so sensitive to who gives instructions ultimately and the role of advocate. But no, I work in teams. That's what I did on a school governing body. That's what I do within the context of the family law, Gauteng Family Law Forum that I'm part of. We work as a team. That's what we do.
My second question, there appears to me that there is, and now I go to your area of specialization, which is family law. There appears to me that there is some jurisdictional war on Rule 43 applications in Gauteng and in KZN. I've read recent cases from KZN where judges there, one judgment really shocked me, where a Rule 43 application was struck off the roll because it had 47 pages. And the judge said it was struck off the roll based on prolixity. And the judge did not go to explain to us what will then be acceptable number of pages. But I know for a fact in Gauteng that the pages of a Rule 43 can go up until 500 pages, if not more. What is, in your view, the proper way of adjudicating Rule 43 applications when a judge feels like, but I've been given too much paper to read?
Prof, as you know, in Gauteng, there's the mandatory financial disclosure form that has to be submitted. That form contains a myriad of information and calls for lots of information and copies of bank statements and the rest. In matters where finances are at play, where it's a question of maintenance. The difficulty in having to condense facts for litigants is the long-term effect, potential long-term effect that any Rule 43 order may have. And as a presiding judge in that court, I was fully aware that I had to accept a bit more than perhaps they would in Natal. But to put a number to what is enough, when is it too much? It's very, very difficult. And it becomes overwhelming in family court to read all of that and to have to distill what is important in that, well, it's no longer files full of paper, it's case line full of paper.
No, thank you very much. And parties play hide and seek and catch me if you can and all those kind of things. Thank you very much,
Thank
CJ.
you, Prof. Thank you so much.
You're excused.
Thank you very much, CJ. Thank you, commissioners.
Commissioners, lunch is ready if you want to eat now. I know it's a bit early, 12:30. Go eat quickly and come back and just plow through the afternoon. I propose that we do that. Thank
Good
you.
afternoon, CJ.
Are you well?
I am well, thank you.
All right. Sorry to keep you waiting. We had well, you were here when it happened, so I did not explain. All right. Let's begin, shall we? You are a judge in the labor courts since 2017.
Yes, CJ.
And let's take a few steps back. You studied law, obtained a BProc LLB from the University of Limpopo, and later a diploma in insolvency law from UP, and then a certificate in international commercial law from a certain university in Amsterdam.
Yes, Freie University.
You did articles and practice as an attorney for a very brief period. Then joined the University of Limpopo as a law lecturer, I assume.
Yes, CJ.
Which subjects did you teach?
I taught the commercial law, labor law, and I also taught insurance law.
Insurance law. Okay. Then in 2003, you decided to go back to private practice.
In fact, in 2003, when I started my practice, I was fortunate also to get employed by the university.
So to get?
To be employed as a lecturer at the University of Limpopo.
Oh,
so when I started the
part-time.
practice, yes, simultaneously
All right. So you ran that practice until your appointment as a judge in 2017?
Yes.
Okay. Doing what kind of work?
I did, in fact, it was a general practice, but I focused more on the labor law. I did the contracts. I also served, in fact, I did work for the Land Claims Commission where I assisted the claimants with the formation and of legal entities. So I did contract law, and I did also wills and estates.
Yes. All right. And you were involved with the CCMA and various bargaining councils between 2012 and your appointment as a judge?
Yes.
All right. So you have actually sat in the High Court during your time at the labor courts.
Yes, I sat. I acted there for 18 months.
18 months. Yes. And which courts did you sit in?
I sat in almost all courts except the civil trial. I mean, sorry, the criminal trial.
So did you say except?
I sat in all courts as CJ.
Including criminal?
Except
except
the criminal trial.
Oh, I see.
But I sat in criminal appeal court, full courts. And I did the reviews, criminal reviews, and petitions.
Was it your choice that you did not sit in the criminal court?
No,
How
it wasn't.
did that come about?
No, it wasn't.
Do you know why you were not rostered to?
I did not know. I do not know, and I did not ask.
I suppose it wasn't your place to ask. All right, so you don't have any experience on the criminal side?
I wouldn't say that. I have a fair understanding of the criminal law. As CJ would know, as a candidate attorney, I served at Mankwen Mahabane Attorneys, which was a general practice. And in early years, as a candidate attorney, you would be sent to all the courts, particularly as a candidate in the criminal, to do criminal or to bail applications, matters which are not really complicated. But my experience also so maybe I should start by saying when I then started my law firm,
I did not do any criminal matters. But at the High Court, as I indicated earlier, CJ, I did sit in full court criminal appeals. I sat in, I did also the reviews and the petitions. So I do have a fair understanding of criminal law.
How have you enjoyed the labor court?
I have enjoyed being at the labor court. It is not an easy court. The workload there is insane. CJ would know that.
Yeah. Well, is it any better where you want to go? I don't think so.
It's not necessarily better. But it's because labor law is specialized, as we all know. I would want to move to a court where I think I've served the labor court, and I think it's time for me now to move to a court that to the High Court, where I will be dealing with different kind of laws.
Yes, no, but I fully understand. You've written judgments at the labor court.
Yes, I have, CJ.
Many, I hope.
There are a lot.
How many?
When I counted, it was over 400, CJ.
And in the High Court?
In the High Court, I have also.
You haven't?
I've written judgments.
Oh, all right.
Yes.
How many?
About 26.
All right. Have any of these judgments been reported?
Yes, CJ, when I looked, or when I checked, the last time I checked, about 100 or so of my judgments, or just over 100 of my judgments have been reported.
You listed 3 reserved judgments in your application form. Have you been able to deliver those?
Yes, they have been delivered, CJ.
All of them?
Yes.
All right. All right. AJP.
Thank you, Chief Justice. Good afternoon, Judge Mahosi.
Good afternoon, AJP.
You indicated that as a candidate attorney, you were sent to all courts to do bail applications and some of the trials. When you say all courts, I think you mean district courts. Because
district courts, yes.
Okay. You have seen the comments from the GCB, compliments and some of the negative comments by the GCB.
Yes, I have.
And looking at the matters that you handle, I also noted that you did 6 full court appeals.
I have, AJP.
In the said appeals, is there any of the appeals where you sat as a senior judge?
No. But I have written judgments of all. I have written about 4 judgments for the full court. For the full court.
In paragraph 14.1, it is stated that the last sentence, on the other hand, the candidate perhaps lacks experience dealing with full court roles. I don't understand. Do you know what could be GCB meaning when they say you don't have experience in dealing with full court roles?
Yes, I saw the comment, AJP, and I do not agree with it because I think, or I believe that I have had enough exposure in that regard. I have sat, as I indicated, I have sat in the full court appeal, both in Pretoria and Johannesburg.
During your stint sitting in Pretoria and in Joburg, did any of the leadership or any of the senior judges indicate to you that maybe there were some complaints that you are not handling the course well, you are abrupt, and that you are ill prepared to hear certain matters?
No, I have not had that kind of complaint.
Now, I'm just raising this because in Pretoria, every term we meet with PSA to discuss the challenges that we have with council, and they would also indicate to us the challenges they have with our judges. So as I stand here, I haven't had any complaint, or PSA have not indicated any complaint. So on these complaints that they are raising, because you said you want to be in the High Court, what's your response to them? Maybe to be more particular, when they say that you are ill prepared to hear matters, you are ill prepared to hear matters, and you prefer a form rather than substance.
I saw that comment, AJP, and when I saw it, I was actually very surprised. Because as a judge of the labor court, where we encounter lay individuals, if I was an abrupt and perhaps ill-prepared, or any of the comments that they've made, I don't think I would be sitting here for this interview. I would have long been reported, and I don't think I would be here. So it is not true. In fact, what I've done after seeing the comment, I went back and I looked at the roles at the High Court, and without giving this commission a lot of work to do, but I have uplifted a few of the roles particularly in the unopposed court, where, for example, on the second week of the second term of this year, I sat in an unopposed role or unopposed court, and of the 46 matters that I had, I was able to give the orders in 30 of those matters. And 10 of those matters were not accessible on case line and therefore were not heard. And I only removed one matter where there was non-compliance. And in any event, AGP, my view is that where there isn't any non-compliance with the rules and the directives of the court, it is my duty not to grant orders or to make sure that the practitioners obey the rules of the court. So my view is that we must all be prepared to go to court. I should be prepared to go to court, and I do prepare thoroughly before going to court. And the practitioners should come to court prepared. Where their papers are not in order, their matters will be removed from the roll.
Yeah, surely this commission will appreciate that, to deal with accusations wherein there are no specifics. It's a difficult task for a judge to do, especially if there are no formal complaints. You mentioned that you dealt with 46 matters. Were those matters on the roll of one day, the 46 matters?
It was for one day, yes.
And the opposed matters, have you dealt with opposed applications?
Yes, I have, AJP.
I see for 6 weeks opposed applications. How did you handle those matters? Because they are the ones that are also demanding. You find that you are to deal with about 10 or 12 opposed applications in 1 week. both those matters are opposed, so you really need to prepare thoroughly. But what's your experience or, when you dealt with such matters?
Yes, the only solution, AJP, is to make sure that you read ahead of time, make sure that you prepare properly, and in most instances, when you are prepared, when I'm prepared well, I'm able to deliver extempore judgments in matters where uncomplicated matters, and only reserve those judgments where the matters are more complicated.
I also see that for 4 weeks you were in the urgent court.
Yes.
Can you recall how many matters were allocated to you in that week in the urgent court?
In an urgent court on a given week, you may be allocated maybe about 40 or more matters.
Did you manage to handle those matters effectively?
Yes, I was able to do so.
Thank you, Chief Justice.
Premier.
Thanks, Chief Justice. I don't have questions for Judge Maus.
Minister.
Thank you very much, CJ. Good afternoon, Judge Maus.
Good afternoon, Minister.
How are you?
I'm well, thanks.
No, thanks. Looking at your CV, I see highly qualified person in terms of academical qualifications. I looked as well at the feedback who law bodies as well praised your body of work. What I wanted to check with you first, it's the experience of having been in the bench, having been an attorney. What's your experience in terms of access to opportunities by women in the sector? And what would it take for us to be able to see a meaningful contribution of women or even them rising into various positions of responsibility?
Thank you for the question, Minister. I think it's a very important question. It hasn't been very easy for women to get opportunities. But I think what is important that we should do is to make sure that we create opportunities for younger women to be educated and to get proper training, and also to be exposed, and for them to be exposed to the fields that they would be interested in. For example, particularly in law, we must be able to mentor young women and make sure that they understand exactly what the job or our work is all about, and also make sure that they have interest in getting into the labor field. Oh, sorry, not the labor field, the law field. I'm so used to being at the labor court. I feel like I'm a permanent judge there. Like, yeah.
No, thank you. Just a follow-up on that, linking to, I'm looking at, I think it's GCP, making a comment about your personal commitment to the values of the Constitution. And looking at that in terms of work, maybe just to explain, in terms of your contribution, what is it that you think has been your most contribution in access to justice, or just ensuring that we're able to see the values of our Constitution in the country?
My contribution, I think the significant contribution that I've made is being able to be closer to the young ones, being able to lecture, but also to teach at the practical legal training, practical legal school. I think it was, for me, it was most important. What I also have done was to ensure that when I write my judgments, I keep in mind the importance of the Bill of Rights. In short, that it's what I think is significant for me.
Okay, thank you, CJ.
President Rolemel.
Good afternoon, Judge Mahosi.
Good afternoon, President.
How are you?
I'm well, thanks. How are you?
Okay. You mentioned the high workload of the labor court, and I can attest to that because I served as a judge of the labor appeal court for quite some time. So I just want to find how you found the transition from being a judge of the labor court, which is a very busy court, and acting in another busy court, but now being exposed to different branches of the law. Was it easy for you?
I must say that it wasn't that difficult. It was actually easy because as I indicated earlier, and also as you have said, the labor court or the workload there is crazy. So going to the High Court, I found that I was actually ready to be there. I could cope with the work. I think it wasn't difficult. Just to answer the question, it wasn't difficult at all.
This is just a follow-up. I'm just curious. No right or wrong answer as such. So if you were to be appointed as a judge of the High Court, would you in the future perhaps consider being a judge of the Labor Appeal Court?
Definitely.
Or would that door be closed?
No, that door would not be closed.
Thank you, Judge Mahosi. Thank you, CJ.
JP Tlalezi.
Thank you, Chief Justice, and good day, Judge Mahosi.
Good afternoon, JP Tlalezi.
I won't ask you about the labor court. My name is already on the transcript. Just clarification on one aspect. I may have not heard you properly because the acoustics in here are not so good, or we may have used two negatives, which will convey the message that we are conveying differently. Did I hear you to be saying that where there is non-compliance with rules and directives, you do not grant orders? In response to the AJP's question on the comments made by the GCB.
Where there hasn't been any compliance with the rules and the directives, yes, parties are given an opportunity. Their matters are removed from the roll for them to be given an opportunity to comply with the rules.
They are given an opportunity.
Their matters is not dealt with.
Is that not elevating a form of a substance like their comment? I just wanted to understand it.
Let's take in an unopposed role, JP. Rules and directives are there to be complied with. Otherwise, why do we have them? If they're not complied with, and it is required. For example, the practice directive would say that if you have not complied with this particular rule, your matter will not be granted. In that case, I cannot give an indulgence because otherwise then the rules of the court would not be complied with.
given our experience in the labor courts, we've got a myriad of cases driven by unrepresented or self-representing persons. And some are union officials with no good background in the procedures of the courts. Is it not a matter of looking at the issue, deciding that on the basis of the issue before you and the extent of non-compliance and whether that non-compliance will make any difference?
Yes, it is. I agree with you. That is correct.
Thank you.
Professor Marumagai?
Thank you very much, Chief Justice. Good afternoon, Judge Mahosi.
Good afternoon, Commissioner.
I'm interested in the judgment that you wrote that appears on page 86 of your 86. It is the hand paginated 86. I'm not really sure on your bundle, but that would be the case of preference capital versus conveyor and industrial supplies. It was the one where the applicant sought an urgent application brought an urgent application to provisionally wind up another company. I'm not sure, do you remember that case?
I remember the case.
And what the company sought to be liquidated did, they brought an application under section 131, subsection 6 of the Companies Act, which is a business rescue component, presumably to suspend the liquidation proceedings. What I want to understand is, when does section 131, subsection 6 gets to be applied successfully in these kinds of matters? And what do we understand by the word liquidation proceedings? And based on your explanation of what liquidation proceedings refers to, what then is the correct legal position? Can you bring an application to use business rescue to suspend liquidation proceedings even before a provisional order for liquidation has been granted? I'm not sure if my question is clear, or do I need to clarify it?
Maybe clarify your question.
Yes.
And Commissioner, if you may.
In this case, you have company A that brings an application, an urgent application to place another company, company B, under provisional liquidation, right? Then company B brings an application to place itself under business rescue. Then if it places itself under business rescue, that means the business rescue proceedings will then have to suspend the liquidation proceedings. In other words, to allow company B to have a breathing space to try to give the business rescue practitioner a chance to save the company. So what I'm asking is, based on those facts, there is this phrase that is used in the Companies Act, liquidation proceedings. So my question is, can you bring an application to place a company that is subject to liquidation proceedings under business rescue, even before the provisional order of liquidation is granted?
You can only bring that kind of application when there is an application for liquidation.
Because in this judgment, it seems to me that you, in the application for provisional winding up, you leave it aside just a little bit and you focus more on section 131, subsection 6, and ultimately you strike off the urgent application of the role, because it seems that you sustain the application in terms of section 131, subsection 6. I'm not certain that you are wrong. It might be that you are right. It was just a sort of something that I could not understand the reasoning as to why you allowed that.
Yes, remember, Commissioner, when determining the issues, it depends on what is brought before the court.
Yeah, but there's a legal framework that governs the whole thing.
Yes.
Lawyers can bring everything to you. You need to
Yes.
get to the gist of the matter, and that's where I'm trying to get to.
Yes, but perhaps, Commissioner, do you want to take me to the portion of the judgment which you are referring to?
I don't think we have time to really deal with that. I just wanted to deal with it from a conceptual point of view. But I can leave it there. But at least it was something that really came to my mind as to how Section 1316 actually applies when you're dealing with provisional liquidation. But I think we can leave it there. We don't have to monopolize.
Thank you, Commissioner.
Thank you very much, CJ.
Commissioner Gauteng.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
I just want to check earlier, you had responded to the CJ's question about the 4 outstanding judgments. I see that they were reserved in April, and I would just like to know when you handed down these 4 judgments.
I indicated when I completed the form, I indicated that they would be handed out before the beginning of the term. They were handed down after the beginning of the term. So it was in, I don't have the exact date, Commissioner.
Not within the 3 months.
It was after
the 3 months.
After 3 months.
But of course, you are used to a high workload. So I just wanted to understand the reason, perhaps, why those took longer to complete.
I can attribute the delay to quite a number of various reasons, Commissioner. But I do not want to sound like I'm making excuses. I understand the importance of delivering the judgments within 3 months. But the reality is, in some instances, even where you aim to do that, there are instances or there are circumstances which require or which makes it impossible for us to do that, or for me to do that. It can be a complexity of the matter. It can also be the fact that my health, and also the other pressures of the family responsibilities. I don't know if you want the exact reason for this particular judgments.
Yeah, I just wanted to understand why 4 of them have been delayed for so long, because there is a 3-month turnaround time, and if you are comfortable, then yes, I think it's good to understand. I mean, if it's anything to do with resources or any explanation as to why they are delayed for so long, then I think it's important that you tell the Commission.
Yes, I agree, Commissioner. It was the complexity of the matters, but also during that time I fell ill. I must indicate to the Commissioner. Yes.
Thank you, CJ.
Thank you.
That is everyone then. Okay. Thank you very much. Oh, Commissioner, why do you have such bad luck? Okay, go ahead. Sorry.
Thank you, CJ. Good afternoon, Judge Mahosi.
Good afternoon, Commissioner.
I just want to hear your comment in relation to the judgment that you have referred that speaks to NUMSA's case. NUMSA's case and agri-animal feed. I think central to it is the decision of NUMSA to operate outside its scope of metal sector.
Yes.
And the labor court decision to give priority and more protection to the promotion of access to justice and redress to employees, which in a sense informed the court, the labor court, to rule in favor of NUMSA. And now the Concord reversed that decision mainly on the trade union's right to represent its employee and its legal standing. Are you not of the view that in this instance the Concord did not give much more protection to the employees' access to justice and redress as envisaged by the Constitution? Thank you.
Thank you, Commissioner. In that matter, in fact, what happened in that matter is that the Labour Court granted an order. I upheld the point in Limena that was raised by Afri Animal Feeds. And the Labour Appeal Court, I think the judgment that you are referring to is that of the Labour Appeal Court. The Labour Appeal Court then overturned my decision. And the matter went to the Constitutional Court, which agreed with my order.
Which in a sense did not give more protection to the employees' access to justice, but more on the legal standing of NUMSA. No, thank you, Judge Mawusi. Thank you, CJ.
Thank you, Commissioner Mamang. Anyone else? I forgot. All right. We have reached the end of your interview, Judge Mahosi. Thank you for making yourself available, and you are free to go.
Thank you, CJ, and thank you, Commissioners, for this opportunity.
Chief Justice.
How are you?
I am fine, I guess. Thank you.
Okay. I'm fine too. I guess. In my culture, it's customary to extend the courtesy to the other
You're
party
right.
as well.
You're very right. I could be excused under
Under the
the pressure of
circumstances.
the moment.
Indeed,
Sorry
you
for
are excused. You have a long list of academic qualifications, and I'm wondering where you find the time to study all these. You have a Bachelor of Arts degree from the University of Venda and a Bachelor of Laws from the University of Pretoria, two Master of Laws degrees, one in tax law from VETS, the other one in mercantile law with a focus on insolvency and on insolvency law and liquidation law from the University of Pretoria. Then you did a postgrad diploma in forensic and investigative accounting.
Correct.
And you have a Master of Business Leadership from where did you attain
UNISA.
that from? UNISA. And then you did an advanced short course in business rescue practice.
Correct.
With UNISA again, and you are currently registered with UNISA for a Doctor of Laws in mercantile law.
That's correct.
And you are practicing as an attorney since 1 February 1995.
It's 1996.
19
1 May.
Well, I'm looking at. Oh, sorry, you were still doing your articles in 1995. All right. You started at the state attorney's office.
State attorney was just when I was about to be admitted.
Mm-hmm.
My articles were somewhere else. One firm in Johannesburg, and then I ceded to Pretoria.
Mm-hmm. So you didn't stay long with the state attorney. You became a professional assistant at Matlala Incorporated, and then changed law firms, and then had your own by 1998 in partnership with other parties.
That's correct, yes.
Right. And you are still practicing as an attorney now.
I am still practicing.
You have acted in the High Court. This particular one to which you are applying, not so.
Excuse me, I didn't get that.
You have acted as a judge in the High Court.
Yes, I have.
In the Gauteng division, in both seats of the Gauteng division.
Yeah, both the Johannesburg and Pretoria.
All right. You mentioned 98 weeks. Is that the extent of your acting experience as a judge?
That number wasn't entirely correct. I should apologize. It was actually 97.
97.
As at the time of making or submitting the application.
Mm-hmm. Have you acted since?
Yes. The total now is 105.
105. In that time, in which courts have you sat?
I've sat in most of the courts. The one that comes to mind where I haven't sat is the criminal court.
Mm.
I've only done criminal appeals and bail appeals.
All right.
Then I haven't also sat in the tax court, although I had the benefit towards the end of last year of a special motion involving tax law, that is the commissioner and other parties.
In how many criminal appeals have you sat?
Criminal appeals?
Yes.
May I refer, Madam Chief Justice?
Sure.
Someone might have think that. The criminal appeals is 44.
Oh, that's a significant number. Full bench and full court?
Yes, very few full court. I think full court appeals, I could say less than 5.
Have you written any judgments in those matters?
Yes, I have, mostly in the full bench ones. In the full court appeals, I had the benefit of writing what was initially a minority judgment, but at least upheld at the SCA level. But when I wrote the judgment initially, I had meant to just share my views with the other judges because at the prima facie level before we could decide, I had a different view. And then I said in the area of criminal law, I wasn't familiar with the principles. I better write and they see where I'm getting that conclusion. Maybe if they see the path that I traveled to reach the conclusion that I was at, they might maybe see things my way. But then, obviously, there were the 2 other judges wrote in concurrence what became the majority judgment.
Mm-hmm. And you say you upheld in the appellate court?
Yes, I was.
Must have felt good.
Yes, but the only sad part is that it involved 5 accused and only, I think, 3 or 2 took the matter on appeal to the SCA and they were released ultimately. I followed up with the legal aid board but obviously I couldn't keep on following up as to what is happening with the others.
With the others?
Yeah, they assured me that there are processes, but I don't know what happened.
All right. One hopes that they would have been informed about this so that they enjoy the benefit as well. Okay. How many judgments in all have you written?
My total judgments, if I may refer again, Madam Chief Justice, it's 185.
185. Have any of them been reported?
Very few. 2 of them have been reported, save for that minority judgment at the full court level. But mine alone is only 2.
Okay. Your description of your practice does not seem to include any criminal work.
Yes, that's true.
You have not done criminal work.
I had only done it in the earlier years. Okay, when I did my articles, yes, it was there. And when I started practice, it was there. And initially, the legal aid board could involve practitioners directly, and then, but obviously I can't blame the legal aid board. I think I switched focus to aspects that were not to do with criminal.
You listed a number of reserved judgments in your questionnaire, some dating back to March 3, 2. What has been the fate of those judgments?
They've been delivered, all of them.
All right. You list a few bodies in which you have been involved as part of your involvement in the wider community. You've been an instructor at led law schools since 2000.
That's correct.
And you say you've conducted seminars, webinars, and addressed conferences.
Yes, that's correct.
In which areas of the law?
Mainly in, I would say, company law, and then insolvency and liquidation law. Then, but with the law schools as well, there's been mainly insolvency law.
All right. And you also state that you've written, well, you've had a few articles in non-peer reviewed journals, published journals and newsletters. Was that also on insolvency law?
Insolvency law, and I think, if I may refer, there were a few others in other aspects of law. But as I've emphasized, that was non-peer reviewed journals. Madam Chief Justice, I can refer to page 25.
We've just been asked to stop the proceedings for a minute just to make sure that the recording equipment is back on. Can we continue? Oh, we were still talking about your published articles.
Yes, I was on page 25 with the, or 24 with the hand marked when I was saying there is one on Social and Ethics Committee, which is company law, and then another one company law, and then insolvency.
Yes.
But those are, and then the conferences, those are not your, what I can call serious journal articles. It's commentary more or less.
All right. And you also train candidate attorneys and junior attorneys, and do you teach, or what do you do at law schools around the Gauteng province for the law society?
It's teaching.
It's teaching.
Yes, it's teaching.
All right.
It's okay, but maybe the correct reference, they say tutoring, but all school we can say teaching.
All right. Thank you, Mr. Manamela. I'll hand over to AJP Ledwaba to put questions to you if he has any.
Thank you, Chief Justice. Mr. Manamela, let me take this opportunity to also thank you for almost always availing yourself when I called you to come and assist, with acting when one of my judges would be booked off for health reasons.
Now, thank you for the opportunity, acting EJP, sorry.
I see that you've been acting since 2013, or almost every year. Actually, every year you did act in the Gauteng High Court.
That's correct.
And the number of matters you've set in, they speak for themselves. You have also indicated that it's only the criminal court and the tax court that you have not set in. Let me know, have you applied to be appointed as a judge before?
No, this is my first time.
But why did you wait for so long? It's more than 10 years.
I think mainly I was afraid of this chair I'm sitting on now. But other than that, it was mainly to do with family. My children were still small. So there was that need for time to be there in their activities. That's why if one looks at the number of stints, they start increasing when they were often mature age and getting out of high school. But more or less, it was also some level of indecision to make the final commitment. But now I'm here, and I think I am ready to make a contribution.
And even earlier, the leadership of the court, the JP, did encourage you, and I also encourage you that you should avail yourself.
Yes, yes, you did throughout, yes.
Okay.
Thank you for that.
Maybe since you indicated that you've never been in a criminal court, you said that in practice you did that work. During your acting stints, did you also have an opportunity to deal with petitions, criminal petitions,
Yes,
automatic reviews?
Yes, I think it's, I can't remember how regular they do come, but I think every stint there will be one or two petitions and the automatic reviews.
And how was your experience in being in the urgent court, being the busy one where you are expected to deliver judgment as soon as possible because of the urgencies of the matter? I see you've been in the urgent court for 6 weeks.
Yes, quite challenging because you don't have the benefit of time, as you mentioned. You have to decide on things when you're required to. But what is more helping is the resources around. I find that at the beginning I was able to confer, that is in the earlier years, with the senior colleagues. But obviously, that time, as time went by, I obviously used less and less of them. I'm referring to things of, how do you, if I can give an example of you get into an agent court where the matter was not necessarily enrolled, but it comes through right there. It gets daunting because you haven't even gone through the papers, and then now you are supposed to deal with the issues. And then earlier, in earlier days of my stint, I felt pressure that I had to deal with the mess if there was no sort of interruption, because I'm saying to myself, the parties are looking for the same way of their matter being adjudicated upon like any other party. But then you get to realize that no, it is something where you can manage your own role as to when you're going to hear which matter, as long as that is convenient to the parties, including the legal representatives, and also that it doesn't obviously affect the nature of the harm that has been avoided or contemplated.
At your law firm, do you have partners, PAs?
Yes, but at the moment we are very thinly staffed. We are only 3 lawyers, but it goes with the level of work or the amount of work that we have. So I do have a partner and a PA who is a quasi-partner.
I'm trying to put you in a corner. Should this commission recommend that you be appointed, how soon can you start?
I think I've been spending more days acting JP at the court more than the practice. So to answer directly, I don't think they will miss me that much. My involvement has been less and less over the years. And some of it not by choice, but mainly because I was at the High Court most of the time. So I should be able to start as soon as I'm required.
Thank you, Chief Justice.
Premier.
Thanks, Chief Justice. I'm fully covered. Thank you.
Minister.
Thank you very much, CJ. Good afternoon, Mr. Manaman.
Good afternoon, Minister.
Question on your questions, question 3. You highlighted that you were previously found guilty by a professional body in terms of your submissions, that you made late submissions in 2004. What was the reason for the late submissions?
I guess I can just say I didn't do what was expected of me by the rules, which was regrettable. There were issues that led to that. At the beginning of the year, I had the unfortunate issue of separate. I was in a two-partner firm or two-director firm at the time. So beginning of that year, there was a separation. I even had to go to court to get a court order, which didn't really help. Thereafter, we pursued mediation that helped. So that affected the auditors and bookkeepers accessing material for purposes of drafting or helping me comply with the rules. But obviously, I was supposed to manage all that and ensure that what was supposed to happen should happen on time, but it didn't. I learned my lesson, and I even went as far as augmenting my management skills, even academically, as the Chief Justice alluded to, with some qualification in management. Because I felt that although it's an administrative issue, I could have handled it a little bit far more better to avoid the transgression. The transgression has helped me over the years to know how easy it is to find yourself on the wrong side of the rules, and I've used that in my training of candidate attorneys and even at the law school. And so far, I've managed for 21 years to avoid a repeat. But that doesn't excuse the fact that there is that blemish on the record.
Thank you. My last question is on the issue. I looked at your CV. I think it's one of the commendable ones, as CJ has said, in terms of your achievements, looking at the areas of your work, both in terms of commercial law and also forensic and investigation areas, which is something that is quite rare, especially for Black practitioners. What are your, I want to ask in terms of transformation of our sector and many of others areas, because we hardly find majority of the people, especially Black professionals or previously disadvantaged individuals in these areas, specializing or being able to get, what can be done to have more into this? Is this the area, one of the areas that you are seeing, you are training in? Perhaps if you can share with us.
Just help.
Should I continue?
Issue. Yeah.
Honorable Minister, you were done with the question.
I'm not so sure if you got my question, but it was more around looking at your profile, your qualification in areas that when we look at previously disadvantaged individuals, you hardly find. And I made reference because if you look at both in terms of commercial law, the issues of forensic and investigation, you've done qualifications in that. So I was just listing that, but more so saying whether this is an area, I think, let me just go, mercantile law as well, insolvency, liquidation, and also a qualification, yeah, in forensic and investigation accounting. This, as I said, these are skills that you hardly find. And one of the issues as we deal with issues of transformation, making sure that previously disadvantaged individuals are able to find space in the areas that are not really. What you think should be done in order to make sure that there's more of you, perhaps I can use it that way, there's more of individuals having access to this specialized areas, but two, is this one of the areas that you are training? And maybe just as I could, because I'm not gonna come back, I was sharing with CJ, I could recognize your name because acting Judge President is one of the names that I remember quite regularly, as you say, am I Corin, your sentiments of him availing himself to act. And most of the time it's actually pro bono or in the work that he does. So I thought I must acknowledge it's very rare to remember names as you sign because it's quite a lot of bundles, but this one I particularly remembered.
Okay, thank you, Minister. I think the challenge has been that you can obviously have the qualifications, the academic qualifications. You still obviously, as the Minister mentioned, you need to get to apply them to get the opportunities. But with the question coming from the Minister, I could say, obviously, matters of budget permitting, you could have the state attorney, for example, being expanded and being, to some extent, being capacitated to offer services, which will require, obviously, a statutory amendment, to organs of state, which are the entities that generate a substantial amount of commercial work. The reason why I'm saying state attorney, and I'm looking into, at the beginning, obviously, the young practitioners coming in, especially from previously disadvantaged background, they need to come in at the level where there's a lesser risk. Maybe state attorney offering employment, that could be there where they get engaged, and while getting experience into commercial law, they also, to a point, get their financial needs met. The other way is to, I think the Solicitor General is there for that purpose, to coordinate procurement from even organs of state, to ensure that that is, the implementation that is there is fully improved, to expose people to the areas of law. The areas of law that are typically commercial law. And the other one is obviously our burden as practitioners to take along candidate attorneys and paralegals in training. I hope that has answered you, Minister. Thank you.
Professor?
Thank you very much, CJ. Good afternoon, Mr. Amanamela.
Good afternoon, Prof.
I'm not sure if we will do justice to your CV if we don't talk about the foundation that you and your colleagues have laid in the company's tribunal, where the current members of that tribunal are enjoying the expertise that you laid in that tribunal. I just want to know, in your view,
thank you.
In your view, do you think that the jurisdiction of that tribunal is restricted and that hamstrings it from actually contributing more to the development of company law in South Africa?
Yes, I think I fully agree with that. I think it is restricted. I can start on a competitive level, like the competition tribunal, which is one of the tribunals that I think is lauded, and I think the record is there to say that with its mandate and level of activities, it has been able to deal with matters relating to competition law fully. With the companies tribunal, the challenge is only very restricted to particular areas of the Companies Act, or the provisions in the Companies Act that are within the jurisdiction of the Companies Tribunal. So if we were to find a way of broadening that scope or jurisdiction, then I think it could, in a way, be able to offer make a contribution that it should really make. Although when I was there, and I think there is an amendment, or there was an amendment that has been mooted to say maybe there is in the area of mediation. That's where the Companies Tribunal could be kept busy, so to speak. But the problem there was that it's voluntary mediation, and we all know what happens, especially where you have parties who come before the tribunal without the equality of arms in the sense of finances. Some can afford to just bypass that and go to court. So I can conclude by saying the Companies Tribunal, the contribution could be far more greater if the mandate is statutorily increased.
There's also discussion about arbitration as well. I just want to take you to a judgment that you wrote, Hermanas NO versus Ledwaba. I think it is the very first that appears on your bundle. It's in page 27 of your. You did not go to it because I just want to deal with some of the things that are coming from it. In this case, it is a sequestration application, and you deal with sections 8, 9, and 12 of the Insolvency Act. And what I saw, and it's a brilliant judgment in so many levels. But what I want to ask you about is the state of insolvency law in South Africa, where sequestration appears now to have been used as a debt collection mechanism, contrary to what the Insolvency Act intends it to be. In other words, if anyone owes you something, apart from taking them to court, you might as well try to create an act of insolvency so that you can take them to court. What would be your view with regards to understanding this aspect of the advantage to creditors requirement, this aspect of reason to believe? I'm not sure if you have thought about it.
Yes.
Because a lot of emphasis is placed on advantage to creditors. But this aspect of reason to believe, we seldom see it being interpreted and being dealt with by the court. I'm not sure if you have dealt with. I know that you are an insolvency law person, that's why I'm burdening you with this question.
Yes, no, thank you. The reason to believe requirement, obviously in its full extent, is that there's reason to believe that sequestration will be to the advantage of creditors, which is obviously features in compulsory sequestration. And then, obviously, I think you're putting emphasis on it because involuntary surrenders is a direct requirement that there will be advantage to creditors. The primary reason for that is that in compulsory sequestration, the creditor will not be that much aware of the financial circumstances, the nitty-gritties of the assets and liabilities of the debtor. And therefore, it can only convince the court, obviously on a balance of probabilities at the final stage, by way of bringing the facts through which the court could conclude that there will be advantage to creditors, or there's reason to believe that sequestration will be advantage to creditors. So I'm thinking the primary reason for a roundabout test, if I can call it that, was to contrast it with a voluntary surrender where the person who is the debtor, who knows his or her financial affairs, could attest to whether there will be advantage to creditors or not. Whereas with the other, one not sitting at arm's length won't be able to do that.
No, that's correct. Thank you very much, CJ.
Commissioner Toro Shlepu?
Thank you, CJ. Good afternoon.
Good afternoon, Commissioner.
CJ, I think Prof. Marumohai took my questions. I wanted to highlight how modest Mr. Manamela is. He has written a lot on company disputes, and we are still referring to his cases. Thanks.
And I was just thinking that I've never heard Professor Marumohai compliment anyone's judgment before. And here he is throwing words around like brilliant and... Yeah. Commissioner Mangen.
Thank you, CJ. Good afternoon, Mshalo. Let me add my words to the good work that you have done.
Thank you.
In the space of the insolvency law. This year, the Gauteng division of the High Court ran a pilot project in the insolvency court. Did you have an opportunity to sit in that court?
No, not yet. When I was about to, I think it started is it in the second term, I think, of 2025 in Johannesburg?
Yes.
Yes, that's, I did a first term, full term in Johannesburg, but then I missed it and I thought it should be pushy to say I want to act in that court. I thought the time will come. I may have thought wrong, but I'm hopeful.
Given the fact that it's a pilot project, and I note from your CV that you were once the chairperson and the general secretary of the Association of Black Insolvency Practitioners. Do you see it as a welcome development, or will it continue to create an exclusive court for white practitioners who, in the main, specialize in insolvency law?
Yes, it will. The normal approach is business as usual. People are motivated by outcomes, financial ones mostly. Unless, and again, it's going to have to be through a rule. The one that has got more force will be if we could find a way of making a statutory requirement. But to come directly to the question, the issue of opening up some other sectors of our industry is possible, but it's just that sometimes we get busy to overlook, and we overlook it. For example, the state organs or state SOCs, state-owned companies, they've got a way of equipping black practitioners or previously disadvantaged individuals. And I think, obviously, if that platform is used, it could create a pool of people who are in some areas of law, including insolvency. But with regard to the court itself, I guess the focus now is still to get the systems on the ground, apply them and see if they're working. It's going to be more into whether the court can run efficiently, for example, alleviate the congested roles in our courts, and also primarily because, and I think everybody will say this with regard to every aspect of law, insolvency law matters are also urgent. And the one that I didn't want to start on is people will talk about expertise. To say that you need in those courts people with particular expertise. I think is exposure. Even with a degree, if you don't get an opportunity, it becomes useless because you don't apply. So sometimes you don't even need a degree if you get an opportunity. So yes, it will for a while operate as an exclusively probably white court, or mostly predominantly white. And because probably in those areas that those are the practitioners that are involved. But as soon as it gets going, just like other areas of our law, there will be, I can use the word infiltration from previously disadvantaged individuals. I don't know, I see on your face, I don't know whether I've answered you, but that's my attempt at your question.
No, I'm fine. I'm fine, CJ. I can let it pass. The HHP got the gist of the question. It's going to be important to see who is presiding in that court, but also who is appearing in that court.
Yes, I didn't talk about who's presiding.
Sure.
I think I spoke about who's appearing. Because I'm still at the appearance level, not the presiding level.
Fair enough. Thanks, Chief Justice.
Anyone else? All right. Thank you very much, Mr. Manamela. It was a pleasure interviewing you. You are excused.
Thank you, Chief Justice, for the opportunity. Thank you all to all commissioners.
Miss Mazibuko. How are you?
Good afternoon, Chief Justice and the Commission. I am trying to be settled.
May we start?
Yes.
Okay. What academic qualifications do you have?
I have a BProc degree. I am busy with my master's in banking law. And I've also enrolled for a program. It's called postgraduate for academic writing. Yes.
So the masters and this other certificate are not yet in your pocket?
No, not yet.
We can't talk about them?
No, we can't.
Okay. A huge chunk of your working life has been spent at Legal Aid South Africa?
Yes.
According to your application form, you did your articles with them?
Yes.
In 1996 to 1997, then worked for a brief spell at Mthembu Attorneys,
Yes.
then returned to Legal
Yes.
Aid Board. In 2000, you were there until 2014?
2014, that's correct.
And by then you had worked your way up to executive.
Yes.
And you decided to open your own practice.
Yes,
All
2014.
right, in April 2014.
That's correct.
And that's where you still are to date.
Yes, Chief Justice.
All right. You've also acted as a magistrate.
Yes, there was 2014 until 2015, somewhere about
Was that
9
a
months.
continuous appointment?
No, they kept on, I think you get 3 months, then sometimes they don't, then they call you again. Yes. But it was for 9 months only.
9 months. All right. And you've acted as a judge intermittently since 2021.
That's correct, Chief Justice.
In which division?
Gauteng division and the Mpumalanga division.
In Gauteng, in both seats?
Yes, both Johannesburg and Pretoria.
Okay. So how long have you acted as a judge?
I calculated for about, but I know I put together the in 4 weeks, and it made 19 months, 19.5 months. If that is if we agree that every month has 4 weeks, I meant to say.
All right.
So it's 19.5.
Okay. And you have written judgments during these acting stints?
I did, Chief Justice.
In which areas of the law?
In different areas, civil trials. I've written on BILIT, road accident fund, administrative law. I've also written on credit law, insolvency. I'm struggling to remember all of them.
The usual range.
The usual range, and also on bail appeal and criminal appeals, full court appeal matters, and also civil matters where maybe it's only 2 judges that are sitting.
You've presided in the civil court?
Yes, I have.
In a civil trial?
Yes, civil trials, yes, and opposed motions.
Have you presided in a criminal trial?
No, I haven't.
Did you appear in court when you were at the Legal Aid Board? Well, you still are there. Has your work there, your job description included appearing in court?
When, Chief Justice, I missed that, the first part of your question.
At the Legal Aid Board, have you appeared in court? Did
Yes,
your duties include that?
Yes, throughout, even when we're Justice Center Executive, I was still required to do 1 or 2 matters. So I've I've been in court throughout.
All right.
Yes.
Did that include appearing in the criminal court?
Yes, a lot.
And when you were acting as a magistrate, you
Also-
probably sat in the criminal court, not so?
I did.
Okay. How many judgments would you say you've written?
I've written about 91 judgments, but I've realized that whilst I was preparing that, I did not include most of the leave to appeal judgments. But for trials or opposed motions, it's about 91.
Have any of them been reported?
One was reported. I wrote it this year.
All right. What was that about?
It was on National Credit Act, about Section 103, whether the debt review, when a consumer enters into debt review arrangement, does that stop the incurring of the interest, or is there another default, or he remains in default on the original credit agreement?
And what did you find?
I find that no, it doesn't. It's only one default. When the consumer defaults on the original credit agreement, when they default on the debt review arrangement, it cannot be said that that's a second default or something. So that was my finding. But we're sitting, the three of us, in that matter. It was a special motion.
But you wrote the judgment?
Yes, I did write the judgment.
Okay. You are a member of SAULA, among other professional bodies. And you sat in its executive. Well, when did you serve in its executive?
I didn't serve on the executive of SAULA, but on the provincial. I'm currently a secretary in the provincial, in a committee, not the provincial. Yes, in those subcommittees.
Okay. And what does SAULA do these days? What value are you to society?
Chief Justice, we are SAULA, rather, but I'm a member of SAULA. SAULA, we are the interest is on women lawyers, to ensure that they are supported and that and try to redress, to correct the previous historical background that women, you don't find them mainly in court, or even if they start practice on the way they live. And also the other thing is, when one rises, it's expected. It's actually our motto that we rise, all of us, you carry others with when you are rising. So it's not a matter of we are on top alone, then the others, they are not. You go down and pick them up because they are a support system as sisters.
All right. All right. I'm going to hand over to Acting Judge President Letoba to put questions to you.
Thank you, Chief Justice. Good afternoon, Ms. Mazibuko.
Good afternoon, Acting Judge President.
Surely you have seen the comments made by various organizations.
Yes, I have.
Can we start? You know that there's an objection by one Mr. Pesi Sukoto.
That's correct.
Yeah, what's your comment or your response to the objection?
AJP, my response rather is that I think Mr. Sikhoto is making a mistake. I was not representing him. He was a witness in a matter that I was involved where it was a murder matter. So he was one of the witnesses. And he complains in his objection, he raises the point that the defense team failed to file papers on leave to appeal. The papers were filed, and the matter was postponed, I think in October or November last year, 2024, for sentencing in this year in January or February. So that occurred, and the leave to appeal was granted. And as we speak, the sentenced people, they are on bail pending they are on bail pending their appeal.
On your schedule, you also state that you held special trials. Those are the trials that last for 2 weeks or more.
That's correct.
Yeah, the special trials that you had, did they last for the entire period? So the special trials is for 6 weeks that you had the special trials.
That's correct.
Okay. And, if I can remind you, you also applied to be admitted to the training of aspirant women judges,
That's
and you
correct.
were not successful.
That's correct.
You know why were you not successful?
I'm not sure if I can share my suspicions why I was not. I didn't get a response, but
No.
but I can indicate that if you allow me, AJP.
Yes.
I think the panel found that I don't necessarily need same due to the fact that I've been acting for some time. And I'm saying that with
You are spot on. You are spot on.
Okay, thank you.
Yeah. Because the panel felt that you have the necessary experience and we should give opportunity to other women.
Thank you.
Are you ready for the new job that you've applied for?
Yes, I am ready. AJP, I've taken time. You would realize that I started acting in 2021. And I think in 2023, beginning of the year, I didn't make myself available when I was called. That was for me to reflect and see if this is what I want. And that was after I have done a full term in 2023, I think. The first term of 2023. I hope I'm not making a mistake. So then I reflected, and when I started again in 2023, I think third or fourth term, and continued and had another opportunity of doing a full term this year. So I realized that I think that gave me confidence, that and also an assurance that this is what I want.
In Mpumalanga, you acted for how many weeks?
I think it's 16 weeks.
16 weeks.
Yes.
And your firm, do you have partners, PAs?
I have 2 PAs and 2 candidate attorneys. I don't have a partner. Yes.
Should this commission recommend you to be appointed? How soon can you start? We are now in October.
Yeah, I see it's already mid-October. Now I don't want to say December because then I'm not sure what happens. I do know that there's matters in December, but January will be fair for both my clients and the practice, and so that I don't carry baggage into this new job.
Thank you, Chief Justice.
Thanks, Chief Justice Sawana Mamazu.
Yeah,
Are you well?
I am well, Premier. Thank you.
Thank you so much. I'm trying to make a follow-up from the question that was raised by the Chief Justice about the master's degree.
Yes.
I thought you said your interest is is in the banking industry, banking law.
That's banking law, yes.
And as such, you have enrolled for a Master of Law in Banking program.
Yes.
And therefore, I couldn't understand when you said you are not keen to enter that space of studying for a master's degree.
I think it was, I understood the Chief Justice to be saying that we cannot say that because it's not yet in my bag. I don't have it as yet, but I am interested in the banking law. And I will tell you why. When I did this matter that I've referred to, the one on the National Credit Act, I was even more thrilled I could not wait because I think it's a matter of curiosity for me.
And when the acting JP was raising the issue of the objection from your former client, I thought you'll go at length to assure that the accusation tabled are not justified. It sounded that you were very dismissive as well of the objection.
I can go in length. I had responded. I had thought perhaps I should not bore the commission with details, but I can. I have written, and I remember in that response of mine, I did apologize because I was going to be a little bit lengthy. But I do have the response. I'm more than ready to actually take the commission into confidence.
There's been doubt of your readiness to take this responsibility. So which area of the bench you think you add value if you are appointed?
Premier, if you look at my career path for the past years since I've started practicing, it's more on people. And you would see what I got exposed to even before when I was at legal aid. All my life it has been the law going to the people and that they be educated, because most of the things is because in courts, sometimes the environment is intimidating, whereas if people are educated in some of the areas, for instance, on credit law, you know, what does it mean when you've entered a credit agreement? What are the implications? Do you really need to, or is it because it is available? So that's the education that people need. So I'm more, and I understand where people are coming from. And also my background, I've lived in the village, I've lived in the township, what you like, and I've lived in suburbs. So I know, I'm just a basic person. I know where African people are coming from and what they are struggling. And I'm also able to relate with some of the problems, the injustices that are there. And now as a lawyer, I am able to read the Constitution and see that this problem is, and see that justice is done in a matter. So it's not only the education and the sophistication, but it's also the practical and the person who has the knowledge and the background of who've tasted life in the village, in the suburb and in the other areas. So I think that's what I'm bringing. And also the knowledge, my exposure when it comes to law itself, and the leadership also, and the passion that I have for this. When the AJP was asking me, I've taken time to reflect. Do I really want this, or is just a glamorous job, or what? Thank you, President.
Thanks so much, Teacher.
Commissioner Hassan?
Thank you very much, CJ. I just want to clarify something, Advocate over here, Commissioner Hassan. If I'm correct, the GCB did talk about some limited exposure to litigation and that you've only been dealing with RAF matters. How would you respond to the GCB's concern?
Thank you, Commissioner, for that question. I think they raise a concern that I've written judgments on RAF mostly. It's not correct, Commission. Out of the 91 judgments that I've written on different areas of law. I am not sure why they were not able to access same.
Could you maybe just mention those areas for us to make a note of?
I think the one area that they had a concern on was the area of family law. I have written on family law. I have written on corporate law. I have written on administrative law, and many other judgments on procedural law. And I had an occasion where I have written a judgment where I was asked to develop the common law. I think that was my second case in 2021 that I've written on a judgment. I've written on insolvency law. They're just escaping me now, those areas.
Okay, and then just to clarify, have you written any judgments related to any constitutional law? Because I think you've covered some of their concerns. I think the only thing then that would be outstanding is constitutional matters.
I think I can say yes. One of the judgments that I submitted, it was on constitutional rights of the applicants. That is the AfriForum matter. Where I dealt with the structural interdict. So there's a lot of constitutional law rather in that. Also with the National Credit Act matter, it also involves the constitution because you need to interpret, well, at least that's what I did. I had to interpret the National Credit Act, aligning myself, or rather inconsistent with the constitution and looking at the historical background of the consumer industry.
Thank you, CJ.
Thank you.
Professor?
Thank you, CJ. Good morning, good afternoon, Ms. Mazibuko.
Good afternoon, Commissioner.
Can I please take you to the case that you have been referring us to? This is Court versus National Credit Regulator.
Yes, I might need to.
I just lost. It is in paginated page 69 of your bundle. The typed page 26 and the handwritten pagination page 69.
Okay, it's the 69 on the bottom.
Yeah, yes, they are all on. Yeah, the one at the bottom.
Yeah, yes.
That's where it is, but nonetheless, it doesn't really matter if you don't get it.
No, I'm here. I found it.
In that case, as I understand it, and correct me if I'm wrong, in the main, you are dealing with the in duplum rule.
That's correct.
As it is understood under the National Credit Act.
Yes, from the common law, yes.
And that's where I want to get in because that's the confusion that I got. Whether the case was premised on the statutory in duplum rule or on the common law in duplum rule because the two are different and they are couched different. And I couldn't quite understand from the reasoning as to which formation of the rule you are actually applying. But not only that, there is a constitutional court case of Paulse versus Slipknot that gives us the parameters of how the in duplum rule should be applicable. And it doesn't seem like it is referred to in your judgment. I'm not sure if you you were aware of it at the time when you were writing the judgment, but I'm more interested in the first part of the question.
If you look at the first, I think the first three paragraphs of the judgments, they speak to what exactly the parties came to court for. It was not necessarily on the in duplum rule. But I do mention in the judgment that the in duplum rule is originating from the common law. But here it was within the act. So it's a statutory one.
I get that, but the thing is, at the end of the day, if you are going to determine that there is a principal capital amount, and from that principal capital amount, there will be an interest on it, and that interest should not be more than the principal amount. Now, the question would be, in terms of the relief that you are going to pay, that you are going to give, are you relying exclusively on statute, or are you relying on the common law? And that's why I'm bringing in the Constitutional Court judgment as a guidance, as precedent to guide you on the right approach. So I'm asking whether you and your fellow judges were not aware of the precedent of the Constitutional Court at the time.
I think I get your point. I think our focus was on because remember they picked on the section of section 103. So I think our focus, we wanted to zoom in there. But I do get the point that perhaps we should have also embraced that guidance.
Yeah, because this is important, right?
Yes, no. I fully,
Thank you very much, Chief Justice.
Commissioner Shabangumdao.
CJ, let it pass.
Commissioner Ngaito.
Good afternoon, Ms. Mazibuko.
Good afternoon, Commissioner.
Just on the objection by Mr. Scott, it's made in respect of your application and that of your senior counsel. I think in that case it was Advocate Mohale Makinta, is that correct?
Allow me to correct this. No. Mohale Makinta was also representing
another
two
group
other
of,
clients.
yeah.
I was representing two others.
I think it's 6 and 7 that you were
6 and 11.
6 and 11 that you were acting for, but you were on the same side.
Yes, we're in defense.
Yes. I must confess that I understood what was going on in this case for the first time when I read your response.
Yes.
This S versus Mlambo is the case.
That's correct.
Yes, and your response was actually well written.
Thank you, Commissioner.
And the other judgment you wrote was a judgment about the removal of a child from the father to the mother who was going to Ireland.
Yes, I think it was in Johannesburg.
Johannesburg, yeah. That's also a well-written judgment.
Thank you, Commissioner.
Yeah. Thank you, Chief Justice.
Thank you, Commissioner Ngaitobi. I thought you were going to pose questions. Well, it appears that there are no questions for any further questions for this candidate. On that happy note, Ms. Mazibuko, I think we should release you.
I thank you, Chief Justice.
Thank you very much. You're
And the
excused.
Commission. Thank you.
Okay, Advocate Bugale Makinta.
Yes, I'm ready. I'm ready, CJ.
Good afternoon.
I'm good, and how are you, CJ?
I'm fine, thank you.
Thank you.
When were you born?
I'm sorry, I saw that it was a typo on my questionnaire. I was born 28th of October, 1973.
73,
Yes.
okay. And you are an alumnus of the University of the North and the Star University, from which you obtained BProc and LLB degrees.
BProc in the University of the North, LLB, the University of, by then it was called Vista University, yes.
All right. But then you obtained your LLB in the latter years.
Yes. Yes.
What made you decide to further your studies
Actually, I was a
at mature age?
I was a prosecutor by then. Then I wanted to be a senior state advocate. So that's why, for me to qualify as a state advocate, actually, I had to obtain an LLB degree. So while working,
While you're working and raising 3 children, you're also studying.
Yes, yes.
Yeah, life of a woman. You have long experience at the NPA. You were a prosecutor initially, then you were promoted to state advocate and became senior state advocate. So between 1998 and 2007, you rose to the top of that ladder. And then you became a magistrate for 3 years.
Yes.
From
yes,
2007, only in an acting capacity.
Correct, CJ.
Why did you not go for permanent appointment?
I think I was ambitious.
You wanted something else.
Yes, I wanted something else. Yeah.
So you decided to join the bar.
Yes. I
Which
decided
one?
to Standard Bank Association of Advocates in Pretoria. Yes.
Never heard of that one.
The likes of Judge Musupa, Judge Bahlani.
Yeah, I see.
Yeah.
But I didn't know. All right, that's well. Back in my day, there were only so few. In Johannesburg, there was only Shriner and Ines Chambers. That was it. And today, there's been a whole proliferation across the city. So from 2011 until now, you've been practicing as an advocate.
Correct, CJ.
And what kind of practice do you run? What kind of work do you do?
General work, CJ. And I like to mention that as an advocate, I never received any work from state attorney, no private sector. So the bulk of my work was from Legal Aid South Africa, primarily criminal matters, divorces, family law, and land claim matters, and other instructions from private practitioners briefing me on various field of law.
Is
And
that still the case?
yes, even now, I haven't received, even after acquiring Silk, I've never received any work from
our government?
No, never.
That's a terrible indictment.
Yes, and I try to knock all the doors requesting for work, but I never received one. But I'm grateful for what Legal Aid did for me, because with their work, it enabled me to secure a suitable home and education for my children. It exposed me to the high-profile matters in the criminal court, in the High Court, and that exposure led the former Judge President of Gauteng to consider me for acting appointment. And the same exposure, Chief Justice, together with the mentorship programs that I am conducting and pro bono work, my peers actually recommended me for senior status.
Yes.
So actually, I'm grateful for what Legal Aid South Africa did for me. But now, unfortunately, now since acquiring Silk, the situation has changed actually since February 2024, because by then, before last year, February, legal aid was already allocating complex matters for me because of my experience and my exposure. So the tariffs were categorized as under increased fees. Now we know that legal aid doesn't cater, the tariffs doesn't cater for senior counsels, and now even the work, I'll have to wait for more complex work. So it's a challenge in my profession, and I can't wait for legal sector code actually, to be implemented, because I believe that the code is the only structure which will make sure that all practitioners are getting equal work, and in that respect, junior advocates, junior silk like myself will be able to appoint juniors and will be able to train more people.
When did you take Silk?
February 2024.
All right. So you have acted as a judge in which division or divisions?
I've acted in Gauteng division, both Johannesburg and Pretoria, and 5 weeks in Limpopo.
In Limpopo.
Yes, Chief Justice.
And have you managed to sit in all the courts?
Yes, in Gauteng, the only court that I haven't sat in, I think, is tax law and special motion court. That's the only one.
All right. And how many weeks or terms?
90.
You say 5 in Limpopo, and how many in Gauteng?
I think it's 90, all in total is 98. 98 terms, 5 in Limpopo. Yeah.
You've had a lot of time to produce many good judgments.
83.
83.
Yes,
Okay.
CJ.
Any of them reported?
3 of them reported.
Okay. In what areas of the law?
2 criminal,
Diverse.
2 criminal law, 1 company law.
The reported ones.
But yes, the reported ones, yes.
You say 2 criminal and?
2 criminal laws and 1 company.
All right. And the rest on the diverse range?
Yes, yes, yes. CJ.
Okay. You mentioned that you suffer from brain fog since legacy of COVID-19.
Yes.
How do you cope with that?
Actually,
this is one job where you can't afford to lose your concentration for 1 second.
Yes, I agree, Chief Justice. Actually, I wanted to inform the Commission. I know I've already indicated that on the questionnaire and a follow-up response, but for the public, I believe that they will want to know what happened to me during my interview in 2021. First of all, CJ, I would like to mention that I was invited to apply for the position by the then former JP of Gauteng, and the invitation came after he was impressed by my extensive legal experience, independence of mind, and sound judgment, and he considered those qualities suited for a judicial appointment. That is why he approached me to apply for a permanent position. And what I can say, CJ, that is that during my interview, I was going through some health challenges, and at that time, my brain was working against me. I just froze. Before the interview, CJ, I could feel that something was wrong with me, but because of the unfamiliarity of the condition by then, I thought the symptoms were just temporary. But CJ, looking back, I realized that I should have done something different. Maybe some days before, I should have informed the JSC about my condition or even withdrew from the interview. But CJ, over the past 5 years, I've been focused on addressing and improving my health issue, and I am managing. I've never encountered a health issue during court proceedings that compromised my ability to function independently, fairly, and effectively. My current health status, CJ, poses no impediment to my ability to uphold the rule of law and the high standard expected of a judicial officer. CJ, I want to mention that prior to the 2021 interview and afterwards, I've also had an opportunity to adjudicate on matters where parties argued that there were dispute of facts. And I penned down judgments referring those matters for oral evidence if the factual issues were not admitted by the respondents in their answering affidavit. Additionally, like I've said, I've also written judgment that the researchers identified as reportable, so that itself demonstrates my improvements and my readiness to assume the permanent position. Thank you.
Well,
Sir.
as I understand it, when you came here before, you had actually written a judgment and applied the plus Evans rule.
That's what.
Am I right?
Yes, that's
and
what.
you had you've done so correctly.
Yes, that's why a lot of judges were angry at me to say, you have written judgment on this principle. What happened? And I told them that my brain was not working with me, unfortunately.
Don't beat yourself up because of that. Like that's just life. Well, I hear your explanation. It's appreciated.
Thank you.
I would just advise you to add exercise and a good diet to these therapeutic measures you speak of. I can relate. I've suffered from brain fog myself. You have participated in the aspirant judges training program.
Yes.
Did you find that useful?
Yes, it helped
How
me a
so?
lot. Judgment writing. I attending those programs. Actually, I attended two. They helped me to improve my judgment writing.
So it's a worthy project you reckon? Is it a worthwhile project then that we should fight to keep going?
Yes, CJ.
All right. Acting Judge President Leto, you have questions for this candidate?
Thank you, Chief Justice. Advocate Mukhali, you said you were appointed as an SC when last year?
February 2024.
2024. Don't you want to be an SC for some time so that you can get more juniors and share the experience that you have? I think you've been in the profession since 2002, about 23 years.
Yes. AJP, I don't need to be a senior counsel to train juniors. I don't need to be a senior judge, a senior counsel to train mentees. I'm doing it right now, and I will continue doing it even after being appointed, because even in Pretoria, there are a number of judges who are still doing mentorship program. So I believe that I've done my part as a practitioner, and now I am ready to be elevated to a position of a judge.
Can you please explain to this commission about this complaint that was laid in July 2024? Or was this matter reported to the JSC or not? Because much as you say a complaint was brought to the attention of the JP and the DJP, I cannot recall this matter. Was it reported to the JSC or
No.
only to the leadership?
No, only to the leadership.
And how was it finalized?
Nothing. She never, I responded, and there was no counter reply till today.
You responded to the JP?
Yes, I responded to the
now
JP.
DCJ. Okay. And the longest period that you acted in Gauteng was for how many weeks?
2020.
I mean in succession.
2020, the whole year.
Of 2020, the whole year?
Yes.
In which court were you? The criminal court?
Yeah, in no, first term, second and half of third term, I was in criminal, and fourth term, I was civil court.
Thank you, CJ. No further questions.
Premier?
Thanks so much, CJ. Advocate Mkhali Makinta. I can see you come from Rustenburg.
Yes.
So you have no interest at all in assisting the community of Rustenburg, because I can see you are not involved in any community work of any sort.
It's not correct.
It's here in your report that you have not participated in any community work or any community formation.
Oh, I'm highly active in doing community work. I'm presently supporting and giving legal advice to young children under Krasha Mashele, Pan-African adolescent children. And one of the nests is in the Northwest.
Advocate Mohale, would you please try to speak louder and bring the mic close to you?
Yes, Premier, I was saying I'm highly active in community enrichment. I provide legal advice, support, and mentorship to young children. Pan-African Adolescent Girls Movement, supported by Krasha Mashele, and they have various nests in South Africa. Actually, it's catering 10 different countries, but here in South Africa, we have nests in Eastern Cape, in Gauteng, KwaZulu-Natal, in Northwest.
Unless activists for in the form, page 11.
Which form?
It says, please furnish particulars of community and other organization of which you are or you have been a member in the past 10 years.
Maybe it was an oversight of, but my going down my questionnaire, I explain the community service that I'm doing.
And you think you are ready to occupy a position in the bench, and if you are, which area you think you'll add value to the bench?
Premier, like in Gauteng, I dealt with variety of matters. My strength is towards the criminal law. I developed jurisprudence in 2 areas in the criminal law, and I remember the AJP somewhere in August. I approached him and I requested him to, because I was allocated civil trials for 4 weeks. By the second week, we were getting few matters because of the introduction of mediation proceedings. So I requested the AJP to give me more work because I did not feel comfortable doing 1 or 2 matters a day. And he allocated an agent, he allocated agent court for me to adjudicate him. I started that Friday. I was invited on case line around 11, 12 during the day. I managed to read all the files. There were 12 in number. I prepared the directive. By 4 o'clock, I started my court. So that itself shows that my dedication to the bench, and that is not that only. At some stage, I think it's 2024, I also approached the AJP for more work, and he allocated a complex, voluminous civil trial, special civil trial for me, and the allocation was made on Monday. The parties were ready, 10 witnesses, doctors and experts were already there. It was a medical negligence matter. Tuesday, I started with the matter, and I had to draft new directives relating to time management because we had already lost a Monday. So we had to start court earlier and adjourn late. I managed to take evidence of all the witnesses and finalize the matter on time and deliver the judgment within 3 months. By the way, all my judgments were delivered within three months. And my field, my strength is not only where the matters are opposed. We all know that with Gauteng and our unopposed court roll, we are allocated 50 to 60 matter a day. I just don't rubber stamp the order just because the application is unopposed. I like the fact that GCB did not even look at my 4 judgments that I've submitted. They went into Safli to draw some of my judgments which were delivered from the unopposed court roll, and they analyze those judgments as well structured, well reasoned. So I believe that I've shown that my dedication to the bench, I've shown that I can work under pressure, I've shown that I can handle workload, and I'm ready. I'm ready to take a permanent position. I will be more comfortable in criminal court because that's my specialty, but any other matter that can be allocated to me, I won't have any difficulty to deal with.
We are sitting with an objection from one Pesisi Otto, who's objecting to our candidature on the basis of lack of knowledge.
Percy Sokoto was never my client, Premier. He was the deceased brother. I was involved in the matter. I was a counsel. He was not my client. And he's not telling the truth that I've never filed papers for leave to appeal because immediately after the sentencing, I stood up. I think that is why he is saying I was all over. I was always on my feet because yes, I argued for my clients. I argued for my clients for leave to appeal to be granted, and even their bail to be extended. I really argued, and I think that's why he's complaining. But I've responded to the objection and also attached the court order indicating that the accused are out on bail.
Thanks so much, CJ.
President.
Thank you very much, CJ. Good afternoon, Advocate Mohale Makinta.
Good afternoon, President.
How are you?
I'm doing fine, and how are you?
I'm fine. I don't want to mislead the commission, so you need to confirm whether this is factually correct or not. You have had occasion to appear at the Supreme Court of Appeal where I was part of the panel?
Correct?
Yes. I don't remember the case nor the outcome. That's not important, but I thought I should just mention that I thought that you were very well prepared on that occasion.
Thank you very
much. Is that a fair assessment of your performance?
That's a fair assessment.
Thank you. Thank
yes.
you, CJ.
Thank you very much.
Thank you, President. Minister?
Thank you very much, CJ. Good afternoon, Ms. Advocate Mohale Mankita.
Good afternoon, Minister.
On the questionnaire, question 10, what would you regard as your most significant contribution to the law and the pursuit of justice in South Africa? I'm interested in part C, where you reflect the work that the Department of Justice and United Nations have done in the Global Action Plan in trafficking in persons. But what I couldn't find there is what is your contribution in that area?
What I'm saying is that the primary objective of this this committee is awareness. My problem is that I was seized with the matter. A 12-year-old was raped, actually was trafficked from Mamelodi to Sunnyside. She was used as a sex slave for almost 4 months. In Mamelodi, posters of missing persons were all over. The families of of this young girl, they were commuting from Mamelodi to Pretoria to work, but no one could see or came aware that the child was here in Sunnyside. And the child was not in the house. She was not locked in the house. She was outside in the street, at the parks, used as a sex slave. So my question is, or my problem is, when looking at the objective of this national policy framework, where is awareness? So that's one of the reasons why I joined this movement, because I realized that how can I improve? Because our kids, my family kids, my friends' kids can be victims of human trafficking. So how can I assist? How can I make sure that people knows how a child is trafficked and how to identify a trafficked child? So that's one of the reasons I joined the movement. And in the
Which movement?
The
I'm lost, actually.
Pan-African.
Because the question I'm asking is that you are asked about your contribution into justice. You made reference to the Department of Justice in collaboration with UN and their work on global action. And what I was asking, what is your role in the global action against trafficking in persons national policy? Were you a drafter of the policy? That's what I'm trying to understand. How do you link to this?
No, I'm linking it. I was not part of the policymakers. I'm linking it to say that their objective is awareness. But what we see, there's no awareness. I was asking myself, if the policymakers are saying we are doing this awareness, where is it? That's why I joined the mentorship program, so that I can do those awareness. And asking myself questions that if these policymakers are within the government structures, I believe that the government, if I don't know if I'm mistaken, they are controlling our national TVs, the broadcast stations. Why awareness is not being done by television, educational programs, soapies, and so forth?
I don't have much time. I'm just asking a specific question. Okay, maybe just explain this thing that you joined. What is it that you joined?
I can't hear.
What you say you have joined. You say you have joined the team. Which team is that one?
No, I've joined the movement, Pan-African Adolescent Girls Movement.
Okay.
For awareness sake.
Oh.
Yes.
So that adolescents Pan-African movement, where is it situated?
It's supported by Gracia Marshall. It's here in Gauteng. It's operating in 10 different countries.
But the issue is, how does it link to the department and UN?
Actually, if the minister start from the beginning of the questionnaire, I talked about the state versus Obono, how I applied the provision of section 214, 215, using the records in the courts, because the matter was supposed to start de novo. So I did not go that route. I developed the law, because in most cases, when the presiding officer is no more or is incapacitated to deal with the matter, the case supposed to start de novo in terms of section 215, but I did things differently. I followed the principle of State versus Gombe and apply section 214, looking at the interest of the child, the best interest of justice, the right of the accused to have his matter be finalized speedily, and took the records as evidence, and the matter was finalized within two weeks.
Yeah, I think the problem here is the writing, how you framed the issue. That's why it's so confusing. And I'll go to the issue because this links again then confirms what GCP says. Because GCP raises the issue of how you've been able to, if you look at the feedback of the law bodies as well on your application, they've picked up quite a number of concerning issues around paying attention to detail, being able to specifically explain something properly, but also be able to deal with the issue. For instance, as well, how you record issues. I mean, for example, the form, you've recorded your date of birth wrongly in the form. And those are some of the issues, typos, grammars that are being picked up. Would you like to reflect on that?
Yes, with regard to the date of birth, I acknowledge and I responded, apologizing for the mistake done. But GCB, I did not see any comment where the GCB is saying I cannot articulate my reasoning and so forth. What I've noticed is that they were saying in some of my judgment there are some minor typos.
Next one, CJ. Under GCP comments, if you look at 6.3, they are saying that she's not been involved either in appearing or in her capacity as an instructing attorney in any reported judgment. CJ asked about whether you have any reported judgments. But again, the last point there, 6.6, talks about while her judgments are competently drafted and a reference to authorities shows a general knowledge of leading cases, her judgments do not show depth or any particular degree of insights. Would you comment on those two issues?
The first one, I did not get the second one clearly, but with regard to the first one, yes, it is correct to say there is no reported judgment where I was instructed or where I appeared. Because like I said from the beginning, the only work that my practice had for so many years is from legal aid board. The state never instructed me in high profile matters for me to be able to report the matter. But as a judge, as an acting judge, I have 3 reported matters. The researchers identified 3 of my judgments to be marked reportable. So the second part, may you please repeat the second part?
Okay, the second part they are talking about, you do not show depth of any particular degree of insight. It's 6.6 on the GCP's comments.
Maybe we have different, my 6.6 is talking about Sunset Ridge Estate Home Affairs Association. It's not, I don't have.
General Counsel of the Bar.
Yes.
It talks about, where it talks, 6 talks about the candidate's knowledge of the law, including constitutional law.
Are you looking at the right candidate, Minister? Huh? Are you sure you're looking at the correct candidate?
I am.
Just double check.
I must check.
Okay, it's GCB. So.
As I was going through the document itself. My apologies about that, CJ. I wanted to reference on the issue of the errors that are reflected. Let me check. I'm trying to find the paragraph on GCP. Okay. Maybe let me give
paragraph
another person a
9.3.
space.
Yeah, you can
CJ, I'll
come
come
back
back to
later.
it.
Yeah.
I'll come back to it.
9.3.
Found it.
Yes.
Okay.
9.1 actually, and 9.3.
Carry on, Minister.
Yes. 9.3.
My apologies about that. Check on 9.1 and 9. Actually, that 9, section 9, that's the comments where they are making issues around your typos, your grammatic errors in terms of your judgments. And that's why I made reference corresponding with the actual application form, that the consistency between your errors in your judgment, what they observe, in what is coming out of your judgments, is also reflected in terms of your questionnaire, how you completed your questionnaire. And I asked for your comments on that.
9.2 reads, however, the candidate's judgment from 2022 onwards shows an improvement and they are more clear, properly structured, and generally well written. In certain cases, the judgment will be improved with a more detailed analysis of the legal principle. There are occasional typographical and grammatical errors in the candidate's judgment. I cannot argue with 9.3, and what I can say, Minister, is that now I am privileged. Last week, the High Court Pretoria has allocated the intern researcher who will be assisting me during my stint. So this kind of mistakes, I believe that with the assistance of the intern researcher, they will be addressed.
Professor?
Thank you very much, CJ. Dumela Memokgale.
Dumela, Professor.
You know, it really pains me that in 2025, we are still talking about opportunities not being given to black females. And an impression is created that generally in South Africa, white male and female lawyers are generally good, with the exception of a very few league of black lawyers who continuously get briefs in South Africa. And the rest of the population is let out of that particular pool. And when you come here, then you are expected to have appeared in reportable judgments as a legal practitioner. For me, it is deeply worrying, and it means that something must certainly be done. Something must give. It cannot be that we are talking about the same thing year in, year out, that black females are not provided the opportunities that they ought to be provided. Your story it's painful that you have to be sustained with the tariffs of legal aid. That is unsustainable. It is just a blessing that you were able to get to where you are today, but I think something must be done. At some point, something must be done. All of us, we have a duty, because people know that this is wrong, and something must be done. On a substantive issue, there is an issue with respect to Section 60 of the Criminal Procedure Act, where community members appear not to understand the import of this provision. And once you have been arrested, community members who have already sentenced you and convicted you, they don't want to hear anything about bail. What do you think can be done to conscientize the citizens and the population at large on the values underpinning bail, so that they can really be entrenched in communities to understand the purpose for which bail is granted or is being denied.
Commissioner, each and every accused has a right to be released on bail. And when the accused appear in court, there are schedules. The court consider under which schedule does this offense falls in, and the accused needs to prove to the court that there are exceptional circumstances that they exist for him or her to be released on bail. And yes, I agree that the public most of the time they're not happy when that right is exercised. So what I can say is that maybe we should balance the accused rights and the interest of the community. Not to say that the courts must allow the community to bully or to tell them what to do, but just for Ubuntu principle, I think the courts must also try to put themselves in their shoes. Maybe if there is an uproar with a certain crime committed, I for Ubuntu purposes, I believe that it is not it's not the must for the court to immediately grant the bail. Maybe the court must allow the community maybe to anger to go down a little bit, and maybe the prosecutor also, because they are from the complainant side. The prosecutor also may maybe explain the purpose of the bail to the public. Even the magistrate or even the judge, yes, they must explain the purpose of the bail to the angry mob.
But a lot has to be done to make people aware of the rules underpinning bail. Thank you very much, CJ.
Before that, Prof.
Yes, you may.
I may. Oh, yes. Before that, when you are talking about the briefing patterns, the skill briefing patterns, I would like to share with the Commission what happened to me in January. The legal sector code, it was, the matter was in court. We know that there is a legal battle going on between the code and some practitioners. So an attorney was instructed by one of the law bodies, LSSA, to draft their papers. And that attorney approached me to say that this is a complex matter. I'll need your assistance in this matter. And the LSSA actually said I must outsource the senior counsel to assist me in this regard. I submitted my CV and it was taken to the LSSA. And then after 2 weeks, the attorney was informed to source additional 2 CVs for the same matter. And 2 CVs were sourced, and I was not successful because the brief was given a black advocate who was admitted, who had 4 years experience as an advocate, and that pained me a lot, and there was no explanation given, and I was just like, it is what it is. What can I do? Thank you very much.
Commissioner Ngukai, sorry, is there follow-up?
No, it's not a
Okay,
follow-up.
Commissioner Pillay, then you.
Thank you, Chief Justice. Like the GCB, I was a bit concerned about some of your judgments. There were certain of your judgments, and I think the one that comes to mind is the Lidwaba judgment, where you gave a leave to, you granted an application for leave to appeal.
Lidwaba?
Lidwaba, yeah. Lidwaba versus Kunanani, I think.
No. Where is the matter? Where is it quoted?
It's not in your application, but it's one of the judgments that you've written that I found on Safli. Was it not you, Lidwaba versus Kunanani?
I can't remember. When was that? I can't remember.
All right, and the Msiza versus the state, was that your judgment?
Caesar.
Yes. A criminal appeal.
Let me check let me try to check my list of judgments. Where's my list of, I can't, when was it?
It was 2024.
So the Dwaba is 1 October 2025.
It's the same. Unless there's another Mohale Makinta somewhere. You acted in the Limpopo High Court?
Yes, in Limpopo
Yes.
High Court, yes.
So the one I'm referring to, the Msiza judgment is from Limpopo, and so is the Lidwaba judgment. You don't recall it?
I'm sorry, I can't recall.
Are they cited in her application?
I'm not sure,
no,
CJ,
they are
it's just, it's what's reported on Safli. I'm assuming it's the candidate because
I
it's
asked
Mohale.
because I've forgotten hundreds of the judgments I've written
Yes,
over
no, I
time.
understand.
So
This one was written in September 2024.
Yes, it was.
And I think Lidwaba is in 2025. This month, October 2025, Commissioner Mukaitu tells me.
October 2025?
Yes.
We are not yet in October 2025. Today is the 14th of October.
The judgment is dated the 1st of October 2025.
that's very recent. You should remember it if it's yours, advocate.
Let me just give you the general concern I have, because I really would like to hear your response to it. The one is that in the Lidwaba leave to appeal judgment, you granted leave to appeal without providing any reasoning for why it is that you believe another court will come to a different conclusion. And so that lack of reasoning I see reflected also in the Msiza judgment, because in that appeal, you set aside the conviction and sentence in relation to 2 counts. But if one reads your judgment, you only provide reasoning as to why you're setting aside the sentence, but not the conviction. I don't know if you recall this. This is an appellant who was 17 years old and some odd months when he committed the alleged rape.
It was an appeal matter.
Yes. And then you found that because he was dealt with as an adult, but then you go into principles of sentencing as to why that should be taken into account in respect of sentencing. But the order that you grant is an order setting aside conviction and sentence. It's a September 2024 judgment.
I can't argue with you because I can't remember.
I accept that. Thank you. Thank you, Chief Justice.
Commissioner Mugwethu?
Thank you, Chief Justice. Advocate Mohale Makinta, I just want to come back to this topic that was raised by the Minister about attention to detail. The GCP report cites a number of cases that are in your form in which they say you have incorrectly referenced the judgments. So you can start with paragraph 7.2, Ericsson, South Africa, Pty Ltd versus Johannesburg Metro and others. And then immediately thereafter they say, cited by the candidate in her application as Ericsson South Africa Proprietary and City of Johannesburg Metropolitan Municipality, as if those were parties on the same side. The same thing runs through to the next judgment, Van Groningen at paragraph 7.9 versus Road Accident Fund. Then again cited by the candidate as Van Groningen, Sue Marie, and Raf. Then the third one, paragraph 7.14, Janssen van Vuren versus the member of the Executive Council for Health Province. Again cited by the candidate. It goes on and on and on. And then 7.18, 7.19, 7.22. So this problem about your lack of attention to detail seems to have also crept in this round of the applications. Do you have any defense or comment?
Thank you very much, Commissioner. I'm going to start with the first one, Erickson. The judgment was delivered in 2021.
How does that help us? Because you are filling the form now in 2025. You have to correctly reference the judgment.
I did not, this is an appeal. I was overturned on this appeal. I did not reference it. I submitted only 4 judgments. I did not, and the 4 judgments, I included them in my questionnaire. I never wrote this judgment in my application.
But 7.2 says cited by the candidate in her application.
No, I did. By then, 2020, 2021, during my interview, not for this interview.
So, okay, what's the explanation then for citing it wrongly in 2021?
I can't remember 2021.
Yes, all right, that's
I can't
fine.
remember.
All right, okay, that's fine. Let me leave this line of questioning. You don't remember what happened, and you've also explained the medical issues around that. Let me just ask you on the area that you probably are comfortable with, which is criminal law. Is that correct?
That's correct, Commissioner.
That judgment of S versus Mlambo, what principle was applied by the court to convict all of the accused? Because as I understand from the facts, they did not all participate in the murder of the alleged rapist.
On common purpose.
Yes, that's what I assumed. And most recently, common purpose has come up in the Supreme Court of Appeal, in the Gupta judgment, where it's been reappraised. What are the principles, just from your knowledge and application? I'm not going to hold you to the textbook, but I want to get a functional knowledge of a topic that's hot, common purpose.
Yes, what I know is that when the state alleged common purpose, it has to prove that they were common intention, the meeting of the minds, they associated together, they planned together to commit an offense. Even if the person is not there when offense took place, but the meeting of the minds prior the commission of the offense must be there, or even during must be there.
And then intent, is it direct intent or?
Even indirect intent, it's also forming part of common purpose.
Yes. Thank you, Chief Justice.
Are there any further questions? Thank you, Advocate. You're excused. How are you? Is your mic on? Please switch on your mic. Thank you.
I'm well, thank you. How are you?
That's better. All right. Uh, may we start?
Yes.
Okay. You hold 3 degrees at BA with English and history as your majors, then did LLB, LLM, both passed cum laude. The BA and LLB you did at UCT?
Correct.
The LLM locally at Wits?
Yes.
Okay. You have a long checkered work history, but I'll focus on the more relevant aspects for today. Your legal career starts in 2000 when you clerked at the Constitutional Court.
That's correct.
That seems to have been quite a busy period for you because I see that you were simultaneously working as an editorial assistant for Juta.
That was a part-time job.
Of course,
Yeah.
it would have had to be. And you were also working for yourself as a pub quiz master. What is that?
Yes, I have an interest in general knowledge and trivia.
Oh.
And it was one of those kind of things where they ask you obscure facts from the past or the present.
All right. So when you left the Constitutional Court, you went to do your articles at Bowman's.
Correct.
And you worked there for a brief spell. Decided to go to the bar, did your pupillage. That was in 2005. But then you did not join the bar, you went to the LRC.
The Legal Resources Center at the time, and it still does, actually allow advocates who are members of the bar to be employees of the LRC. And it's had that program, I think, ever since it started, when the previous Chief Justice Jaskelson was in that position. And so I was certainly a member of the bar. But the one point that I was very clear on was that I would do that full time. There are a number of people who have come from the bar and worked part-time at the Legal Resources Center who are advocates. But for me, it was important that I should do it full time.
All right. So you were at the Legal Resources Center until 2008?
Yes.
And then decided to go and practice in your own account?
That's
in
right.
September 2008. And that's what you are still doing to date?
Yes.
Okay. Let's see. You have acted as a judge, both in the Labour Court and in the 2 seats of the Gauteng Division of the High Court since 2016.
Yes, the first stint was a pro bono stint through SASLaw, of which I was a member at the time, and that offered an opportunity to do a 1-week stint in the Labour Court.
And you've acted intermittently since for shortish stints, the longest being 10 weeks in Johannesburg in 2023.
Yes, I was lucky enough to do a full term in the first
Oh, that
term.
was a full term?
Yes, Chief Justice.
All right. So you've acted for a total period of 28 weeks?
Yes, I will also be doing 3 weeks this coming term.
The 4th term?
In the 4th term.
Where? In Johannesburg?
In Johannesburg, yes.
All right. And you've sat in both the civil and criminal courts?
I haven't sat in the criminal trial courts. I've sat in criminal appeals.
All right.
But on the other courts, I believe that I've sat in all of the courts. There may be, I think the one particular court that I haven't sat in is the new insolvency court.
Have you been involved in a criminal trial, even as counsel?
Yes, I have. Particularly early on in my career, there were a number of criminal matters that I was involved in. That, yeah, I have some experience there.
All right. And you have written a total of 33 judgments, 6 of which have been reported during this acting stints.
Chief Justice,
Is that
the AJP asked for information recently, and I had a chance to look at that. In fact, there are 55 written judgments. It's just that a
55.
number of them weren't on SAFLI, and yes, there are 6 reported judgments
All
amongst
right,
the
so
55.
still 6 reported. Okay. You have also served as a small claims court commissioner since 2011.
Yes, that is, it's been one of the very most fulfilling parts
Yeah.
of my career.
You listed a few reserved judgments in your application form with a promise that they'd be delivered within 3 months from the dates on which they were reserved. Have they been delivered?
No, there are 3 which haven't been delivered, but they are within the 6-month period. I am obviously very concerned to ensure that they will be delivered for that period, and I regret that they weren't delivered within the 3-month period.
All right. You've done a lot of things, but I'm not going to go there. It's late in the afternoon. Hopefully, the other commissioners will touch upon these other achievements of yours. AJP?
Thank you, Chief Justice. Good afternoon.
Good
Advocate
afternoon,
Moultrie.
AJP.
I'm looking at the spreadsheet here. You have not sat in a full court of appeal.
Not in a 3-judge appeal, no.
Yeah. And also, you've never had what we call special civil trials, civil trials for long duration.
That is correct.
Now, you are aware of the complaint that has been made by Mr. Beamish. I just want to understand how you were operating or how the bar is operating. I come from a background of being an attorney, so some of the things that are happening at the bar. Now, when you send these complaints to the JSC, there was an agreement that those complaints should be served on the applicants, right?
The reviews that are prepared.
Yes.
Yes.
And now, after the interviews, and you also published this thing on the, what do you call it?
I understand that the General Counsel of the Bar published them on the website.
Yeah, on their website.
At the time, the General Counsel of the Bar was using the Johannesburg Society of Advocates website to publish them. But it was the Johannesburg Society wasn't publishing them, if I can say.
Now, these reviews, are they still there? Are they still published?
I believe they are still published on the GCB's website, yes.
My concern is some of the reviews that were made are reviews that were made against people who are now appointed as judges. And I need to disclose to this commission that especially those whose reviews have been published, they feel that that was not the correct way to do. Some of them could not be appointed earlier because of those publications. Now, looking at the publications, are you still of the view that they should remain on the website even if a person has been appointed as a judge? Because one of the complaints is that the sexual harassment was there. And when somebody opens that website, that is going to show.
AJP, I should say personally that I have never been supportive of the publication of those reviews. it's well known at the bar that I have always raised this as a concern. It seems to me that the purpose of the reviews is to, as far as can be done, assist this commission in its work. I personally don't believe that it's the correct thing to do, especially in the circumstances that you are referring to. But it's not my decision.
But in your time as a chairperson, did you raise this with the GCB?
Yes.
Was it oral or was it a formal issue that you raised with them?
Orally.
Yeah. The other concern that I want to raise is that some of those judges indicated that because of those publications, they would feel very uncomfortable to sit with you in a full court or a full bench. I know that I'm alive to the fact that it is the decision of this commission to appoint, not the decision of the judges, whether you are appointed or not. But that having been conveyed, how are you going to handle such a situation when you are to sit with one of those judges, if they raise it?
AJP, I would fully respect the views of a judge who is in that position, raising it as being a concern. In fact, as I've indicated to you, I think I would agree with them. I hope that they would understand that the publication of the reviews is not a matter that was my decision. It's not a matter over which I had control, and I say in retrospect, and it's well known at the bar, if I might perhaps use a Trumpianism, that I have been concerned about this from the moment that I took on that job in 2021. This is a conversation that needs to happen, and it must be taken seriously. I'm certain that the General Counsel of the Bar would be amenable to a discussion with the JSC over the question. And if there's anything that I could do to help, I would do it. Haven't been involved in this for some time, but I take it seriously. As far as their views of me are concerned, I would only say that I hold absolutely no personal view about the judges. The process by which those comments are prepared, I've explained, and is not a personal view of mine. It's an attempt, as far as can be done reasonably and with care, to provide information to the JSC. I would understand why they're unhappy about the publication. I would hope they don't hold it personally against me.
So you are saying those publications, they are as they are. There are no further comments that these charges went to the JSC, they were recommended and they've been appointed. So if a junior or a pupil clicks on that website, he or she is just going to see this negative review on the GCB website.
The individual reviews are on the website. What does happen is that if the candidate were to apply again to the JSC, the reviewers who are asked to prepare those reviews are asked to look again at what was said and then to look very carefully at what was found. And so, for example, in relation to at least one of those judges, the next review that was submitted to the GCB indicates that the matter was resolved to the JSC's satisfaction. So, yes, I think it's true that the individual review from a particular year without that information is available on the internet. but the very next review relating to the candidate indicates that the issue was resolved to the satisfaction of the JSC.
Well, I agree with you that this is a matter that needs to be dealt with seriously, because I know of two judges who are not seeing eye to eye, and the leadership of the court, I think they worked together for about 10 years. They never sat together at all. I don't think it will be in the interest of the judiciary that such events should occur.
AJP, that is very unfortunate, and I would do absolutely everything that I could to make amends as best I could with the judges concerned, and it is not my habit to make enemies or hold grudges. And if appointed, I really hope to work closely and collegially with all the members of the bench.
Yeah, should you be appointed, I think this is something that the leadership needs to deal with seriously, because you're there to serve and not to make friends.
Absolutely.
So hopefully the leadership of the time will be able to resolve this matter amicably, understanding that it's not personal, but it's just how the organization was operating. Thank you, Chief Justice.
I wish to thank you, AJP, for that.
You seem to suggest that the JSC must expend time and effort persuading the GCP to remove these publications from its website. Why should the JSC have to bear that responsibility?
I apologize for that, giving that impression, CJ. I didn't indicate that. My understanding is that
Well, you said perhaps the JSC and the GCP should have a conversation and you do everything in your power to ensure that things go, as I understood, you'll correct me if I'm wrong, as I understood it, then you'll try to assist to have these colleagues' complaints addressed to their satisfaction. So how else am I to understand that statement? You want us to go and talk to the GCP and persuade them to?
CJ, no, I will absolutely commit to doing anything that I can. My comment is made specifically in the context of the correspondence that I have attached as Annexure B, pursuant to which the JSC has formally given its agreement to that publication. And to that extent, it seems to me that there has been a formal engagement already some years ago between the JSC and the GCB on this question. But if there is...
Oh, in that context, okay. Thank you. Premier.
Thanks so much, Jay. Good afternoon, Advocate Moultrie.
Good afternoon, Premier.
There is what I see as a damning objection from one investigative journalist, Tony, about your candidature.
We have an objections committee that deals with objections that come in against candidates. And they dealt with that one and they made the determination that we should not ask this candidate about the merits of that complaint. There was a suggestion that we can perhaps ask him to explain, just articulate it for me, Advocate Ngaito.
Thank you, Chief Justice. It's correct. We've dismissed the objection on its merits insofar as it relates to Advocate Moultrie. What we have said is fair is to ask him to explain the general procedure that is followed by the GCB in making those determinations. Hence, we said nothing when the acting judge president was doing exactly that. Thank you, Chief Justice.
No, Chief Justice, I'll align myself with what you've just said. Thanks.
Sorry, Chief Justice, through you. Chief Justice,
yes,
if I may just make one point. I think I also just to indicate that I've looked at the comments, and you are recommended by almost all the people who wrote to the JSE about your performance and that you can make a contribution to the judiciary.
Thank
I
you.
do not just want to talk about other things. I also want to mention this positive aspect. Thank you, Chief Justice.
Professor?
Thank you, Chief Justice. Good afternoon, Advocate Moultrie.
Professor.
I just want to get a sense from you. We live in a country where competency and excellence is color bound. In other words, when you look at universities, white professors and both female and male are great by virtue of looking at them, even though some of them do not even cut the deal.
Excuse me, you do not?
Do not even rise to the occasion.
Right.
Then the same is true in practice. You look at some of the successful law firms are mainly white owned. Some of the most successful advocates are white, particularly male, and now recently white female. And we see a skewed division of labor, briefing, and instructions across the board. And at the end, it creates a perception that generally white, male, or even female lawyers are excellent in South Africa. And black lawyers, both male and certainly females, are poor. I'm not sure about your experience, and I'm not really asking you about what you have done in the past. I'm now trying to get to where we can actually go as a country. In your view, currently, not what happened in the past, and what happened in the past is crucial, it's important, and we ought not to mince our words on it. But nonetheless, looking forward, based on your experiences, and I'm looking at the number of cases where you appeared as a lead counsel and number of cases where you appeared as a junior, and that is being granted opportunities.
Excuse me,
I'm saying that is being granted opportunities to excel and being able to take opportunities and being as great as you are. What do you think should be done by all of us to level the playing fields, to ensure that we provide opportunities equitably and allow people to fail because of their own mediocrity, not because of the system?
Thank you, Professor. I agree with the premise that very commonly excellence is associated with race, even today. That happens all the time. I should say that it's changing fast, and it can change faster. I was privileged to start my law career at a time when black lawyers of my generation were coming through. I have been lawyers with some of the best lawyers in the country who are black and women. But the reason why they are still exceptions, and unfortunately exceptions, is quite simply ignorance and racism. The answer to the problem is that we've got to address that. There are fundamental structural inequalities in our society that are holding people back. And we end up with a skewed environment wherever there is power. And our obligation as a country is to address that legacy seriously, meaningfully, to the benefit of people who are suffering the effects of that. at a very practical level, there could be many things to do. And from the perspective of legal education, which you're involved in, and from the perspective of professional education, which I'm involved in, we must work hard on those matters to ensure that those structural inequalities are addressed. Is that specific enough? I'm concerned that I may not have an answer, because I suspect that there are not silver bullet answers to this question.
No, I hear you, Advocate Moultrie. Thank you very much for your answer. Thank you, CJ.
Commissioner Muhima?
Thank you, CJ. Good afternoon, Mr. Moultrie.
Good afternoon, Commissioner.
Just one question on my side. One of the criteria that the JSC was inducted on is the independence of the judiciary, and I think you will agree with me that judicial independence is a secret weapon.
Excuse me, I missed that.
I'm saying that you'll agree with me that judicial independence is a secret weapon to promote good governance. Absolutely. Now, I would appreciate if you can allay my fears that your candidature will not be compromised on this fundamental issue of the independence of your independence as a judge, given the discussion that has taken place earlier on. Thank you.
Commissioner, as I understand it, you're referring to the discussion about the General Counsel of the Bar's comments on candidates.
Yes. Look, the thematic areas around judicial independence, amongst them will include the need to stay away and refrain away from membership of any society. It could be secret or it could be otherwise. I suspect you'll understand that we come from the background of the influence of the Broederbond type of influence in all aspects of life. So when there is a reason to suggest that this could find expression in how we take decisions, it becomes a concern. Hence, I'm proposing that you allay my fears in relation to the fact that on this independence, which is critical criteria in terms of evaluating our candidate, there is no cause for concern.
Commissioner, I believe I can allay your fears in the sense that I absolutely reject the thought that a judge could be beholden to any interest other than the Constitution and the law. That is a deep, abiding commitment that I have, and as a practitioner, I have sought, obviously, to fight the cases of my clients within those constraints. As a judge, my obligation is to the law and the Constitution and justice and access to justice. And if there was something that I could refer you to specifically that could prove that, I would. But other than to say, I believe that my entire life has been committed to that principle. My entire professional life.
Thank you. Thank you, CJ.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Advocate Moultrie.
You were very gracious in your responses to AJP Ledwaba around judges in the Gauteng division who may take issue with some of the reviews, and you graciously took responsibility for that. I think we have to be very careful here, though, because if you look at the body of work of the JSC over many years, you will see that there's been heavy reliance placed on the GCB's reviews. Perhaps could I ask you, Advocate Moultrie, just to explain, and I know you've done it in Annexure A, but just for the benefit of the public, what process is followed in compiling those reviews?
Thank you, Commissioner. The General Council of the Bar is a federal organization, if I can call it broadly that, of which the provincial bars and other bars are members. The Johannesburg Society of Advocates is one of those bars. It is the General Council of the Bar that produces these reviews, which, as you say, it appears that the JSC has considered useful, and in fact, the correspondence that I refer to indicates that. The GCB, because it doesn't have direct members, asks the constituent bars to please do the work of preparing the reviews. In this year, I was asked to be the chair. We have a standing committee to do that because the work at the Johannesburg Bar, I think, as you know, that is done in this regard is very extensive. Often we had, at the time I was there, I think in that year, over 35 reviews were produced. The then chairperson of the bar...
Just before you continue, perhaps you can give us a sense of how those reviews are compiled and the kind of work that goes into compiling the reviews.
The reviewers are required, first of all, to gather as much information that is publicly available about the candidates, but primarily through their judgments. That is a key part of it. In the old days, that used to be a bit difficult before we had SAFLI, but these days it's made it a little easier. The review teams are to operate in teams. They are not self-selected. They are, in fact, when I was in charge, I was quite careful to ensure that they weren't self-selected. I should say this in relation to the very first year that I took charge of this. I was aware that a number of candidates had previously applied. And because I knew that there had been teams that had produced those reviews before, and due to the time pressure that we were under, I asked the same teams to work again on their reviews. And one of the very important features, and perhaps in thinking about allaying Commissioner Moimang's concerns, I did notice that the review that was produced in the year that I took over said the same things as the reviews from previous years, at least in relation to one of the candidates. And on that basis, I'd like to say conclusively that I was not involved in a campaign against the people. But I apologize for that slight digression. Once the reviews are produced in draft form, my process was to sit as a committee, very carefully ensure that the review teams were able to justify the content of their reviews on the basis of the information that had been gathered. Because in addition to gathering judgments and the like, the review teams are asked, and in fact the entire membership is asked, of their experience of the candidates. In relation to matters that may not have come before this commission in a disciplinary inquiry, things like judicial temperament, matters of particularly cases where advocates who've appeared before judges might feel that they run the risk of victimization should they make a formal complaint. I felt very, very concerned that there was a risk that might produce a situation where a campaign could be undertaken against the candidates. And so, for example, the moment we heard in that year that there was a shortlist, I wrote to the people who had volunteered for to be reviewers. They were entirely volunteers. They didn't know which reviews they would be writing. They didn't, and I wrote to them immediately and I said, you will be asked to be part of a team. The reviews must not be written by one person. They must at least have 2 people, if not 3. And you must be prepared to justify to the rest of the committee on the basis of evidence what you've written. We in that particular year, we had difficulties. It was an immediately post-COVID year. And I should say that I had to have that meeting virtually in the sense of emails only. But the process was followed. We then submitted the comments to the GCB. In both of the cases that we're referring to, I informed the chairperson of the GCB that the comments were sensitive and in one case very serious. The GCB then took the decision to submit the comments to the JSC. I should add that in relation to one of the comments, I particularly insisted that the review should indicate that it was the view of the GCB on whose behalf we were writing, that the JSC should put the allegation to the candidate in advance of the interview.
And you as chairperson of the standing committee, what was your role in relation to those reviews?
First of all, making sure that they were written, making sure they were written on time, interrogating whether they met acceptable standards of, if I can put it, of evidence, although of course we're not talking about particular standards of proof or anything like that, and making sure that they were justifiable for their purpose. I was personally responsible for then sending them to the chairperson of the GCB's committee, who was responsible for submitting them, and then that person did that.
And to what extent do those reviews then reflect your personal views?
Commissioner, no, not at all. My particular view on this was that as the chairperson of the committee, it was critically important that nothing of substance should be changed in the review. My role was to be protective of candidates, which is a matter that I was concerned with and continue to be concerned with. But absolutely not at all. Not a single instance in which I changed the substance of any review. I sometimes made sure that the review was properly framed so that its seriousness could be conveyed.
Thank you, Advocate Moshi.
Thank you, Commissioner.
Thank you, CJ. Good afternoon, Advocate. Earlier you alluded to the fact that you have some judgments that are outstanding, and you apologized for them not having been delivered within 6 months.
Yes.
My understanding is that they are meant to be delivered timeously, which is 3 months. And I just want to understand the reason for these delays. Given, especially in the Gauteng division, we had a sitting judge who applied to another court last week, who explained that she could easily rack up to 20 judgments in 3 weeks. So I think it is important to understand candidates' ability to speedily deal with their outstanding judgments.
Thank you, Commissioner. I completely and absolutely agree that it is a commitment and responsibility of judges to deliver their judgments speedily. In 28 weeks as an acting judge, I've written 55 written judgments, 6 of which have been reported. Also given 42 extempore judgments on substance. I'm not talking about rulings or decisions that a matter is not urgent or something like that. I have given 42 extemporary judgments in addition to the 55. During the period since I sat on the 3 cases that are now beyond 3 months, I have sat in 2 additional weeks of urgent court, and I have sat in, I think, 1 additional week of opposed motions. These particular cases, of the 3 that we're referring to, I consider that 2 of them are complex, and in fact, I'm concerned that the law is at the moment unclear in relation to critical elements that have to be decided in those matters. I feel the need to do the research on those aspects, and I wish to give the judgments as soon as possible. I should add that it's particularly difficult and without any way undermining the importance of the principle of speedy justice, it's difficult for practitioners who act on a sort of an ad hoc basis rather than on a sort of a term-by-term basis. And this is commonly the case with advocates because we don't have anyone to run our practices while we're away. And it is difficult, and I regret it, and I apologize.
Thank you. Thank you, CJ.
Thank you very much, CJ. Good afternoon, Advocate Moultrie. I'm pronouncing it correctly.
Minister, yes.
Thank you. I think the first area I want to talk about is one of those areas that I think is quite important as part of access to justice. The work that is done at the small claims court. As a commissioner, having been done that work, I know the DM has been reporting and asking us to improve that work environment. Is work in progress. But sitting here, what are the issues that you think we should be able to pay attention to? But mostly as well in terms of your understanding. Do you think that majority of South Africans are utilizing those courts and they have knowledge of what they can be able to help them with?
Thank you, Minister. I've sat in the Hillbrow Small Claims Court since, I think, 2011. Our court, I say our court, is well staffed by very committed lawyers, advocates, and attorneys. What that means, in fact, is that I only get to sit in that as a small claims commissioner about once every 2 months. And I miss it when I'm not there. And the reason why I miss it is because it's exactly that. That is a place where justice happens in a real way. I regularly deal with 6 opposed trials between 5 o'clock and 9 o'clock at night. We might think that that is an obvious sign that it must be unfair, but it's not, because what happens there is that those litigants fully understand that what's going on is an attempt by the commissioner to understand their problem, to bring the parties together in a very unique way. It's not formal mediation. It's not formal arbitration. It's in a very direct way. I have I've never been reviewed, and I find the parties leave the court, both of them, shaking hands and agreeing, even though one has lost. So I'm an enormous fan of the small claims court. I'm a little concerned about this, though. I participated in the Deputy Minister's consultation with the profession on the expansion of its jurisdiction recently, and some very thoughtful points were made. If the jurisdiction of the Small Claims Court is to be expanded, they have to be properly resourced. I'm not here talking about necessarily the salaries of the presiding officers, but we need to ensure that that efficient service that, at least in my court, we're able to give can be broadly rolled out. So also understanding that what really happens there, and the reason why it seems to me that it can work, is because of the possibility of something like inquisitorial justice as opposed to adversarial justice. But what that raises, of course, are deep concerns about the quality of the people who do it. Because once you get an inquisitorial commissioner who is not doing a good job and doesn't have the skills, you actually open the door potentially to serious injustice. But I strongly support them. I support the expansion of their jurisdiction, and I do believe it's part of the solution to access to justice, which is of critical concern.
Thank you. Just linking that work that you're doing at the Small Claims Court, but also looking at the LRC work, because I do note that there's quite a lot of work that you've done in terms of legal resource to assert and develop their rights in terms of communities. And quite a number of, I think, work that contributes towards access to justice. Again, looking at that work in terms of small claim court, but broadly, where you've been involved in particular within Gauteng communities, how do you see us expanding on the access to justice broadly, beyond just the small claims? The small claims, they come in, they go, but you've acted in the High Court as well. And I'm taking advantage of this vast experience that we have in various areas and working with communities in terms of this area of work that we could be able to expand, especially I'm looking in my area as a Minister of Justice.
Minister, thank you for the reference to my experience. I feel like I learn all the time, so I don't feel experienced. I should say this. I think that there are 4 elements to this problem of access to justice, at least. I think we need to think about legal education. I'm not talking about just lawyers. I'm talking about the legal education of our people to understand that the law has been given a central role in assisting with the vision of the Constitution. Secondly, we've got to think about infrastructure, where those courts are, where they should be placed, what their jurisdiction should be, whether they're magistrates' courts or small claims courts or superior courts and circuit courts. Very practical physical problems. We have to work on legal costs. Legal costs are exorbitant. I would suggest that one of the reasons why legal costs are exorbitant is because we have this difficulty with legal education. One of the reasons why I do advocacy training, for example, is I believe that well-trained advocates produce and present cases efficiently before courts at low cost with good results. Poorly trained advocates or untrained advocates and representatives delay cases and increase costs. We've got to work on that. And then we have to work on the overburdened system that we have. The interventions that have been made, for example, in our division by the leadership of our courts are extraordinary. Such care has been taken to ensure that the judges are not overburdened, that they get to sit in the opposed courts only a few times and the urgent courts only in a few times, so that they can write their judgments. We have the mediation protocol. We will see how that works. We have case management, difficult to work out. We need also to think about legislation. Does every case need to be decided by a High Court judge? Does every one of those unopposed motions need to be decided by a High Court judge? We, as lawyers in courts, there's nothing we can do about that. But we need to think about that. And then the last important thing is that the judges, the colleagues in this room who write their judgments, must help to make the law clear. Because if the law is not clear, people will just take a chance. And that excludes justice. We've got to have the right cases before the courts. And those are just four things that I think are part of the problem. I wouldn't think that I could have the solution.
Thank you very much. Thank you.
Commissioner Steinberg?
Thank you, Chief Justice. Just returning to Mr. Beamish's complaint. When I read the complaint, I contacted the chair of the GCB to get a wider mandate in order to respond. And the message I was asked to communicate was that any criticism about the process should not be laid at Advocate Moultrie's door. He was actually doing a service at the time for the GCB and implementing a process that he didn't make, but that the GCB had evolved over the years and may well need further evolving. That it would be unfair to blame him for any of it. In fact, he gave selflessly many, many hours and days in coordinating this. And yeah, I must add to what Commissioner Pillay said, that many of my colleagues here have said how much they rely on GCB's reviews. I think it's the only body that actually looks at the judgments and then gives a guide to us as to which judgments to look at, etc. So I think we must just be careful not to throw the baby out with the bathwater. Finally, Chief Justice, just to alert you, in Advocate Moultrie's response to the complaint, he included two letters. The one is dated 4th of March 2013. It's from William Makari SC, who's then the chairperson of Joburg Bar Council. And asks the Chief Justice, in his capacity as chairman of the JSC, for permission to publish the comment. And the response comes on the 27th of 5th, 2013, from Mr. Chulani to say, yes, you should. I think that was the last it was left at.
Thank you, Commissioner Steinberg. Are those follow-ups? Okay. Yours is a follow-up?
Yes.
Okay, go ahead.
Thank you very much, CJ. I think we need to be very careful. When we can accept that GCB is doing a wonderful job, but to say that it is the only body that carefully looks at the judgments, I think it's wrong. It is important to note that all the bodies are playing a meaningful role in this particular process. And we should not come out as the JSC as if we are overpraising one body and we are actually undermining the work that is done by the other bodies. And we have not yet done a SWOT analysis as to who does what when on an objective basis. It's okay to say the issue that we are dealing with, we can address it and say members of the body do rely from time to time from the work that is done by the GCB, and we can leave it there. And I think we have to be very careful because otherwise we are going to end up with a situation whereby we discourage other bodies from participating in our process, and we are going to be a little bit poorer should we get to that particular extent. I just want to caution us to be very careful in how we frame things. Thank you very much, CJ.
Thank you for that intervention, Prof. And of course, I agree with you. And I just want to remind us that our record is replete with references to all the comments that are made by the other law board. Issues are raised with candidates coming from all these law bodies all the time. That has been happening in these 2 weeks. So I don't think anyone who follows these proceedings would be fair in an assessment that says the GCB is given preference. We look at AFT, we look at LSA. Someone was referring, I think it was Commissioner Ngugaitobi, to LAA that I have not even heard of before, just this morning. So all the law bodies, their inputs are valued and we do read them, and issues they raised are raised with the candidates. Commissioner Mangeno?
May I just say that?
Oh, you had not finished?
No, I just want to say that I apologize if that's how it came across, because I certainly didn't mean that. Of course, we rely on everyone's, all the bodies' comments. Thank you.
Thank you, Commissioner. Commissioner Mangeno?
Apology accepted. Advocate Modri, good afternoon.
Good afternoon, Commissioner.
Yes, I want to canvass you a completely different aspect, and believe you me, it is important because it deals with knowledge production, legal knowledge production in our country, and which is a contested thing. I note that you are your CV. You say you were an editorial assistant to Judah and Company. And is that the Judah and Company that produces law reports?
Yes, I had a very particular job on what was called the Annual Survey of South African Law. It's now called, I think, the Yearbook of South African Law. Professor Morimachai, I think, writes a number of the topics there. My job was to research every academic article that had been written in the country in the year, and to identify new legislation for every chapter, and then write what we called the literature lists that would appear at the end of those paragraphs. And I should say I didn't do the work for any money.
Yes, thank you so much. There is an observation, it may be my observation, that black academics are struggling to have their articles published, and there is a sense in which it is suspected that there is gatekeeping. An impression is created that black academics are lazy, they are not writing, and when the contrary may be that they are being blocked. Any comment?
Unfortunately, I can't. I haven't been in academia for a very long time. I don't have a good sense of that. I do try and keep up with academic writing in the published articles, but if what you're saying is correct, then I obviously would have a skewed view.
Related to that, you may have noticed, more especially as a person who was part of the committee at the GCB, that comments when people apply for judicial positions. Great reliance is also placed on judgments published by law reports. Do you perhaps know why is it that it is difficult for judges to have their judgments reported on when they've marked them reportable? What is the selection criteria used to determine which judgments get to be reported and others not reported?
Yes, Commissioner, both, well, at least I'm aware of two very high-profile legal publishers, and they have both published the criteria by which they choose the judgments. They have, each law report set has, as I understand it, an editorial committee, and that their obligation is to apply those criteria to the choices of judgments that are published.
I've exhausted your quota of questions, Commissioner Mangen.
Thank you, Chief Justice. It was a kind reminder. I accept. Thank you so much.
Thank you, Chief Justice, Mr. Malto SC. I'm here. I must apologize that we are taking you from this corner to the other with our questions. Mine really relate to the second issue that was raised by the Minister. And in your response, you mentioned about 4, but ultimately I think it became 5 issues. But I did not hear you mentioning the issue of language in the courts, whether is it relevant or not. Obviously, for now, the vexed issue is why should it only be English when we've got so many other official languages. Some proponents of the use of other languages seemed to be interested in protecting the Afrikaans language. We know it is already developed, and relying only on English, it means now it's not going to be used. But they are well aware, these are the views that which are being expressed, that they know that other languages will take time to be developed to the extent that they can be utilized. Now, maybe you could assist, what views can you share with us that interventions that can be put in place to promote all these other languages? Perhaps even include the journals, publications which also encompass articles and views on these other languages. Thank you.
Thank you, JP. I should say that in the first place, there is no legal concept that cannot be expressed in any language. It may require care to do it, and it may require study. In my case, it would require years and years of study. But there is no reason why it can't be done. The question is should we do it? And if so, is there a cost involved? But if there is a will, and if there is a cost involved, I wouldn't necessarily know, then there is no reason why it shouldn't be done. Does it answer the question? I remember when the SCA produced its first judgment that was not in English or Afrikaans. It was a moment of change. It was good.
Conscious decision by the government to spend more resources in developing these other languages, will that not assist?
It may be so. I don't feel like I'm an expert in language development. I don't understand. I don't think I could say what it might involve.
Thank you.
Commissioner Hassan?
Thank you very much, Chief Justice. Advocate, I think you have answered this to some extent, but I just want to pose it in case there's 1 or 2 elements you might have forgotten or you didn't necessarily put in. But I was going to ask you about structural transformation. And what does that look like, not just in who sits on the bench, but who has access to it, who can afford to litigate, who gets the clerkships, who gets briefed, and of course, whose lived realities are reflected in our jurisprudence.
And whose, excuse me?
And whose lived realities of the poor and the working class in particular are reflected in our jurisprudence.
If one is to do justice through human beings, one will be dealing with prejudice. We're all prejudiced. Cannot help this. It is part of who we are. The question is, how do we raise those to the surface? I was looking at the Judicial Code of Conduct. In note 7.2, it says, we are to strive to be aware of and understand the many differences between persons and to remain informed about changing social attitudes and values. It also says the multicultural nature of South African society calls for special sensitivity for the perception and sensibilities of all affected by court proceedings. This is an obligation that we have, or that the judiciary has. And it's also an obligation that lawyers have. Commissioner, once again, I need to be careful that I've answered your question.
No, I think you have also in previous ones. And then just the last point is, how do we move transformation from a narrative, where I think we're sometimes a little bit guilty of just talking about it, but how do we actually institutionalize that transformation in this space?
Institutions have the ability to produce lasting written plans and policies, unlike human beings. Human beings will and must act in their own capacity at all times. But what institutions do is that they can write it down. They can make it applicable. So, for example, if you look at I was looking at the sexual harassment policy that was recently published. We were asked to sign our commitment to that as acting judges. It is critical that that policy must be monitored. It is critical that we must see and gather information so that we can see whether it is having a structural change or not. Otherwise, the risk is that it's just going to be lip service. I think that institutions are the answer. I think leadership is the answer.
Commissioner Ngweto?
Commissioner Pillay had the question on sexual harassment and wanted to follow up.
He's being so gracious. May I follow up, CJ, on the sexual harassment? Advocate Molche, I just have two follow-up questions in response to your answer to Commissioner Hassan. The first one is, you've said you've read the sexual harassment policy, and you will see that the sexual harassment policy does extend quite widely to conduct of a judicial officer, both, it seems, arguably, to conduct during your official role and capacity, but also to extrajudicial conduct. Do you think that's appropriate, and what kind of difficulties do you envisage in implementing that?
It seems that the biggest difficulty is to understand the interplay between the field of operation of the policy and the formal requirements of judicial conduct as articulated through concepts such as ultimately impeachment, but through the Judicial Code. And finding how to balance those processes. For example, if one, I looked at the ADR processes and the concept of an anonymous complaint. As I understand it, if an anonymous complaint is made, it's made and it's recorded, and that's part of the monitoring. It can only go further, of course, if it is not an anonymous complaint. And what I think that the policy does well is recognize where some of those lines lie. And those, I do consider that those will be some of the difficulties. And what you are referring to, in fact, around a judge's personal life and a judge's public life are going to be questions that arise in that context.
And since you considered the ADR process, the complaints process, do you see any difficulties with sexual harassment complaints being put through those processes?
Yeah, I could imagine that there will be people who have difficulties and who will challenge them, and our difficulty will be, as a society, how we deal with that. But that will be the difficulty. I can't say that in principle. I can tell you, I can give you a legal opinion on the question right
And then
now.
just to come back to the transformation question, you know that briefing patterns plays a big role in the transformation debate. Can you just tell us what steps you've taken to address briefing patterns and the empowerment of Black and women juniors in your practice?
I'm committed to it. At every opportunity I take that I'm given to help recommend a junior, I ensure that I recommend blacks and women. It is not always the case that I exclusively recommend blacks and women. And I have been grateful to have, I have persuaded a number of attorneys to take on young advocates who they haven't previously, and to wonderful effect. I do that. I should say that I find resistance amongst attorneys. On two occasions, on one occasion, I was thrown off a pro bono brief for asking them to brief a junior and to pay them.
Can I ask, why does that resistance happen? Can you venture a guess of why do attorneys resist briefing black advocates?
It's just prejudice. It's the fear of the unknown.
And how do we deal with that resistance?
Well, we argue back. Say, no, I disagree. Here is somebody who's perfect for this case. As you know, the Johannesburg bar is at the moment filled with brilliant young juniors, men and women, who don't have opportunities. We are teaching them. We are training them. We are making them better lawyers. The attorneys are not trusting us.
Thank you, Chief Justice.
Advocate Moultrie, good evening.
Good evening, Commissioner.
You know, I think that you've been incredibly modest in the sort of way you have sold yourself on a number of respects. And I want to just challenge you to be more expressive in relation to the work you've done on community empowerment, legal work, in relation to the work you've done at the bar to enhance transformation, in relation to the work you've done on training as you are currently my chairperson in the Human Rights Committee, which is one of the subcommittees of the Johannesburg Society of Advocates. I was just looking at the letter nominating you from Advocate Benny Makula, who mentions your role at the Commission of Inquiry into the leadership or the kingship of the Bakhatla Bakhafel, which went on for years. most of those are not known to a number of us. And we depend on you to educate us about the incredible role you've played up to this point. You know, I was interested, I was glad Commissioner Pillay came before me because I was going to probe you on transformation. Because transformation is one of those things that many of us claim commitment, but very few actually do something about it. In my own experience with you is that you've been one of the few that actually do something about it and go beyond exaltative statements. People coming, trying to get jobs as judges and claiming commitment to the bar, to the transformation of the bar, others wanting senior counsel status, claiming commitment. But you've been ahead of the curve. So can you just set out in brief, not in detail, not what you will do, but what you've done, which is probably the best measure of what you will do.
Thank you, Commissioner. As a lawyer, I believe in evidence and not empty rhetoric. So for me, to answer your question, I would want to do a couple of things. One is it transformative? Is it transformative to represent a community? If that is an area of law that you are interested in. I'm not wanting to argue against you. What I would like to say though is tell no lies, claim no easy victories. Nobody can understand the level of transformation from an individual case for an individual person. But I'll tell you this, the silicosis case. Fundamentally, I was one of the very first people involved in that case. I was also center because I felt that it was something that needed to be done. You will recall that we worked first on a test case. We did all the work on that. We had 1 million pages of discovery from the mining companies, which we read. We developed the expert opinions that formed the foundation of the later class action. Our case was settled, but we laid the basis. After that, I moved to the BioWatch case. One day, BioWatch representative came into my office and said, "We've lost this case. Our advocate says we can't appeal on costs only." We sat down, we thought about it, we strategized it, we developed it, we fought it, we lost it in the full bench. I refused leave to appeal at the SCA. We went to the Constitutional Court, where I was very grateful to be led by Gilbert Marcus. The Olivia Road case was an opportunity there. I need to pick up something about what Commissioner Mangena said. These are opportunities that may have been given to me because of the privilege that I have. So to claim them it's not about me. Whole teams of people did these things. Mazibuko, the first time I ever got to lead a junior in the Constitutional Court, was an opportunity to work on socio-economic rights. We worked on the evictions of the miners who became the miners who were living in those tents at Marikana, who were evicted out of the Krindal and Marikana hostels. All of this work we did because they were our clients. Of course, it's transformative. You choose to do it. But I can't claim it.
Thank you. I think I'm satisfied with that. Also with your qualifier that you're not claiming these victories. The last question, yeah. not an invitation for virtue extolling.
Apologies, Chief Justice.
Is around the, I just don't want to be vague on what the response is. And I don't want you to find out who are the two judges the JP is talking about, the AJP is talking about. But it is a practical scenario where in this country, judges have said we refuse to sit with Judge so-and-so for ethical reasons. In your case, you may feel that it is unfair that people say they don't want to sit with you in a full court or full bench. It's unfair. They should not say that. But they've said it because a lot of things that get said are unfair.
Sorry, I wasn't aware that any judge had said that.
No, that's what the AJP, I thought, was suggesting. Maybe let me clarify if that is correct or not before we go on a dangerous path.
Right.
Yes, I'm correct, yes. So, and you may feel it's unfair. They should not say that. But it's happened, unfair as it is. The real question about your own sort of judicial response is, what is your judicial response there? Somebody says, Mr. Moultrie, I'm terribly sorry. Judge Moultrie, I'm terribly sorry. I'm not going to sit with you. And they give you a reason, and you believe the reason to be wrong, unfounded, unfair. But it's really testing you about how you will react to that kind of a response.
Well, there are two responses. As a human being, one seeks peace and reconciliation, if you can. As a judge, that if I were to be appointed as a judge, that would be an extremely serious impingement on judicial authority. I can't see how that could happen.
But is there anything practical you think you can do? Are you going to go and say, let me go and see them in chambers and let me explain myself? And if they are hurt by my conduct, let me apologize. In other words, let me humble myself. Thereafter, let me go and see the head of the court and make sure there's reconciliation, because we need harmony in the division.
I will most certainly do that, and that's why I premised it from the first perspective of at a personal level. Absolutely, I have absolutely no animus whatsoever against this. I understand that this particular journalist has got the wrong end of the stick. And we have to work together. We're human beings. And I would want to make peace with them.
Thank you, Chief Justice.
President.
Thank you very much, CJ. Good evening, Mr. Moultrie.
Good evening.
How are you?
I'm well, thank you. And how are you?
I'm also fine, thank you. My question is, do you think that diversity on the bench is essential, especially in terms of judges coming from different backgrounds? If not, why not? If so, how do you think it enhances public confidence in the judiciary? Thank you.
I do think it's absolutely critical. I think that a judiciary that reflects, I mean, apart from the fact that the Constitution requires this commission to take it into account, but the Constitution sets the law, it seems to me, as one of the most important ways in which we are going to achieve the vision that it sets. If the Constitution if the judges don't have the confidence to say, someone like me, and not everyone is alike, but someone who I can identify with, maybe at a color level, at a race level, at a gender level, is there, then I can be confident that this is a country that will work for me. And we need everyone to think that, because if we don't empower our people, we can't succeed. So I hope that's the answer. It is critically important, and that's the reason.
Thank you, Mr. Moultrie. Thank you, CJ.
Commissioner Matolo-Dlebo.
Thank you, CJ, and good evening, Advocate Moulton.
Good evening, Commissioner.
You know, we have been speaking about transformation a lot, and I understand from Advocate Mugai, you are very modest. You are not blowing your own trumpet. You know, one of the things that worries me every time is that we interview people for judges' positions, and everybody will tell us that this is what they do, brief junior, and whatever. But one of my duties is to, as a stakeholder engagement of the legal sector coach, we actually go to bar councils and try and find out from the young advocates, female advocates, how do they see, how do the seniors share the work, or do they actually give them briefs, or do they, there's this thing called deviling or whatever. And the information that you're getting is not what I'm getting here. I'm not saying it's you, but I'm just thinking there's something that needs to be done. And how do you think maybe we can get that information, right information, to say there is transformation going on?
Commissioner, we shouldn't, in my view, start with the intention of showing that there is transformation going on. We should start with the intention of finding out whether there is transformation going on. And I do think that speaking to the junior people is a good idea, because they know and they experience. However, for the very same reasons that advocates who find difficulties with judicial temperament, etc., might not want to talk, junior advocates might not want to talk. So I don't know what the mechanism would be, but I can imagine that there is one. And I know that you're an attorney, and we depend on you for work. I'm not placing the responsibility at your door. We need to do it together.
Maybe I'll have another chance to talk to you offline.
Commissioner Shabagumdawu.
Thank you, CJ. CJ, I'll just follow up on what Commissioner Matolo-Dlebo just said. Advocate, good evening.
Good evening.
It's not yet evening. I'm looking outside and I see the rays of the sun that's still setting.
CJ, 5 o'clock, it's 5:30 now. Advocate, there are attempts that have been made just to deal with the skewed briefing patterns and the transformation. There's a legal sector code which has been gazetted. Of course, it's being challenged. I just want to get your personal view. Do you think it will assist in this challenge that we are having?
I'm worried that it won't. I can't tell you the full reasons for that.
No, you don't have to tell me the full reason, because obviously it's before court now. I just wanted to get your view.
I hope it does.
Thank you.
Okay. Anyone else? All right, your torture is over.
Thank you, Chief
Before you
Justice.
go, I just want to thank you for applying for this position. Of course, I'm not promising that you'll be recommended for appointment, but I must say that it gives hope for the future of our judiciary when our senior lawyers with busy practices show a preparedness to join the bench. And one hopes that more Black and women senior lawyers will do so. Thank you. You're excused.
CJ, advocate.
Good afternoon, Chief Justice.
Did I pronounce your name correctly?
Indeed.
Oh, good. How are you?
I'm still fine, thank you. Yourself?
I'm fine. Uh, we won't be very long with you, I promise. You have an interesting career history. You started in the Department of Justice as a clerk, then joined the South African Police Service, and you were a police officer for 14 whole years. And
That's correct.
then decided to practice and join the sidebar. You were there for 7 years.
That's correct, Chief Justice.
And you changed career path again and decided to join the bar in 2006.
That's correct, Chief Justice.
And that's where you still are 20 years later.
Beg your pardon?
And you are still practicing as an advocate 20 years later.
Indeed, Chief Justice.
Okay. You have a national diploma in police administration that you obtained in 1987. Then a BLC. What's a BLC? Is that a degree?
Chief Justice, it's a bachelor degree that was at that stage presented by the University of Pretoria. If I remember correctly, it stands for Baccalaureus Legum Civilium.
And then you later did an LLB and an LLM with UNISA. Then a diploma in tax practice at Rand Afrikaans University and an MBA at Newport University.
That's correct, Chief Justice.
Right. What kind of a practice have you been running in this past 20 years?
Chief Justice, as an attorney...
Well, 27 years, including when you were an attorney.
As an attorney, I had a general practice. The largest part of my practice comprised labor law and criminal law, and I also did a lot of family law. Since joining the bar, I had primarily a commercial practice, commercial and personal injury practice, and in later years, I also did a lot of tax work. I sat as a chairperson of the Independent Regulatory Board of Auditors. That's where I did a lot of regulatory work, and I'm also a chairperson of the tax board and has been reappointed until 2029. I've just been reappointed to the Independent Regulatory Board of Auditors for a further term of 3 years until 2028.
Right. And you are also a mediator, and you're a commercial forensic practitioner and a few other things as well.
Yes, I am an accredited mediator. I did a mediation course by Mediation in Motion Mediators. I also did a mediation course in international commercial mediation at the International Law Institute in Washington, and I did another mediation course at the Civil Mediation Institute in London.
You have also taught law at a number of educational institutions, actually. A large variety of law courses at Tshwane University of Technology, Technikon Witwatersrand, University of Pretoria, Centurion. Did you teach at this Centurion Business Academy?
Chief Justice, no, I didn't teach there. I was part of the management of that institution. And if I say I didn't teach, I mean I didn't physically stand in front of classes. I was part of the management, and I was also part of the course development team. So I developed some of the courses.
Yeah. But then you actually taught law subjects at the other institutions, including the National Private Colleges of South Africa.
Yes, I taught there and I taught at the Tshwane. It was the old Pretoria Technikon that became the Tshwane University of Technology, and also at the University of Pretoria, and I'm currently involved also more on a advisory level and as well as on a curriculum development level at Stadio Higher Education.
And you also mentioned a mentor college. Is that an educational institution? Or you say you're a part-time lecturer and examiner in commercial law and business law?
Yes, Chief Justice, many years ago there was quite a number of colleges that presented legal training, not only legal training, but they presented matric type of training for less privileged people, and that is Success and Lyceum and Mentor and so forth, and I was involved there. The way that I got involved there is at that stage I was involved at the University of Pretoria, and these colleges fell under the auspices of the University of Pretoria, and at that stage the University of Pretoria used me to present those classes.
So teaching and mentoring have been a huge part of your life.
Indeed so, Chief Justice. While I was in the police, I was also the head of legal subjects at the Police College for Basic Training.
You have acted as a judge in Pretoria and in the Pretoria and Johannesburg High Courts since 2021.
That is correct, Chief Justice. I also acted in the Labour Court.
In the Labour Court as well. It's short stints, so I'm a very impatient person. I did not have the patience to tote them up to see how long it is that you actually acted. It's a long list. What is the total period?
40 weeks, Chief Justice.
40.
40, yes.
All right. And in total, including at the Labour Court?
Indeed, Chief Justice.
All right. And in which courts did you sit in the High Court?
I sat in the High Court in Pretoria and in the High Court in Johannesburg. I suspect that you want me to specifically say what type of matters did I deal with. I sat in the unopposed court. I sat in the opposed court. I sat in the civil trial court, special interlocutory court, default judgment court, special motion court, full court appeals, civil appeals, and full bench civil appeals. And I sat in the tax court.
All right. But not in the criminal court?
No, not in the criminal court.
Not even in criminal appeals?
Not even in criminal appeals.
So do you have any experience at all in criminal?
The longest trial that I ever did, Chief Justice, was a criminal matter. It ran for in excess of 2 years, and by the time it completed, we had 17 witnesses that presented their evidence.
As a legal representative?
Yes, I represented one of the accused. There were 3 accused. I represented accused 1, and a colleague of mine represented accused 2 and 3.
All right. You've written judgments?
I've written 47 judgments. 40. Let me just make sure. I think it was. I've written 49 judgments.
49. Any of them reported?
Not as far as I could establish, Chief Justice.
Do you have any published work outside the judgment, some which I assume would appear on Safely and other platforms?
Chief Justice, I published an article as part of my PhD thesis in the Law Journal of the University of Port Elizabeth, it's Obiter. I also published a chapter in a book on South African small business management, and I also published an article in a book on human rights for policing.
You mentioned a PhD. Are you studying for one? Or do you have one?
I'm waiting for the results,
Oh,
Chief Justice. I've handed it in a couple of weeks ago.
wow, that's wonderful. In which area of the law? What was your...
The title of my PhD is The Alternative Dispute Resolution of International Financial Disputes.
You have listed reserve judgments, although they still fall within the 6-month period. Have you delivered them?
They have been delivered, Chief Justice. There are currently 2 judgments outstanding, and those 2 judgments...
From when?
From yesterday and from Friday.
All right. You turned 63 in June. How long would you still have to serve as a judge if you are appointed?
Chief Justice, my understanding is I would have to serve to 75.
Yeah. How is your state of health?
I would argue that my state of health is very good.
You say that with conviction, so I believe you.
I do regular cycle races, Chief Justice, and I swim.
Ah, excellent. All right, AJP, over to you.
Okay, thank you, Chief Justice. Good afternoon or good evening, Advocate Oppenheimer. Yeah, the Chief Justice has covered most of the things, and we've all seen the positive recommendations from the GCB and other bodies. You mentioned that you were in a criminal trial which lasted for 2 years. When was this trial heard?
It was when I was practicing as an attorney. I can't remember the exact dates.
The year and the month?
I stopped practicing as an attorney in 2005, so it must have been shortly before 2005. And that was a criminal trial. I've been, as an attorney, I was involved in quite a number of very long duration arbitrations.
Okay. And the type of work that you did, according to the schedule, you were also in the agent court for about 4 weeks.
Let me just make sure that agent court for 4 weeks.
Do you agree?
Indeed.
And this is the first time that you are appearing before the JSC.
That is correct.
And during your acting stint, have you also done bail appeals?
No, I've done no bail appeals.
Not yet allocated to you. Automatic reviews, criminal petitions, have you dealt with them?
I've done some of those. I am currently busy with one.
The recommendations, it is also stated that you've got an independent mind, you conduct proceedings fairly efficiently and effectively. Do you confirm that?
I do confirm that.
In your acting stints, are there any challenges that you have noticed as you were acting in Pretoria and in Joburg? I mean, material challenges about how the courts operate?
JP, I haven't encountered any challenges in this from a infrastructure point of view.
Collegiality?
The challenges that I've experienced is that the docket is quite busy, and it takes a fair amount of work and a high level of commitment to get the job done. From a collegiality point of view, I've been pleasantly surprised at the level of collegiality and the level of assistance. I've never experienced any inhibition to assist or any unwillingness to assist. My experience is that it is it's not only a collegial environment, it is also a nurturing environment, which is very dear to my heart, and it is also it's a pleasant environment in which to operate.
And the leadership, did they show you an open door policy? Would you go to them anytime if you've got a challenge?
I've always experienced a cordial relationship with the leadership, and it's something that I treasure, to have a cordial relationship with the leadership. I've had numerous meetings with the former judge president, and I've had quite a number of meetings with the current acting judge president, which is you, and both the deputy judge presidents in both courts. And I've always experienced them accepting of ideas before the mediation protocol was formulated. I had quite a number of discussions with the the deputy judge president of Johannesburg, Mr. Justice Sutherland, and we discussed this at length. I had a couple of discussions with Judge Mlambo also, and we discussed this at length. And I had a couple of discussions with Judge Davis also. And I experienced them as very receptive. Before the whole issue or the whole possibility of mediation was, let me use the word, birthed, I had quite a number of discussions with Justice Sutherland about the problems that was being experienced at that stage in the Pretoria and Johannesburg court. I actually partook in a conference in Paarl where these aspects were discussed at length. I also partook in at least 2 colloquiums by the University of Northwest University, where these aspects were also discussed at length. So, to answer your question, I've always experienced cordial relationships with the leadership of both courts, and even the court of the leadership of the Labour Court. I had discussions with the judge president there and some of the other judges when I acted there.
Premier?
Thanks so much, Chief Justice. I'm covered. Thanks so much.
Commissioners, Professor?
Thank you very much, CJ. I'm not sure if it's good afternoon or good evening or both, but good evening nonetheless.
Let's just call it good day.
A good day, yes. I think that is the most safer one. I want to ask you a question which somehow has become a theme in these interviews. For instance, in the court that you are, I'm assuming that you are in Johannesburg now.
No, I'm acting in Pretoria.
You are in Pretoria.
Yes.
But at some point you were in Johannesburg.
I was in Johannesburg.
In Johannesburg, you might find that there is this insolvency court where you see that predominantly the practitioners are white. And when you go to Pretoria, there is a road accident fund, we call it a civil road, and you see that most of the practitioners are black. Now, that tells a particular story. And we know the history of the story. I'm in a quest to now try to come up with solutions as to what can be done. This reflects a story of exclusion in as far as briefing patterns are concerned. And by and large, the clients that go to attorneys to do the kind of work that are generally taken to court. I'm not really sure if you have thought about where we are as a country and what can be done to remedy this situation, because in my mind, this cannot be normal in a society like ours. Have you thought about it? Do you have any thoughts as to what can be done to have a more inclusive sort of process in as far as the provision of legal services is concerned?
Thank you, Commissioner. I think it's important that we need to start this discussion at the right point. Now, I would suggest that the right point is to look at what, excuse me, what the former Chief Justice, who is now late, Longa, wrote in an article when he wrote about transformative constitutionalism. And he refers in that article to an article that was written by Professor Karl Klare. And I think the important thing that Karl Klare says is he says that we need to understand that transformative constitutionalism is a project. It's not an occurrence, it's not an action, it's not a happening, it's a project. Now, Chief Justice Longa goes further and he says, all right, so what is this project about? And he mentions a couple of very interesting things. He talks about the legal, he talks about access to justice, he talks about the legal profession, and he talks about the legal culture, and he also talks about legal education. Now, the interesting thing that he states in that article, and it resonates very closely to me, and that is that transformation is something that everybody has to get involved in. Now, if I think about that, I think about what Roosevelt said. He formulated the law of three, which also resonates with me. And that law of three is do what you can with what you have where you are. So, for me, transformation is an all-in. Transformation is not something that happens, it's not an Excel spreadsheet, it's an all-in. So everybody has to do whatever they can do where they are. So you're referring to specific briefing patterns. Now, briefing patterns, according to my understanding, is to a large degree based on perceptions. Whether those perceptions are correct, whether they are valid, whether they are valuable is irrelevant. It's perceptions. So my understanding is what I have to do as an individual. I have to do my best, find new ways of thinking to change that perception. Now, in my experience, the question that I've asked myself is, where does this perception come from? Perception probably comes from experiences. The perception probably comes from incidents. And maybe the perception is just blatant preconceived ideas. That we have to change. How do we change that? How do I change that? I change that by trying to do as much as possible skills transfer. Because at the end of the day, transformation is we need to upskill. And if we can upskill people, then we can change the perception. How do we upskill people? We spend time, we spend effort, we expend energy to increase the skills of people. Now, let me just give you an example. What I do in my court, and even as a practitioner, I invite as many pupils as possible to come to my court. I invite students from universities to come to my court. I even invite scholars to come to my court. And after every single court session, I take them to my chambers and we do a debriefing. Now, why do I do that? Because it is during a debriefing session where a transfer of skills occurs. If you don't do a debriefing, transfer of skills is not going to happen. But that takes an effort. That's just one thing. The other thing is we have to challenge people. I've been in training and coaching for as long as I can remember. When you challenge a person, they will rise to the challenge. And I would submit that we need to challenge people. They will rise to the challenge. What else can we do? Yes, we've got to stick our necks out and vouch for people. But we vouch for people after we've trained them, we've coached them, we've mentored them, and we are sure that they can do the job. My experience is that a lot of transformation is all talk. And the moment that the job has to be done, then there's a problem. I've experienced a whole host of people that appear before me that they have not received a transfer of skills. And that becomes a problem because that creates an impression in the minds of an attorney. And that causes that attorney to decide, I'm not going to brief that person.
Perhaps maybe let me interject there. I mean, if you are taking it from a philosophical point of view, and we look at that concept of transformative constitutionalism, and we look at as I understand it, the Constitution as a tool for radical social change, that's precisely where the problem is. Where a lot of people are saying, yes, from an abstract or even intellectual point of view, that makes sense. That is something that should be done. But it's not much about the Constitution now. It's much about what is happening now. There are a lot of black attorneys, black advocates who are skilled already, who are not getting briefs. And I think you look at the Constitutional Court, for instance, you look at counsel that appear in that court, you look at the Akala. It's not like we don't have an alternative. Black people who can do the work. And we are not saying that white people should not get the work. That is not the discussion. What I'm saying is currently now, as we are sitting here, what can we do? Yes, there are perceptions, there are attitudes and all those kind of things. But what can be done currently? And perhaps, and I apologize for burdening you with this. It's just a broader question, not only for you, but nonetheless for the country at large. What can be done practically now to say those who have skills, can we give them the work while we are training those who do not have skills? And I think that is the essence of what I'm asking.
Commissioner, I think we need to acknowledge to each other that we don't have the answers. We are grappling with this. We're trying our best, and we're doing whatever we can do. Maybe if we expend a little bit more intellectual energy, we could find a solution. What I've just proposed to you is that I think that is where we should start. We should change the perceptions. How do we change the perceptions? We make sure that the people who we vouch for, and I'm prepared to vouch for people, they must be able to do the work. Because attorneys are going to believe us if we vouch for them. I think there's just another very important aspect. And at my bar, I'm the person who does the training and who does the pupillage and the structured program. And last year, I realized that we are doing the pupils a disservice because we assume that all of them want to go into practice. So at the end of last year at the advanced advocacy training, I approached some of our members that's not in active practice but does more regulatory work in the whole host of regulatory entities. And I invited that person to come and give a lecture. And after the lecture, at least 3 pupils came to me and said to me, this is what we want to do. We don't want to go to court. That's not where we feel comfortable. But this is where we can feel at home. Now, I think that's an important aspect because we're making assumptions. And we need to create opportunities for people that where they can go and where they can bloom. And I realized this after that lecture. I realized that, you've been assuming that everybody wants to become an advocate, get involved in litigation, and that's not necessarily correct. So go and create opportunities in other places where people can go. And maybe, if they are there, they can create opportunities for other people in other avenues. So what I think is we need to maybe think a little bit out of the box and not be limited to our profession. If we look at the legal market, portion of the profession that has shown the biggest growth is in-house counsel. In-house counsel grew by 40% over the last decade. In-house counsel extracted something like $100 billion from outside counsel because they brought the work inside. That's an opportunity that we need to go and prospect on. Maybe that could expose people to further opportunities.
Very much, Advocate Rabenheimer. Thank you, CJ.
Commissioner Pillay, is the follow-up? Yeah.
Thank you, Chief Justice. Good afternoon, Advocate Robbenheimer.
Good afternoon, Commissioner.
Did I hear you correctly that in answer to a question from Commissioner Marumo Achai, you said that racist perceptions come from, in your words, experiences and incidents?
I don't think I said it as a statement. I said it could come from there. So there's a possibility. I think there's a spectrum where it could come from. I'm not saying that is scientific research. I'm just speculating.
And as a basis for, on account of that, you say transformation is about upskilling people. It's about challenging people. It's about vouching for people after, in your words, we have trained them. After they, in your words, have received a transfer of skills. That's the answer you gave.
No, I don't think that's the answer that I gave. I said that is one of the aspects. I don't have all the answers. I'm saying that is one of the aspects. There could be a lot of other aspects that I haven't thought about, maybe nobody has written about it yet, but this is just one of the aspects. Transformation is a broad concept. It's a multifaceted concept.
Let me just understand one of those aspects, Advocate Robbenheimer. Are you then saying that what is required is that white people should train black people so that they can then get work from attorneys?
No.
Because
I'm not saying that the responsibility lies exclusively with white people. I'm just saying that we need to upskill people. Currently, it would seem to me as if the transformation initiative that is currently afoot does not put enough emphasis on the transfer of skills.
And you're saying the responsibility lies with white people and other people to train black people?
It lies with everybody or with anybody who has a skill that can be transferred.
Now, Advocate Robbenheimer, I'm going to give you a second.
Sorry, can I just finish?
Yeah, please do.
In respect of the question that was posed to me, it dealt specifically with insolvency practice in the Johannesburg High Court. And the set of facts that was placed before me was that that court is frequented primarily by white practitioners. So that was the basis for my answer.
Now, I would like you to reflect on this because I don't think I'm going to get far with you in this question and answer session. But can you see how this is deeply offensive to black people?
If you could assist me, maybe I can find enlightenment.
The notion that transformation can be furthered by training black people, by ensuring that there's a skills transfer from white people to black people. Do you see how deeply offensive that is?
I think we're just missing each other. I'm not saying that black people are not trained. I'm saying that for an attorney, a white attorney, let's ask the question, why is it that white attorneys don't want to brief black counsel in the insolvency court? There could be a lot of reasons. I've identified possibly one reason. The way that I propose that one reason could be addressed is by looking at the possibility of a transfer of skills. We don't have clinical information at our disposal. We're thinking of solutions. If we have clinical information at our disposal, maybe we'll get to other solutions.
You see, you don't touch at all on structural inequality. You don't touch at all on unwarranted perceptions and racist perceptions amongst attorneys.
I think I did, because I said there's perceptions, and those perceptions, there could be some of those perceptions that are unwarranted, that are invalid. Maybe I didn't use the words that you are using, but according to my understanding and my intention when I said this, it included a racist perception is an unwarranted perception. It's an invalid perception. But there could be lots of other invalid perceptions.
And do you think
so I did not limit my answer to a specific invalid perception. And racism is an invalid perception. It's an unwarranted perception.
Do you think you can overcome a racist perception by the proposals that you've made today around upskilling black people and transferring skills to black people, etc.?
Not only by doing that, but that could go a long way. there could be other aspects that one could implement.
Let's follow up. It's going to be very short. Now, the problem, Advocate Robbenheimer, with the discussion you had with Professor Marumoagai and Commissioner Pillay, is that you see the problem as being the problem of the blacks. You don't see the problem as being the problem of the whites. That is the fundamental problem which creates a racist stereotype. You think the problem lies with black people. That's why they must be trained.
No, sir.
But the people with power are white people. The people with money are white people. The people with the work are white people.
I think we misunderstood each other. My specific reference was to the specific people who has these perceptions. It's not the black people who has the perceptions, it's the white people who have the perceptions. They must change their perceptions. My discussion with Commissioner Pillay dealt only with one specific aspect.
I'm talking about that specific aspect. That specific aspect sees the problem as being the untrained blacks. The fact that we've got Professor Marumoagai, who has a doctorate, seems to escape you.
No, it doesn't escape me. Professor Marumoagai has a practice in insolvency law.
Then why is he not getting briefs from the white attorneys?
My understanding is that the professor is an attorney.
Well, why is he not getting briefs from the white clients?
Because of the other side of the coin, and that is the perceptions.
Just perception. 1948 was a perception.
No, it wasn't a perception. It created a perception.
It created a perception, or
it strengthened a perception.
Just a perception.
Well, it could be just a mindset also.
Just a mindset.
Well,
the Group Areas Act created a mindset.
I beg your
The Bantu
pardon?
Education Act created a mindset.
Commissioner Ngogaito, I moderate the tone. Have you finished?
Yes, I have.
JP Kalesi?
It's not a follow-up, Chief Justice, unless there's a follow-up to that. Good evening, Advocate Ruben Naiva.
Good evening, Commissioner.
The GCB at paragraph 14 says that the appointment of the candidate would send a message to the public that the judiciary values candidates with extensive legal expertise, ethical integrity, and a strong commitment to justice, professional development, and community service. I'm going to sketch a scenario to you. In the judiciary, we don't have housing allowance. We don't have other benefits like pensions in the true sense of the word. We do have a motor vehicle that is provided and medical aid. It's questionable whether there's a contribution from the state or not. And there has never been any maternity leave provision. The understanding has been that pre-democracy, the appointment of the judiciary then would have been white Afrikaner males who have practiced and now are retiring. And then their last service for years, they will then be on the judiciary. That's why there was no provision for the issues, for the items that I have mentioned. Now, if we were to, I know age is not a disqualification, I might just say that up front, but the appointment of a person in your position at this stage, although it recognizes what is referred to in paragraph 14.1. The downside of it would, or the other side of it would not be a perpetuation of what used to happen pre-democracy. I will allow you to respond. Thank you.
And before you do, just to add that a motor vehicle benefit that is heavily taxed, just that qualification.
Chief Justice, I don't think I heard that. A motor vehicle.
I was just adding to JP Tlalis's statement about the benefits to which judges are entitled. He mentioned a motor vehicle benefit, and I'm adding that that benefit is heavily taxed. You may go ahead.
Yes. Commissioner, yes. My approach would be that the terms and conditions of employment of judges should be re-looked at precisely because of the aspects that you've alluded to. And that is that it is based on an appointment system that is outdated. And that should most certainly be reconsidered.
Would you say only the conditions of service and not other factors of transformation, so that the judiciary should not more and more look like as it was decades ago, pre-democracy? Because if you say conditions of service, obviously the assumption at that stage when those appointments were made was on the understanding that that senior counsel has got a house. All the children are grown up.
Indeed.
They don't need anything but just to say thank you for having served the country. We'll give you a motor vehicle, we'll give you pension, and salary for life for the remainder of his, well, of course it was his life on earth. Now,
Commissioner, I would submit that there is a need for transformation, for transformation on a broad front of the judiciary. That would include race and gender, and with regards to the factors that you've just mentioned, most certainly age also. And if that is the case, then they should be looked at the whole issue of terms and conditions of service. Because the moment that you get younger people into the judiciary, their needs would differ dramatically from those of older people. So the short answer is yes, there's most certainly a need for that to be transformed, and I remind myself of Section 174 of the Constitution that specifically refers to that and makes it a constitutional imperative.
I see. And I must say that when we got in, some of us in 2003, we were scolded that we are too young, inexperienced. Maybe we should have had to wait until 62, 65, then to make ourselves available.
That is indeed the case, Commissioner.
Thank you, Chief Justice. Thank you, Advocate.
Commissioner Nkonyan.
Thank you, Chief Justice. Good afternoon, Advocate Rubenheimer.
Good afternoon, Commissioner.
I noticed from your presentation that you served South African police and not South African police services from 1982 to 1996. I'm saying so because South African police services didn't exist at that time. What existed was a brutal South African apartheid police that were notorious of their brutality. Now, you served for about 14 years, if my Bantu occupation is serving me well. Now, can you tell us what was your role during those years of police brutality?
Chairperson, the South African Police Service, according to my understanding, came into existence in 1990, I think it was 1994. So from 1994, the South African Police, it was the South African Police Service. Before that, it was the South African Police Force. So I did serve in the South African Police Service. Also, before that, I served in
Sorry, Council, don't have luxury of time. I'm asking you your role in the South African police before they were transformed to South African Police Services. I agree with you.
My role in the South African Police was, at the end of my career, was the head of legal subjects in the South African Police College. I was also on detached duty as a chairperson of disciplinary and administrative inquiries. Before that, I was an investigator and I was stationed at head office. And before that, I was stationed at Pretoria Central as an investigating officer.
So you enjoyed the brutality of South African police force, as you say?
No, I didn't enjoy that.
That is why I thought that you'd give us a full and frank disclosure. What was your role during that time? Because that's the essence of my question.
My role was as an investigating officer at Pretoria Central, where I investigated common crime. Then I was, sorry, I omitted to say that after being in the police college, I went back to head office where I worked at management services. I was involved in the drafting of the delegation document that was based on the new act. I was also involved in the drafting of a new policy on the use of force by the South African Police, and I was also involved in the drafting of a policy on street children.
Kota is exhausted, Chair. I will leave it at that.
It is your turn.
Thank you. The Commissioner and I have a similar mind, had a similar question, so it's perfect for a follow-up. Advocate, you've indicated that you served under the apartheid police. And so you've mentioned now that you were involved in some disciplinary cases, the use of force policy. You mentioned something about street children as well. Did you ever participate or witness or receive orders that was in relation to coercive interrogation, to detention, or any, let me say it in any sort of political policing?
No.
Did you ever appear before the TRC? Did you ever come forward with anything that may have necessitated need to speak before the TRC?
No.
Okay, let's go back to what you were saying to us around the use of force policy. What did that entail?
The use of force policy up to that stage was primarily based on the old Section 49 of the Criminal Procedure Act. When the new constitution came into operation, that had to change. So I was sent to Sweden on a course on international human rights and humanitarian law, and I visited their police college, and I visited some of their police. I visited the police commissioner in Malmö. Malmö is in the south of Sweden, and we had discussions on this specific aspect. And when I came back, I was tasked.
So just to be clear, which year was that?
That was in 1990. I think it was 1995, around about there.
So I just need to understand this, it's very important, CJ. From 1982, is that, yes, from 1982 to 1990, let's say from 1982 to 1990, what was your role in the police force?
I worked initially at a police station, Victoria Central, where I did investigations, and then I was transferred to police head office, where I did initially administrative work, and then I did further investigations, normal crime investigations. Then I went, and I was a chairperson for disciplinary inquiries. At that stage, the police had a dedicated division or department that did disciplinary inquiries and administrative boards. That was initially in the hands of commanders, but it was taken away from commanders because there was complaints about nepotism, so there was a dedicated unit created for that. I was part of that unit, and yes, and then in the early 1990s, I was transferred to the police college, where I lectured legal subjects and eventually became the head of legal subjects. I was involved in the drafting of the new curriculum that was implemented in 1994, 1995.
Oh, all right, Advocate, do you acknowledge the systemic abuses of the police force during the 1980s?
I do.
And did you have any moral or ethical concerns working for the police in this position, whether it was disciplinary inquiries chair or what you call as small crimes, etc.? Did you have any moral or ethical crises? And maybe it's important to put it into context, CJ. This was the most repressive time of our dark history. People were disappearing, there was detention without trial, we were on the brink of a potential civil war, and the police force was a critical tool of the apartheid government to oppress and to silence us. And so I would like to know whether the candidate had any moral concerns during the 1980s when this country was burning.
If you're referring to the disciplinary inquiries was in respect of police officers that contravened either police standing orders, national instructions, and had to be disciplined. So I didn't have a moral qualm with that, because there had to be discipline in the police. So
did you discipline any police?
I beg your pardon?
Did you discipline any police who were killed under that period? Who killed activists under that period?
No, that was not part of the disciplinary inquiry. That would be a criminal. Okay. That would be a criminal offence, and that would be dealt with by the criminal courts. My function was to.
All right, CJ, I just want one last question before I yield back to you. I just want to know if you had any moral crises serving the police force during the 1980s.
Please, just allow him to finish his answer. You asked him a question, let him answer it.
My job
Do
as
finish.
my job as a chairperson of a disciplinary inquiry was exactly that. Police officers who abused their position and contravened internal disciplinary regulations and rules. They were brought before me and I meted out disciplinary measures against them in terms of the applicable regulations. It went a little bit further than that, and it also included administrative boards. Administrative boards dealt with, for instance, abuse of police resources, police equipment. So that was my job. I didn't have a moral. I didn't have any moral problem with that. I was quite convinced that it is the right thing to do to ensure that there's discipline within an organization.
Commissioner Mangen?
Thank you, Chief Justice. Good evening, sir.
Good evening, Commissioner.
I would have loved to converse with you the issue that was raised by Commissioner Marumagai and followed by Commissioner Pillay and Commissioner Nkaitobi. But I just want to ask you one question in relation to that.
Yes.
Do you accept as a fact that white people are privileged and are still privileged 30 years into democracy?
I have no problem with that. I fully agree with that.
And do you also accept that there is a duty on those with power to ensure that this inequality gets to be addressed by making, if you are an advocate in the legal sector, you make sure that there is a transfer of skills. If you are an executive in a company, you make sure that wherever you are, you ensure that there is change.
Most certainly.
Thank you.
I can, in this regard, I can refer you to a couple of aspects. I can refer you to a speech that was given by the Deputy Headmaster of JP Boys High, where he specifically dealt with white privilege. And the message of that speech is, if you have white privilege, use it for good. Make something of it. I can also refer you to an article that appeared in the Harvard Business Review, where exactly the same is said. There's no denial of white privilege. The question is, what do you do with it? Do you hide behind it? Do you deny it? Or do you use it to elevate other people? Do you use it for good? Now, my approach to that is that is exactly what white privilege is for. It's not there to benefit other privileged people. It's there to benefit, and it puts the person who is the recipient of the white privilege in an unbelievably responsible position to use that for good.
Thank you. CJ, my second and last question. With regard to the issue of the taxation of judges, I note in your CV that you hold a qualification in tax and you offered some lessons in tax. Am I right?
That's correct, yes.
Yeah. In the law reports, there was a judge, F.E.T. Krause, who
I'm not familiar with
you are not familiar with him. You should check that. The story about him is that he suggested that judges should not be taxed. Having expressed a view on the need to look at the remuneration of judges, do you think that it is outlandish to suggest that judges be not subjected to taxation?
Judges are members of society, just like anybody else. So I can find no reason why judges should not be taxed.
President,
I'm fighting for judges here. CJ. But tell me, I'm interested in this thing because you see the concept of the independence of the judges, the independence of the judiciary. At the heart of that notion is that it doesn't mean that they are above the state. No, but they should be put in a situation where they will be able to dispense justice without fear, favor, or prejudice. And their financial stability, it's important. Now, is there anything untoward about giving consideration to that concept? Because if FET Krause, you may not be aware of that matter, was able to have that matter go into court, is it something that people who are tax practitioners and are doing tax planning of the country can't exempt judges?
Sorry,
Can't judges be exempted?
I'm not comfortable with the fact that judges should be exempted. Judges are citizens of the country like any other person. I think you touch on another very important aspect, and that is the independence of judges. I don't think the fact that judges pays tax could have any influence on their independence. It's like any other law that a judge has to comply with. I remind myself that that the code of conduct applicable to judicial officers specifically states that judges has to comply with the law. And if tax law requires judges to pay taxes, then they should pay taxes. A justification for judges not to pay taxes, I can't find such a justification.
Thank you, Chief Justice.
President,
Thank you very much, Chief Justice. Good evening, Mr. Rubenheimer. I'm over here.
Sorry, Commissioner.
Good evening.
Good evening.
How are you?
I'm still fine, thank you.
I'm also still fine, thank you. I'm looking at your questionnaire, page 11, paginated page 11. 6.3 says, which cases in which you have appeared would you regard as being the most significant and why? And you list 1, 2, 3, 4 cases, but I'm not sure the reason why you think they are significant is coming out. For example, the first case, you say Dawson versus Sydney on Val Community Property Association, and then you say socio-economic rights of land claims beneficiaries, that's all. And then Dreyer and another versus AXZS, and then you say disputes of fact and re vindicatio, that's all. Black Orchid Farming versus SARS, you only say taxation of farming expenditure. And then Sintumuli versus SARCC, all that you say there is dealing with probabilities.
Commissioner, if I can expand on this, the Dawson versus Sydney on Falk Communal Property Association is a matter that I've been involved with on a pro bono basis since 2018. That matter is still ongoing. So what happened there is that the Sydney on Falk community, they instituted a land claim, and the land claim was they were granted they were successful in this land claim. In terms of the Communal Property Association Act, they had to create a communal property association, which they did, and that is the Sydney on File Communal Property Association. There was then widespread corruption and mismanagement in that communal property association, and we brought an application for that communal property association to be placed under administration. The basis on which we brought that application was twofold. The first basis was due to maladministration, and the second basis was that it would be just and equitable to place this organization under administration. We lost in the High Court. We brought an application for leave to appeal. That was denied, and we then petitioned the Supreme Court of Appeal. And the basis on which we petitioned the Supreme Court of Appeal is that the judge in the Court of Quo applied the commercial or the economic criteria to the concept of just and equitable. And our argument was that this piece of legislation is socio-economic legislation, and it is not proper to apply economic criteria to socio-economic legislation. We presented that argument to the Supreme Court of Appeal, and the Supreme Court of Appeal granted us leave to appeal to the full bench of the Northern Cape High Court, and that appeal is still pending.
Yes, thank you very much for that explanation, but I don't think you are getting my point. My point is that you were asked to cite those cases and to explain why, or give a reason why you regard them as most significant. Now, a few minutes ago, you have given us a long explanation about what the case is all about, but all that you have said about why you think it's significant, in your questionnaire, you simply said socio-economic rights of land claims beneficiaries, and that's it. And I've read out your responses in relation to the other three cases as well. Would you concede that you have not explained why any of these cases is significant?
Commissioner, my understanding was that the question required a reason. I was not under the impression that it required an explanation. So that's why I dealt with this in such cursory fashion.
Yes, but I mean, let's take this example of black orchid farming versus SARS. All that you say there is taxation of farming expenditure. Is that a good enough reason? If your understanding was that all you had to do was to give a reason.
Well, Commissioner, my understanding was that the taxation of farming expenditure is not something that comes before the courts on a regular basis, and that's why I used only that sentence.
I see, thank you. My second and last question, Chief Justice. You mentioned that you participated as a legal representative in one lengthy criminal trial that lasted 2 years. Was it not significant? I see you have not listed it here. I'm just interested in maybe you don't have to get into a lot of detail. I suppose the fact that you have not included it here means that you did not regard it as significant. My question is, you said it lasted 2 years. when was this? And the second part of the question is, what charges did the accused persons face? And the third question, they are all related, these three questions, is that judgment reported?
Commissioner, it was a matter that was in the Specialized Commercial Crimes Court in Pretoria. So it was not in the High Court. The charges were charges of fraud. What happened in that case is the case went on for 2 years, and then the magistrate passed away. So the matter had to start afresh. And we then made representations to the National Director of Public Prosecutions, who then decided not to start afresh with the case.
Sorry, the third question, which year? That's the last question.
It was in 2002 and 2003.
Thank you, Mr. Robinama.
It was when I was still practicing as an attorney.
Thank you, Mr. Robinama. Thank you, CJ.
Commissioner Steinberg?
I'm covered, Chief Justice.
Okay. Minister?
Thank you very much, Chief Justice. Good afternoon. It's evening. They are all laughing at me. The Chief Justice was warning us not to say afternoon before, so now it's evening.
The sign was still out at the time.
No, thank you very much. I think the first one I want to start with, it's on the question 10, in terms of significance, in terms of law and pursuit of justice. You've mentioned three things there that I'm picking up. Oh, yeah. Changing training curriculum, advocating for alternative, maybe if you can go into detail, advocating for alternative dispute resolution.
Yes, thank you, Minister. I've been involved at the coalface level in respect of advocating for alternative dispute resolution. I did my first alternative dispute resolution course in, I think it was 2017 or 2018. That was an international arbitration course, and then I did a couple of mediation courses. And I started realizing that the current mode of dispute resolution that we are practicing in South Africa is not sufficient. And there are different ways of doing disputes. Now, having only litigation is more of a one-size-fits-all. And disputes are not that friendly to fit into a one-size-fits-all mode. So I started advocating fairly aggressively for the implementation of alternative dispute resolution. It started with an initiative that I activated to get mediation registered as a profession with SACWA. So the mediation organization that I belonged to at that stage started this process. We attended the information sessions at SACWA and we started drafting the documents. It was a process that took about 2 years, 2.5 years. And when we were ready to submit our documents, another organization that was an umbrella organization, that is an organization by the name of ADR Practitioners of Southern Africa, then came to us and said they want to register, but they want to register as an umbrella organization for the whole alternative dispute resolution industry. And we then agreed with them and we said to them, we'll hand over the whole process to you and you can then proceed with the process. Because at that stage, the executive of MIMM regarded it as more important to make mediation more popular than to hold it for itself. So that's the first aspect. The second aspect, I've been involved in quite a number of pilot projects in respect of mediation. There was a pilot project by the Department of Health. I was involved there. Those projects were all pro bono. And there's a project with the RAF. The Gauteng High Court mediation project started taking shape about a year and a half ago, and I was intimately involved in the initial meetings in that regard. I'm also involved in the creation of a mediation center at Stadio Higher Education, and I'm also involved in the compiling of a postgraduate diploma in alternative dispute resolution. I am an accredited mediator, and I've done quite a number of mediations. The other interesting thing is that I sit as a commissioner of the Small Claims Court, and in those hearings, I sit there as an adjudicative capacity, but I can make suggestions to parties to try and sort out their difficulties, which happens fairly frequently and with great positive results.
Okay, just to follow up on that, Advocate, I am battling to reconcile your proficiency, your expertise with mediation, alternative dispute rather than litigation, with what Commissioner Hassan has asked you. If you look at the TRC report, Volume 6, Section 3, if you go through that report, you'll recognize that 50% of the amnesty is at the period you were at SAP. And TRC was meant to be able to help us to heal the past, to acknowledge the weaknesses and the wrongdoing. Part of that report indicates that those who were in SAP and did not carried out tortures were not disciplined, or if they went through disciplinary process, it would be understood that they were taking information from political activists. And I'm flagging this, and I need your reflection on it, because I couldn't hear the reconciliatory and understanding of this environment. And within that, as a person who so specializes in alternative dispute mechanism, in outside litigation, to have understood the importance of TRC.
Minister, I was, as a chairperson of disciplinary inquiries, I did not have an inquisitorial role. So matters came before me that was investigated by investigating entities. They came before me on the basis of a complaint that was laid either by a member of the community or by a commander of one of these police officers, and the evidence were presented before me of any contravention of the police standing orders or the police national orders at that stage. And I responded to that. I heard the trial and I listened to the evidence, and based on the evidence I came to a conclusion, and I either found the person guilty or not guilty, and then there was a second phase, and that second phase was for the determination of an appropriate sanction. The sanctions that I could impose was prescribed in the regulations, and I was bound by those regulations. I couldn't go outside of those regulations.
Okay, I don't want to disrupt. Did you read the report as a former SAP member of the TRC?
By the time that the report came out, I was no longer in the SAP.
As a person who was in SAP, because the report did reflect about SAP as a former member, did you bother to read it to hear what was happening in the organization you belonged to?
I didn't read the entire report. I read portions of the report.
May I follow up? I think, Advocate Robenheimer, you've written on police and human rights.
I'm sorry, Commissioner, I'm struggling to hear you.
You've written on the police and human rights.
I have.
And I think underlying these questions, as I hear them, is asking you to reflect on the question of human rights and policing through the states of emergency in the 1980s, not your particular role to defend it, but the broader question of the conduct of the South African police and the questions of human rights during the 1980s in South Africa.
Thank you, Commissioner. My experience and the takeaway from my experience is that I have seen what an abuse of power does to an organization. I'm acutely aware of that. And that is something that, to a large degree, well, maybe I should put it more intensely, to an overwhelming degree, has created a specific approach and understanding of an abuse of power. I have an intense sensitivity to an abuse of power, and I have an intense aversion to an abuse of power. What happened in the 1970s and the 1980s is, from a human rights perspective, unacceptable. And it should never, ever happen again. And as a judge, and you can go and read my judgments, I've written 4 judgments dealing with the police. All those judgments specifically addresses that specific aspect.
I think perhaps the difficulty with your answers to our Commissioner Son and the Minister is you say that on the one hand, but on the other hand, you defend your role and say you were just working within the system. It's the just following orders defense.
No, Commissioner, Commissioner Steinberg, you are wrong.
can I finish? I'm asking you to reconcile your answers to the other commissioners and this broad and rather abstract view that you've taken on human rights.
No, Commissioner Steinberg, that is not correct. I did not follow orders. I can relate specific instances where I did not follow orders and it cost me. It cost me dearly. It cost me a promotion because I did not follow orders. I did not toe the line. I was the chairperson of a disciplinary inquiry where my commander laid charges against a black female sergeant. And I found her not guilty. That cost me a promotion.
Thanks, Chief Justice.
Apart from the fact that it cost me a promotion, I was subjected to unbelievable intimidation during that period. And I had to stand my ground and keep my independence as a presiding officer. And that was not on an individual level, that was on a systematic level.
All right. That brings us to the end of an interview I had promised would not be long. Little did I know. Thank you for making yourself available, Advocate Rubenheimer. You're excused.
Thank you, Chief Justice. Thank you, Commissioners.